Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. I didn't ask you to interrupt me. Oh, for Trump's sake.
All right, trying to fix some audio issues we've got going on here. Test 1 2. Test 1 2. Check 1 2. Okay. Test 1 2. Seems a little hot, but then it's quiet in my ears. What's with that? Test. That's a little better. All right.
Hello?
Judge, can you see me? Can you see me, Judge? I can't. Someone was on Zoom, but they're gone. Guys, welcome to the Court of Public Opinion. I'm the Recovery Addict. It's good to have you here this morning. Happy Friday. And a rare podcast Friday it is today as well. You know what else is also rare today? 80s Music Man won the internet. Congratulations, 80s Music Man OG. Yes. I don't know. I'm not sure who this was. There was a guy who was... That's not it. Why do we have that there? There was a guy who was like just staring down at us from this angle. I don't even know who this is. Some court somewhere. We'll figure out what it is. All right. Yes. Podcast on Friday. Are we doing another fence tree trial? If we can find one. We're waiting for another big trial to start so we can follow it. But, everything pushed this week, except for the one we followed early in the morning. Let's see. Why did it say I also want it? Ninnis, you have to change to live chat instead of top chat, and it will reorder them in the order they came in. And I show 80s was first, Kim R was second, Red Pen was third, Rianne K was fourth. Yes, I don't even see you on the list here. I might not have loaded the older messages before you had logged in. But good morning, welcome. Good to have you here. How was your morning? I can tell you how mine went. I know you guys don't want to know, but I'm going to tell you anyway. Remember that whole printer thing where I have to drive way down south to open up a building to let the Xerox guy in so they can repair something? And let's see, he came out once and did all the same things that I did and determined it was broken, which I had told him already. So when he came out, he ordered a new board for it. And so that arrived, and he came today to install the new board. Well, surprise, surprise, surprise. The new board was the wrong board. So he has to order another one and come out again. I'm telling you, this guy gets paid per call out. So it's just an hour of driving out of my day just to drive down and back and everything. And so it's not a big deal, but the printer's only worth $280 new. At what point do you just give us a new printer instead of, we've got 3 call-outs now, 2 people, 3 times. You can't make this stuff up. Anyway, how's everybody doing? Good morning. I'm doing just great. Just happy to be here, that's all. Yeah, it's all good. Yes, 80s Music Man won the internet. Congratulations. Everything IP related worldwide is your responsibility. Thank you very much. And congratulations. It was a genuine win. It wasn't a re-gifted win, which still counts, but it wasn't re-gifted. Very glad it's Friday. It is very much a Friday. Let's see. Did they say why Brendan was pushed? No, but it got pushed way out. Way out. Oh, Ninnis was the first chatter after the stream started. Ah, yes. That's what happens when we have to reload Lumia Stream, which is the tool that handles all the commands in chat. It always recognizes the first person to talk after it's reloaded. That's why, Ninnis. It makes sense now. Printers are the bane of IT workers' existence. They are the worst. This one's a great printer when it works. Which, funny, it still actually works. It's just the screen that doesn't. My office was closed today, so I had the day off. That's awesome. I wish I had your office. That sounds beautiful. Let's see. What good news happened? Oh, we rented out the Airbnb again. Our last renter left 2 days ago, and the new one just is going to be coming right now, so yay. This is the court we were in.
Officer Burnham is going to be out of the country until...
We're gonna go back to that one. So we have a new tenant. Yes. Let's do birthdays, which I think somebody put up already and I missed. There we are. Greeners, thank you very much for this. We'll talk about geese and other things later. Let's see what the birthdays appear as follows. We've got Nate Myers, who may or may not have been born in 1987. I'm not going to say that was like the year, but it's possible, which would make you young, Nate. Nathaniel Neturai. Is it Naturai? Did I say that right? Oompy and Todd. Todd's on Saturday, I think. Let's see. So Nate Myers, Nathaniel, Naturai, Oompy, and Todd. Please tell me I said that right. All right. Let's do the happy birthday thing. Wow, is the camera blurry or what? You guys can barely read over my shoulder. That's a little bit better. Now you can read over my shoulder. All right. Let's, yes, you pronounced Todd correctly. Thank you. That was the one I was concerned about. Sorry. All right, everyone, wherever you are. If it's legal and you're able, stand up, take a breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. That'll do. Nate Myers is younger than my first pound puppy. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Nate Myers, Nathaniel, Naturai, Opie, and Todd. Happy birthday to you. All right, Nate Myers, Nathaniel, Naturai, Opie, and Todd. Happy birthday. I realize there are many wonderful days, but today is your special day. There are a million places you could have been, and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can turn that joy right back to you. Make your day just a little more special, or begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Whew. And it's David Attenbaugh's 100th birthday. That name's really familiar. Was he like the voice on a movie? Like a nature movie? Is that the guy I'm thinking of? Is he like the National Geographic voice? Nature shows, okay. Everyone's heard his voice. Everybody. 100 years old today. Where is it not legal to sing happy birthday? In a library during testing sessions. I'm just saying. Speaking of testing sessions, we're going to talk about that a little bit. It's sort of a podcast topic, but we'll do it anyway. Camera in the corner is blurry. I will fix it. All better. Thank you, Drama Mama. Are free birthday pancakes really offered at all those places? Allie, you mean you hadn't gone? You've been here long enough to have a birthday here. You didn't go to any of those places and ask to claim your free birthday pancakes? If you look closely, you'll notice... the male of the species making IT noises to attract the female. This rarely works, but the male doesn't give up. Yes, great birthdays there. Oh, drum solo, big solo before the finish. Here we go. Help me out here. Male does not give up. He redoubles his efforts. He buys more cables and tries again. Anyone affected by the Canvas outage? That's what I wanted to talk about. Oh my goodness. 255 million people, mostly students, age kindergarten through college, which is pretty much most of the years, impacted by this Canvas outage. And you're like, what is Canvas? Well, back in the day, way back in the day, like when I was in high school, we did assignments on paper. Either you brought your own paper or the teacher gave you paper. Usually it was the first. And, it's later in school, you had to bring more of your own paper. And you'd write your assignment on the paper, you'd write your paper on the paper, and you turn it in. Nowadays, it's different. Nowadays, you write your paper on the computer, and you turn it in on Canvas, which is a tool that helps you work through a class assignment or test or, project. And you had to log in. And Canvas was so convenient. It was so easy. The teacher could just set up their class once and just reuse it over and over. And it was beautiful. And colleges just adopted it by the thousands. Even my college, the great Weber State. Great. Weber State University signed on. Every single one of the Ivy League schools signed on. They use Canvas. All of them. Over 9,000 schools use Canvas. And then, in the last week or so, a company called Infrastructure, who makes Canvas, got hacked. They got hacked by somebody called Shiny Hunters, which is the most hacker name of any hacker names I've ever heard. But Shiny Hunters saw something shiny in Infrastructure, hacked it, and gained access to the infrastructure, and shut down Canvas. When? Well, just during finals week. For so many of these schools, when they're all using Canvas to do their finals. So we've seen posts all over the place, everywhere, saying, we're delayed, Canvas is down. It's right now, it's in maintenance mode, which is not good. That's like booting up your computer in safe mode if you're on a PC. Okay, it's a bad situation. The worst part is not that there's a little delay and it's, some people aren't able to get in and things like that. That's not the worst part. The worst part is the hackers say that they downloaded, 3.72 terabytes of personal data from all these customers. And that if they don't pay up, usually in Bitcoin, they're going to release it all into the wild to the highest bidder on the 12th. Gives us 4 days. So that happens, and luckily my kids who are in college are actually done, even though their colleges were hit. They were affected by this. My wife, with the work she does helping people for college, her school was hit. It's all affected. So anyway, Canvas is the educational platform portal for all things digital classes. Yes. If you have an online class, you use Canvas. It's like saying a Kleenex is a tissue. Right? Kleenex. A tissue is Kleenex. It's one and the same. Canvas was the online portal for doing homework in college and even in elementary school. It's all over there. So yeah, everything was hit. If you want it's Attenborough. Okay. Sorry, David. 100 years old today. Thankfully, my school wasn't hit. It's like a Google Classroom. It's funny because Amazon itself was hit. A couple big, I think even Google as a company was hit because they use Canvas for training. Some of the Department of Defense sites were hit that used Canvas for training new employees and things like that. It's extra vocal fry on the bruh. Okay. I would like all hackers to be exposed. This hacking stuff's getting old. Scams and bank account. We had money taken out of our account. Don't like it. I tell you, I get scam emails, like targeted scam emails, almost every single day. Mostly asking to be to go enter into a business relationship with my company as a brand sponsor. We got people saying, "Hey," I got one today that said, "Hey, we're a legal networking company." And it would go perfect with your channel. They actually did their research to see that we're in the the sort of the law tube adjacent category, and they're like, this would be perfect for it. And just the simplest of checks shows that it doesn't check out. And they want to basically gain access to my YouTube channel, and I'd lose everything. Like Kathy figured out. Sorry, Kathy, we're using it as an example, but she got hacked quite recently, just got her channel back. Gossip, rumor, and innuendo. And it usually starts with somebody saying, we want to do a brand deal. All right. Let's see, Banfield was delayed. The next big thing coming up is the Corey Richins sentencing, which is next week. That's going to be a big thing. We're going to be carrying that one live, so do join us for that. The university I work for usually uses something called Blackboard, which is a competitor to Canvas. We're actually not affected as far as I know. There were a few that are not. That's awesome. I have used Blackboard in the past. Actually, I think I used it at a community college I took one class at, criminal justice class. Let's see. You never hear about anyone ever being prosecuted with the cyber attacks. Do you know why? It's very hard to catch them. It's really hard. Not Corey Reed or Karen Richards. Correct. And I tried very hard to not get the name wrong. I remember the cool chalk line thingy for the real blackboards. Oh, you're talking like the musical instrument? Just Stephanie, you're talking about the staff creator, where you have like a board with all these wires with pieces of chalk out, and you can just draw the entire musical staff with one big swipe. Is that the one you're talking about? I tell you, I was in seventh grade, Stephanie, when my I think it was a geometry teacher, was showing us how a compass worked, like one of those hinged compasses that has a little pin on one side and the pencil on the other. Well, this one has like an eraser on one side and a chalk on the other, and it's giant. It's like it looked like it was huge. It looked like arms, a pair of arms. And he's saying how he can draw, with this tool, he can draw a perfect circle on the board. And he opened up the jaws of the thing and it had the chalk on there, and he put the eraser part in the middle, and he set it down, and he traced this amazing, perfect circle. When he got to the other end, the ends were like, it looked like a spiral, because they closed like this. And everyone's just laughing. It's like, yeah, perfect circle. Great job, teacher. And he's like, that's due to slippage. Or like, oh yeah, now you make up a word to cover your butt, because doesn't work. Apparently slippage was a word, and that was due to slippage. So he was right on both counts, and I did fail that class. They did catch a hacker who leaked some gameplay of the new GTA game. He's in jail for many, many years now. He got caught. How can you catch the GTA guy and not the Canvas guy? Slippage is the word of the day. Yes. GTA 6 isn't real. It's crazy. Crazy fun. All right. Anyway, that was a story. Let's see if we can go to court. We've got a couple judges to watch today. We're going to try to steer clear of landlord-tenant stuff unless it gets spicy. But let's see what we got.
Did you, in fact, operate a vehicle in Romulus on February 18, 2026 this year? At that time, was your license suspended, revoked, or denied?
Debbie, hang on one second.
Yep. Have you found out since then that day it was, in fact, suspended? I'll accept your plea to the added charge and dismiss the original charges in keeping with your agreement with the prosecutor's office. Is your license reinstated now, sir? What do you have to do to get it back? Are you working? Where at and how long?
4 years.
Good. All right. Anything else you want me to consider before I sentence you?
You are guilty.
I'll work with you on the money. How's that?
As long as we get somewhere, we're happy to work with you.
Yeah, it looks like you already owe us some money on some other stuff. We got a no proof of insurance charge.
Well,
we got no proof of insurance from 2024. It looks like you owe us $209 on. All right, so on today's file, it's $500 and 4 days on the court work program. So I'm going to send you down to the front counter. The work days, you pick the days. You pick the 4 days. The days are scheduled. You got to be here at 8 o'clock in the morning. Go downstairs, schedule your 4 days, talk to them about payments, set up something weekly, bi-weekly, monthly, whatever works best for you. Any questions? What's that? No, not at all. I don't care. If, for example, if your normal day off is Thursdays, you want to set Thursdays, that's fine. All right.
Sounds
I'm not in a
good.
hurry to get the days done. I'm in a hurry to get the days scheduled.
And I'm in a hurry to get the money.
Go downstairs. You're all set.
All right, we're going to silence the judge for just a minute. Greeners comes in with a 36-month, the big red milestone. Says, Red, I'd rather be green. You don't get to pick your color. Greeners, thank you very much. Greeners is a staple on the channel, not just a staple, one of our great mods, and does amazing work. He's got a huge heart. He doesn't let it show. He tries to hide that, but amazing individual. I'm very, very grateful for you, Greeners. So glad you accepted the forced offer of becoming a mod on the channel. Thank you very much. One of our great mods. Really recognize you for 36 months today. Makes you an OG, and also an OG Debbie, the creative bee. Debbie, welcome. Wishing all the moms a very happy Mother's Day this week. Debbie, thank you so much. Debbie, this weekend, Debbie, congratulations. 38 months. For Mother's Day, that's on Sunday. I'm getting my wife a new car. And she's out picking it up right now, I think. Can that be the gift? She got to choose it, literally. I haven't even seen it. Here's what I did. I handed her every speck of cash I know of in existence in our house this morning. Every single bill. No coins, just bills. All sorted, all bundled. And she said, I'm going to go buy a car. And I said, okay. What is it? She's chosen out a Toyota Highlander. Did you wash the cash first? I counted it, and I bundled it into easy bundles for simple counting. I did not staple it. So nice of you not to make her go to Coinstar. I know, that was nice. So it's not a Kia. Apparently, we were going to go for a Honda Pilot. And just you can, if you're really curious into how much we spend on our cars, just know that the one that we could afford was a 2015 model. But instead, she went with Highlander. So I guess the Highlander is supposed to be better than the Pilot. I guess. I don't know. She's happy. She gets her car, and it's all good. So I just don't have any more cash. That's happy Mother's Day, Mrs. R.A. Let's see. I want a Durango Hellcat, but my husband won't get it for me. Debbie? I'm not going to say it, but just make an ultimatum. Make an ultimatum. Say, look, I'm not getting any younger, and the Hellcats aren't getting any cheaper. You better buy it now, or I know where to hide a body, and I'll use your life insurance money. Don't do that. Don't do that. Don't threaten anybody. Let's see. Is that how you do it? You have to work on Mother's Day? That's not fair. That's not fair. Speaking of life insurance, Corey Richards sentencing next week. What makes you say that? That's funny. All right, we're going to go back. We're going to go back and listen to court. I'm sorry, we're in the middle of listening. Let's see. Oh, we got a pro se. I will tell you. Thank you, Josh. By the way, Josh is amazing at finding these for us. I appreciate you. I know we're taking away from your fishing time. We've cut deeply into your personal routine when it comes to that. So I appreciate you helping us find these. Let's do a quick check in what this one he found here. Let's see if we can. Dana Margaret Hathaway's personal meeting room. There we go. What is this? Nope, not that. Oh, there's a public satisfaction survey she puts out. That's cool. Let's go back about an hour. Let's go to 6, shall we? Can you guys see this? All right, we've got it. Oh, you need the personal satisfaction survey.
Okay. Good morning, everybody.
Good morning.
Who
How
am
are you
I
doing,
looking
Judge?
for? We have Mr. Ayden. Who's on the Ayden case?
Good morning, Your Honor. Amy Gibbs on behalf of the defendant.
Okay.
Pro se right there.
All right, I'm going to call the case. Are you ready, Mr. Ayden?
Yes, I'm ready, Honor.
Okay. Calling case number 26-002473, Hassan Ayden versus Issa Shaheen and Bradley Mendelson. Appearances, please.
Hassan, are you in the plaintiff?
Amy Gibbs on behalf of defendant, Your Honor.
Okay, I don't know that we have to discuss whether or not the case should survive, Ms. Gibbs, because it sounds like Mr. Ayden is consenting to a dismissal with prejudice, which was one of the issues before. Is that correct, Mr. Ayden?
Yes, Your Honor, because of outgoing discovery disputes and, you know.
You don't have to say why. I just wanted to know.
Yes,
so,
Your Honor.
okay, so we're dismissing the case with prejudice, Ms. Gibbs. You still want to go forward with costs and attorney's fees? If you'd like to make your argument, go right ahead.
Thank you, Your Honor. Yes, we would, unfortunately, because of the history of this case and the myriad of lawsuits that Mr. Ayden has filed against the city of Dearborn and various city officials. We are, in fact, requesting that you enter an order for reasonable attorney's fees and costs to deter Mr. Ayden from continuing to file malicious litigation against the city and city officials. And as you know, under MCL 600.25912, the court has the discretion to award the amount of costs and fees, including all reasonable costs actually incurred by the prevailing party and any costs allowed by law or by court rule. We do feel that the this litigation falls directly within and meets all three criteria of what is determined frivolous as defined under that statute. So the statute defines frivolous as at least one of the following three, and here we meet all three. One, the party's primary purpose in initiating the action or litigation is to harass, embarrass, or injure the prevailing party. Two, the party had no reasonable basis to believe that the facts underlying the complaint were actually true. And three, the party's legal position was devoid of arguable legal merit. As I said, the statute only requires one of those three conditions to be met to impose the reasonable fees to the prevailing party. And here we have all three, as we outlined in our brief. I'm happy to go through those, Your Honor, if you'd like. Otherwise,
objection.
Hold on. Mr. Ayden, you're going to get the opportunity to speak. Mr. Ayden, you logged in at about 9:30. You were in your car then, too. You had no opportunity to get home or someplace where you could get out of your car?
No, I'm home, but my grandchild's yelling and screaming. I had to come outside, so I'm sorry.
I understand. All right. You're looking for a quiet place. Okay. I at least appreciate that. Okay. Ms. Gibbs, were you finished?
Do you live in your car,
I
sir?
can go into further detail about each three of those conditions and how they were met, Your Honor, if you would like. Otherwise, we did set them forth in our brief.
Oh, she says
no. I don't need them. Okay. All right, Mr. Ayden, this is your opportunity to make a record. Go right ahead.
So, Your Honor, first, she says frivolous, okay? She doesn't want to do depositions. She doesn't want to go through litigation. There's over 900 pages in Washtenaw County, okay? Frivolous, it's not frivolous. My case was at a city council meeting. I was at the podium speaking. I got arrested twice, okay? The chief of police's job is to protect the public, not to listen to city council member telling him to arrest me on the podium. He could have told him I cannot arrest him on the podium. So he used malice, intent. This is not a frivolous case. I have the city of Dearborn, I'm suing them in federal court right now, okay? I said to myself, instead of all this litigation and all these depositions, I just want to dismiss the case. First, I dismissed it without prejudice, okay? Then she wants to sit there and tell me, without prejudice, then she wants to vacate. Then I sent her a stipulation to dismiss with prejudice, right? To end the case. She would not sign it. What they're trying to do is make me as a person filing lawsuits. She wants to sit there and say I filed other. This has nothing to do with other lawsuits filed. My other lawsuits have nothing to do with. I just don't want the litigation to be from federal court to be the same thing over here. And I can prove it to the court. She knows. She knows I'm gonna sit there and just go to federal court, the back and forth depositions for what? For additional economy. But she doesn't want to dismiss. She wants me to look like I'm a bad person. I'm prosa, 900 pages. If you see there's 900 pages, I asked for depositions, they dodge them. I asked for interrogatories, they dodge them. Like, I just want this case to end. I'm not doing this to harass. I'm not doing this to put a burden on anybody. I'm just tired of the back and forth motions with her. She doesn't want to compromise. I send her emails. Like, the back and forth, it's getting very exhausting for me. I asked this court to dismiss this case without any sanctions because without any attorney fees. I'm prosa. I don't got no money to afford an attorney. If I had money, I could have represented. I'm not here to harass. I got arrested on a podium. I'm allowed to speak. For playing an audio recording, I get arrested. For sitting there saying the wrong thing, I get arrested. They don't want my speech. They use malice against me. So I'm entitled to file a lawsuit. This is not a frivolous lawsuit. I have no depositions in front of me. On a C7, they put Facebook content. They're not allowed to put on a C7 and C8 extra materials. And she did that. They're trying to make me look like I'm a bad person. These are individuals that are employed by the city. Anybody that is a public official can get criticized. Why are you putting Facebook when I did not enter it in my material? They're adding extra materials. Now she's sitting there saying frivolous. How's it frivolous? We didn't even go through depositions. I can sit there and tell you, you know what? I want depositions. They put extra materials, and I want you to deny the what's it called. But I'm not going to sit there and go through this. The back and forth is just too much, Your Honor. That's all I have to say.
Okay. Ms. Gibbs, anything you want to add?
Yeah, I mean, I agree that the back and forth is too much. There's been numerous litigations filed against the city by Mr. Aoun. We have, requested at various times that he dismiss those. He has never agreed to dismiss with prejudice and has a MO of agreeing
Objection.
to voluntarily.
No. You don't object during the hearing.
Agreeing to voluntarily dismiss and then filing in another circuit court, federal court, wherever he can find in this vendetta against the city. And we really need to deter this type of serial filing and harassment. The motion for summary judgment indicates that any and all actions taken by these two defendants completely fall under governmental immunity. So we have a basis under C7 as well as C8 because he did not put forth any legal merit or factual merit to support any of his claims. There was probable cause to arrest him when he spoke with vulgarities and refused to leave and did not follow Open Meetings Act laws and the decorum of the city council, which again is all within the governmental sphere of these two named defendants. So we have basis for dismissal of each and every count under C8 as well.
Okay. All right, Mr. Ayoun, now it's my turn. First off, this case is going to be dismissed with prejudice. The claims all fall under governmental immunity, and the two employees are insulated by governmental immunity. So there's not an issue there. I am of the opinion that in reading MCL 600.2951, you probably should be entitled to attorney's fees and costs. However, I am bound by the Court of Appeals opinion on this subject. And in particular, there's one that came out in 2023, Davis versus the Wayne County Commission, where the Court of Appeals dealt with one of the most prolific abusers of the legal system and found in a bizarre attempt to justify abuse like this that courts need agitators. So given that opinion, I can't grant costs and fees. I hope you do take this up, though, because this kind of reminds me of that Martin Niemöller quote. No. My turn. Okay. Stop, Mr. Ayoun.
I apologize.
What I was saying is it kind of reminds me of that Martin Niemöller quote, that everybody's fine with something happening to someone else, And there's not going to be anybody left to do anything when nobody stands up. So
sort of.
Your request is denied, Miss Gibbs. If you want to take it up, God bless you. Thank you, everybody.
Thank you, and I apologize if I did anything wrong.
Miss Sullivan, or Miss Gibbs, I guess, do you have anything else with me?
No, Your Honor.
You're good. Thank you. Submit an order. Miss Sullivan, you just turned your video off. You ready to go?
I was just here to observe, Miss Gibbs.
Oh, okay.
Thank you.
Yep. Miss Janisic, you are next.
Thank you, Judge. Good morning.
Morning. What case are you here for?
I am here on the Muzan and Poinces consolidated cases. I've got both case numbers 240.
Sorry. I just hit myself in the face with my stack of motions. This is Shanae Muzan versus Roynell Williams?
Yes, Your Honor.
Looks like we have a number of people on here. I'm going to leave it up to you guys to let me know if we're missing anybody after I call the case. Let's start getting appearances. Calling case number 25-006313, Shanae Muzan versus Roynell Williams and others. Appearances, please.
Lisa Janicek for defendants Williams, Your Honor.
Good morning, Your Honor. Elena Semeta appearing on behalf of Marita Pointes.
Okay.
Good morning, Your Honor. Madeline Nicola on behalf of defendant Muzan. How are you?
I'm doing well.
Good morning, Your Honor. Steve Landstrom on behalf of defendant Citizens.
I believe that's everybody.
Well, good morning, Your Honor.
Mr.
Howard Eisenstedt. I represent Shanae Muzan as a plaintiff.
Okay.
Underlying case.
All right. Then I am... Are we looking for someone from Progressive as well? No? I'm just reading the caption here. Nope. I think there was a wrong caption. Let me see.
There is Progressive on our caption. I don't know if they plan to be here.
Okay. I just want to make sure we don't get started without
Let's jump. Where are we jumping
anybody.
to?
So according to everybody that's checked in, I think...
Let's jump back here.
With all the other matters being dismissed.
Okay, Mr. Green, did you discuss your rights and options with Mr. Bowditch?
We're looking for a tree case. Yeah. Green is close.
You understand those rights and the options they present to you? You understand the possible penalty for the charge of open intoxicants? Up to $500 fines plus court costs and up to 90 days in jail. Understood? Is that a yes, sir? All right. And do you understand the possible penalty for the charge of allowing an unlicensed driver to operate? Up to $500 fines plus court costs and up to 90 days in jail. Understood? Understanding all of this, are you pleading guilty to these two charges today?
Resting a no contest plea.
You got the facts that I need?
I think probably get it from the ticket.
Sir, you're going to plead no contest to these charges? Are you doing so freely and voluntarily? Do you understand that when you say no contest, you're literally saying, Judge, I'm not fighting that charge? You understand what a no contest means?
Yep, that's what it means. Not pleading guilty, but not fighting it.
I think the ticket, the appearance ticket has enough facts on it to support the plea. I'll accept the plea to the two added charge, dismiss the original charges.
That's satisfied.
What should I know before I sentence Mr. Green?
Well, Your Honor, this all happened, unfortunately, a mishap about his insurance, but kind of spiraled out from there.
Mr. Green, anything you want me to consider before I sentence you?
No, sir.
Okay. All right, are you working or retired? Where'd you retire from, sir?
How
long you been retired from the union? Good for you. No shows. What's the status of Mr. Green's license?
I believe he's valid.
You still suspended?
Yeah, we go.
Still suspended.
File the motion.
All right, so we're dismissing that.
But he'll owe $45.
Yeah.
To clear it.
And then he can get his license back.
It looks like.
Can you pay 45 today? All right, so then you can get your license back. All right. Yeah, you got to go to Secretary of State to get your license back, but the 45 will clear you to do that. You understand that? All right.
All right.
All right, fines and costs on each of these two files, $250 for a total of $500. Can you pay that today, Mr. Green, or you need options? Go downstairs. You want us to just set up a payment plan? Yeah. All right. All right, go downstairs, set up some kind of payments, weekly, monthly, bi-weekly, whatever works for you. Any questions? Good luck.
Carl, I believe that speaks about.
Thank you.
Anything else for me?
Thank you.
Thank you. Thank you, guys. Have a good weekend. If I don't see you.
So that,
Yes, we just waited.
So what are you gonna do about the feral?
Waiting in the share.
Just, are we like the items or whatever?
Yeah.
Dep, we're going to default them.
Yes, Your Honor. Mr. Klaska would be admitting to this count one, the non-technical, the technical violation of violating the electronic monitoring program where he was at an unapproved location, and the count involving.
I can see an ankle monitor on his right now. This is
dismissal from unsuccessfully from some regional recovery court. And then I believe it is count 5.
Josh has one for us.
Involving having violated the no contact order with Mr. Todd Klaska or Gene Klaska, directly or indirectly. And people would agree to dismiss the count involving not violating any criminal law, as well as not violating any law for resisting, obstructing, and there were 2 separate officers.
All right. Ms. Risky, is that your understanding of the plea offer?
Yes, pleading to counts 1, 2, and 5, 3, and 4 are being dismissed, Your Honor.
All right. Mr. Klaska, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Thank you. Sir, your name is Alex.
Sorry, that's just a sentencing for breaking his monitoring rules. Let's see, we're going to go to 7 here in just a second. Thurston County yesterday from Josh.
Travis Gray? Oh, on the Zoom. Thank you. Mr. Gray.
Travis Gray.
Can you unmute yourself?
All right, I figured out the microphone. Yes, I'm here.
Okay, this is cause number 6A0093157. 1 count of operating a vehicle without insurance. Do you have any questions about how you'd like to proceed?
No, I had just bought the vehicle. I met the owner. The owner picked me up. We went to the DMV because he didn't have a title to the vehicle. And when we went to the DMV, I didn't realize his wife was picking him up, and I got left with the vehicle. And I got bumped on the way out, and she took off, and apparently she was following me, but that's a whole nother story. I had insurance. I sent you copies of the paperwork that I had. I had a non-owner's insurance at the time. But since I own the vehicle, I'm fighting with the insurance company now to have it, insured. It's been a long process, a very, very long process.
Understood, sir. Just give me one moment, please. So in order to mitigate an insurance ticket, I do need to see some type of proof of valid insurance. And it's going to be very difficult for you to show it to me over the phone. It has to be a piece of paper that I can later add to a court file if need be.
I've emailed that to you guys already. The clerk, I've been in contact with the clerk for the last few weeks, and I've emailed my insurance and the registration. I've emailed everything I have, driver's license, everything.
Understood. That was just an error on my system. Give me 1 second, and I'm going to take a look at all that.
All right, appreciate you.
Josh Gewis, content
And you
warning.
do have 2 counts, sir. You're aware of that? Also cause number 6A015154. We'll kind of take them one at a time. So starting with the one in 3157.
Yeah, I've got 2. One, no insurance, no driver's license. I just went and got the driver's license yesterday. I was just released from prison. I had 2 driver's licenses when I went into prison. And when I got out, all of a sudden I didn't have any.
How can you have 2 driver's licenses? Doesn't the other one get canceled? Because you have to have. I mean, was one of them fake? Went to prison for fake IDs.
I'm just looking through the emails now, sir.
All right.
And we're looking into your ear. I don't know why, but.
On one of the emails from Dairyland, they had the wrong name on the account, and I've given you my email addresses that has the correct name on it, and they were supposed to have fixed it, and I'm in talks with them trying to get everything situated.
Sir, I absolutely understand that frustration. I do need to see an insurance card that has your name on it and says something like effective date, this date, and expiration date, this date. I do see,
I've sent that. I've sent that to you. It's one of the last things I sent today.
Sent today?
Yeah, I sent it today. My driver's license and the insurance card.
Janet's not buying
today.
this.
I see an email that was sent on April 28th asking you for the photo of your insurance card. And do I just not have that in my file? The clerk and I are really actively looking for this, sir.
All right.
It's just not there.
I'll tell you what time I sent it.
These are hockey players walking in the background.
That may not be enough. Things have to go from wherever they go
Janet's at the
to
hockey
me.
rink.
See if the clerk can find it anywhere. But so, yes, sir. So we don't have anything from you today. That being said, if you would like to continue this and have another opportunity to send in the insurance, that's fine. But at the moment, I just don't have it in front of me, so I just can't base my decision off of it.
It says the court has received your exhibits and have forwarded them to your file, and you are hearing for your hearing this afternoon. That's the text I got. Infraction 6A01515540. No license, just that's the one I've sent to her today at 9:50.
Sir, I completely understand, and I do see that someone requested you to send that, and I do see something that says that this will be added to your file, but I just don't have it, sir. And I appreciate what you're saying. If this was some type of an error, then, of course, a continuance would allow us to fix this, but I just don't see it in front of me. My clerk is still looking, though.
All right. Let me.
Okay. We have found something that was received this morning, and the clerk is just adding it to the file, sir.
Oh, thank God. Thank you.
Thank Janice. She's the clerk.
You there?
I'm still here, sir. We're just, just adding things to the file so I can see it.
No, you're good. You're good. This has been crazy frustrating.
Well, it'll be crazier if as if the attachment is
hello.
valid. I think Travis may be suffering from Tourette's.
Remember in the beginning when we started 110 years ago?
I've seen it updated on Laserfish here. Tried refreshing. I did see it on your end, though, so I do believe that it's
squirrel finds a nut every once in a while.
If they didn't, I would lose my mind.
For a second, I thought we had Mr. Frog in there, but no.
What more do you need to see?
I'm just going to take a brief nap while they find the documents.
Don't miss the forest for the trees.
I don't like
Yeah, just look on it on your screen. So, sir, I don't know what the issue was with getting into the file. My clerk does have it on her end, so I just frankly just got up and viewed it there. I did see insurance with an effective date of March 20th, 2026, and your name on it. And so because of that, I can mitigate this to with $200. All right. So on that matter, mitigated to $200. Next matter, cause number 6A015154. One count of no valid operator's license with valid ID. How do you want to proceed on that one, sir?
I have a valid driver's license now. Like I said, I was released from prison November 28th. When I went to prison in 2019 in New Mexico, I had a driver's license in New Mexico and I had a driver's license in Washington. New Mexico.
So I understand, and I'm sorry to cut you off there. The big thing here is I just need to see that you are licensed. And you know what? I can do that just by looking at your driving record here. I do see that you were licensed as of 05/06/2026.
Yesterday.
Two days ago now.
We can reduce that one to 200 as well, sir.
Why reduce that one to 200 as well? Because I was released from prison and I had two driver's licenses. Unbeknownst to me, one of my licenses was surrendered when I got transported here from one prison to another prison. I had no idea it was surrendered. I had no intentions of even having it surrendered.
And sir, I completely understand. I don't mean to cut you off. I have to go with what information I have in front of me. I have in front of me an issue date of a license. I don't have any other information about a past license or anything like that. I do know that you were issued a license.
I sent you my driving abstract from Washington and New Mexico. I've paid for them and sent them to you. It should be in my file. You should have an abstract of everything I've done since 14 years old when I had a driver's license. I have never had suspended or revoked or any kind of license. I think it's bullshit that they've surrendered my license unbeknownst to me and forcing me to take a drive test and a written test and all this other bullshit when I had a valid license to begin with.
You're not helping your situation at all. I'm going to find this matter mitigated down to $200. This is based off the information I have in front of me, and that'll be the order of the court. You can pay that over.
That's fine. Send me a bill. Eat a dick.
So you can pay that community service at a rate of $20 an hour, or you can pay it over installments or in full. Next matter is going to be Ayden Hand.
Oh, he's still sharing information.
This is cause number T00162236.
This man has a lot of cables.
One count of speeding and one count of no valid operator license with ID. Did you hear about your options today?
Yeah, I'd like to do a mitigation.
Okay.
I was here a month ago, but I didn't actually get the opportunity to explain the situation.
I think he asked for an edict, is what he said.
Understood. Just give me 1 second here to pull up the report and everything.
He said, issue an edict. I'm pretty sure, if you go back and listen really carefully, he said, issue an edict. I'm like 99% sure that's what happened. What's in the envelope, Janet? What do you have? Coupons?
Okay, sir. What would you like me to know?
Okay, so my friend was in the car with me because it was his vehicle. He has one kidney and a catheter, and his only kidney was like in critical condition because it's his other kidney that he lost had a failure, function failure. So his other kidney is kind of doing the same thing. And so he wanted me to take him to the hospital because he was driving at the time and he really needed to go to the hospital. So that's why I was the one driving, because he couldn't operate the vehicle in the amount of pain he was in. And that's why I was speeding as well.
Okay.
Good reason.
For telling me that. Do you have a valid ID on you or a valid driver's license on you right now?
I have a valid ID on me. I wasn't able to get my license in the amount of time I was given. Because they've been very busy. I haven't been able to set an appointment.
Well, you should have called 911 maybe. Is that a Doomsday shirt she's wearing? Bloomsday. Okay. It's different.
And you say that you were driving your friend who was having a medical emergency, and
yes,
true medical emergency, like a kind of life or death one, or?
I'd like to believe so. It's happened one at a time. I didn't drive at that time. My mom took him, but that's because we were at the house when it happened. But we were out doing Uber when this happened. So like we weren't too far. We were like a couple miles away from the hospital.
Okay. So normally I do need to see proof of a valid ID in order to reduce that one.
I do have it.
You know, or a valid driver's license.
Doesn't have that.
That is, you know, most of your ticket fine is that amount. Do you think you could get a license in 30 days?
I'm not entirely sure, to be honest. I've been calling, trying to get an appointment. He gave me 30 days last time, and I haven't been able to set an appointment yet. If I'm not able to do that, would I be able to do like a payment plan?
Yes, you can do a payment plan, and I will reduce this under the extremely extenuating circumstances. I can't take it down that low, but I'll take it down as much as I can. I'm going to reduce the speeding to $93, and I'll reduce the no valid operator license to the $250. Okay. You can come up here and get your stuff. Okay.
Wow. Apparently, can't drive your friend to the hospital without a driver's license, even in an emergency. I had to get pulled over once driving a friend to the hospital in an emergency. It was a food poisoning emergency. So he felt like he was dying. He wanted probably to have that be true.
Speak to Allison Huff.
But he wasn't dying.
Allison Huff in the courtroom. Allison Huff online. What about
bench warrant?
And I apologize if I struggle with this name. Abel Kausi Lenore. This is cause number T00145691. One count of failure to renew registration. Any questions about how to proceed?
Yes, sir. And is it gonna affect my insurance?
Yes.
Non-moving. This is a non-moving violation. We're generally not reported to insurance.
Okay. So, and I can explain what's happened. I still have the insurance in my car. It's a business car, so I don't usually drive it, and I don't know that the license was expired. The tab was expired. If you look at it, the next Monday, following Monday, I went and purchased the tabs on it.
You have updated tabs?
Yeah.
Can I see those?
Yes, sir. I was stuck on Saturday, I believe. Monday, I went to pick it up.
Is it a run? Is it a Bloomsday run?
This was a 13. I got pulled over.
Susan CR, thanks for the 5
Monday,
gifted
I
memberships.
went to take care of that, sir. I didn't even know that the tab was expired.
I found a few years ago my kid was the no license sober driver in high school, still doesn't drink. Okay, cops should give a break in that situation where it's like, I'm the designated driver. Give me a pass.
Yes, sir. I appreciate you doing that, and I appreciate you bringing this in. The lowest I can reduce this down to is a $115. Thank you. Have a good day.
This court's raking in the money today.
Next is a Lucas Lowen.
Lindsay's
This is
brother?
cause number 6A0199187, one count of operating vehicle without insurance and one count of failure to renew registration. Any questions about how you'd like to proceed?
No.
What would you like to do?
Got an insurance card, and I brought a registration with me, but I grabbed my wrong registration. I grabbed the old one, but I got tabs the next day.
Likely story.
Unfortunately, I just have to see it.
I know.
You know, and it's a pretty substantial.
I have a picture,
difference.
but that doesn't help because it's on my phone.
Unfortunately, no. But you're doing everything right.
Yeah.
How would you feel if we continue this and you brought in what the court needs to see? We can set a hearing at a later date, and then you can come in with the evidence. I mean, I can view the insurance thing. I just can't go off your word on the tabs.
I mean, I guess.
What makes me think he doesn't actually have insurance? Why would he not say yes right there?
And I'll be very upfront with you, sir, just to help you make up your mind. If I were to see the renewed insurance, the lowest I could take it down to is $175, and it's currently at $242. So it's, you know, maybe or maybe not life-changing amount of money, but the insurance one can likely be mitigated pretty substantially while you're here.
Okay. I'll just give you the insurance one, and then I'll just pay for it because it'll cost more if I take more time off.
Understood. Let me see the insurance.
That's their design. That's their plan.
Thank you. Looking at an insurance card, I see the name. I see an effective date of April 7th, 2026. This was a committed date of March 14th. So I can reduce the insurance down to $200 and then enter the full value on the registration, total of $442.
Yeah.
So come up here and just get your stuff. I'm sorry. Should have told you while you were up here. And of course, you can pay in full installments. Yeah, we got it. Next is Ryan Matney.
I think this is all just traffic court stuff.
Good afternoon, Your Honor. Good afternoon. This is cause number 6A0213301, one count of speeding in a school zone and one of failure to renew expired registration. Do you have any questions about how you'd like to proceed today?
I don't.
I don't remember seeing your face, and I apologize if I got that wrong. Did you get to hear the three options today?
No.
Okay. Just kind of in a nutshell. Contested hearing, that's where you're telling me that you didn't commit the infraction. We have kind of a mini trial. If you lose, I find it committed with the full fee. If you win, that's just it. Mitigation hearing, you're telling me you did do it, but you would like to give me reasons to reduce the fine. Still goes on your record and everything.
Yeah.
Then deferred finding, if you qualify, pay an administrative fee, don't get a ticket within 6 months. This one's automatically dismissed. Any questions about those?
No.
How would you like to proceed?
Mitigation. Yeah.
Well, and I have to warn you, sir, that speeding in a school zone is one of those tickets that I cannot mitigate.
Understandable.
And then do you have
You're just going to get a huge fine.
valid registration now?
I do.
Can I please see it?
Yep.
This could be like a $500 to $1,000
I
fine.
apologize. Do you mind just taking it out of the slip so I can see the name on there? No, you're fine. Looking at the registration, issue date of April 2nd, another date of 3/16. It happens. Okay, I can reduce this down to, it says expired registration greater than 2. And you can sit back down, sir, if you'd like, yeah. So school zone would be found committed at 392, and I can take the insurance, or not the insurance, but the failure to renew registration down to, and the fines are different if it's greater than 2 months or less than 2 months. Officer didn't note how long the registration had been suspended or had been failed to renew for the narrative. He did put it in the citation, but that's not enough for me. So we'll just take it down to the 115 on that one and commit it on the other.
Thank you.
And you can pay community service all at once or installments, totally up to you.
Okay.
Community service, $20 an hour.
Okay, cool.
You just take your slip from the clerk.
Right here or out there?
From her.
Oh, okay.
Next, we'll call Jeanette Palmer. There's Jeanette Palmer on Zoom. Oh, there it is.
Yes, that's me.
And Ms. Palmer, this is cause number T002332338, one count of failure to renew registration. Any questions about how you'd like to proceed?
I think mitigation. I had a senior moment and forgot to renew my tabs. I always do it in May, and my daughter had my first grandson, and I think I just, got discombobulated. So I've got last year's now, and I've renewed for this next year. I've got my license, my insurance. I'm good to go, but the state patrol got me.
This is I appreciate you renewing the registration. I do need to be able to see it for the sake of the court file. I don't know if I'll be able to see it on the camera or not, if that will count. I will do everything I can to make that count, though.
Okay, if you hold it up, I'm going to zoom out like this and show it like this. So, yeah, it's sort of blurry. See it signed, Janet.
That's so close.
Get closer, Judge. Get closer.
Okay, I do see a registration that is valid as of 04/12/2026.
Yes.
And I see name on it.
And then I got the new one.
Don't want to show the
Should be to 2027 now, even though she said I didn't have to renew it till May 24th, but I said, I'm not going to forget this year.
You need to put the sticker on the car license plate, though.
I can take this down to, just give me 1 second here. I have to exit. I've got you. You're good, ma'am. Thank you so much.
All right, we're back. Didn't want to share.
I thought I had a commercial driver's license, but
you just thought you did?
Officer checked that I didn't. I know I have to update my physical, but I'm not currently driving a commercial vehicle.
But she knows how. Maybe it's the hockey
So I
bus.
see that they had expired May 24, 2025. This was issued on April of 2026. Okay, I can reduce this down to $175.
What about 115? I thought the last guy got, well, anyway. Okay.
She's bartering.
The last guy, I couldn't tell how long it had been. I can tell how long it's been with yours. So, got to do what it says.
I know. Okay, thank you.
Of course. You have a
And
great
how
day.
will I pay that? Through the court? Will I get?
Contact Thurston County District Court. We're not going to send anything out, so just call the district court, give them your name, let them know what happened, and they'll make it happen.
Okay, thank you very much.
Next one is a Timothy Spino.
Yes, sir.
And this is cause number T00262-607. One count of using electronic device while driving and one of failure to use a safety belt. Were you here for the explanation of how to proceed? Are your options today?
I don't need, no.
Okay.
I just want to tell you what happened.
I was sitting next to a state.
You just want to tell me first, is this a contested hearing, mitigation hearing, or requesting a deferred finding?
I believe this is a mitigation.
Okay, where you're going to say that you committed it and then give me reasons to reduce the fine? Okay.
I was sitting next to a state trooper with the light. I was using my GPS and it came unstuck from the windshield. It fell down, hit my legs, and the GPS itself went down by my feet. I tried to reach it, I couldn't. I did my seatbelt, grabbed the GPS, looked at it, light changed. I pulled forward. He pulled me over, said I was using an electronic device and didn't have a seatbelt on.
Understood, sir. I'll just take this down to the lowest I can take them. Each one can be reduced to $93. I think that's $186 total.
I don't really think I had a choice, you know. The thing was down by my gas pedal. I had to get it out of there.
It's exactly why we have the mitigation hearing, sir. You know, that's the lowest I can take it, though.
All right, cool.
This court has no mercy.
For the failure, you didn't, I guess that explains the seatbelt, too. You had to take it off.
I couldn't reach it.
Take them down to just both as low as I can go.
All right.
Did I get that right? $186? Yes.
Any cup?
Of course.
Basically, the court's saying you should have pulled over, turned off the car, and then done it. Red Pen gifted 10, and now Shelly Small gifts another 5. Thank you. You guys are very generous today.
Next is a Kimberly Tiedman or Tiedman.
Kimberly
Tiedman. Anybody on Zoom at all?
No, Judge.
Okay. That is it for the 3 o'clock. Is anybody here for the 3 o'clock whose name was not called?
This was last night, first.
Let's go right into
got a few people here still, Judge. I'm trying to watch my messages.
Everybody today has 3 options to resolve their traffic infraction. You can do a contested hearing. That's where you are telling me that you did not commit the infraction. That's what you'd like to do. We have kind of a mini trial. I read the police report, take your testimony, and then determine whether or not the infraction was committed. If I find it committed, it goes on your record and you pay the full fine. Next option is a mitigation hearing. That's where you're telling me that you did it, but you want to give me some reasons to lower the fine. Just give me some good reasons, and there's a good chance I will. Last is a deferred finding. That's where you are just paying an administrative fee. And then as long as you don't get another infraction within the next 6 months, then this one will be automatically dismissed. You don't have to come back to make that happen. But if you do get another infraction, then this one's found committed. Okay? So I'm just going to start calling everybody.
Clear as a bell.
If you have questions, please feel free to ask when your name is called. And I should let you know, not everybody qualifies for deferred finding. Again, ask me if you qualify. I'm happy to tell you. First one is a Miranda Achenbenner.
Present. Close enough.
Come on up.
Please come up.
Oh, sure.
And I apologize. How do you say her last name?
Aschenbrenner?
Aschenbrenner. Thank you.
It just
so much.
looks scary.
This is cause number 6A0076115, one count of no valid operator license with valid ID. Any questions about how you'd like to proceed?
No.
And how would you like to proceed?
The mitigation.
Can she? Can't see what her shirt says.
And do you currently have a valid driver's license?
I do.
Note that I do see that on your driving record.
Oh, you do?
And I can save you the trip up here.
I honestly didn't know that it wasn't valid. I had the SR22 for a while, and then after that expired, I didn't realize I had to go back and get like a real driver's license. And so that's where the gap was at.
Understood. So the lowest I can take this down to is $200.
Oh, that's fine. All right. It's better than the 6. Thank you very much.
Of course.
And I just call the court and
you can get a slip.
I don't know what her shirt says.
Thank you very much.
Of course.
She'll take the 200 and go.
$20 an hour for community service. Just ask at the window for the community service form. We don't have any particular places, just nonprofits. They fill it out.
Cool. Thank you. Have a great day.
You too. Next, a Joshua Batella.
Josh, bench warrant shall issue.
How about a Colby Chance?
Bench warrant.
How about a Charles Deffendahl?
Charles.
It's cause number T00265574, one count of using electronic device while driving. Do you have any questions about how to proceed?
No, sir.
How would you like to proceed?
I would ask you for a deferred, please.
Just going to see if you qualify.
Boom, boom, boom. No, you do not.
Apologize, it is just running slowly.
No worries. My computer's run slow, so.
And I drive fast.
Can't do anything about this one. Okay, looking at history right now. I do not see a deferred finding used within the last 7 years.
You can qualify that.
And you do not have a commercial driver's license, and this is something that qualifies for the deferred finding. So the administrative fee will be $150, and then once that's paid, just don't get another infraction in 6 months.
Could I have the administrative fee reduced? I was diagnosed with MS, so money is tight right now. Getting back and forth to work and doctor's appointments, money is kind of low, and I would ask for a little bit of leniency on that, sir.
I understand. I think, yeah, I'm just not able to, sir.
Okay.
And I apologize. It's just something I can't do.
Yeah. Understandable. Okay.
You get your the slip from her, and then
and this does not, if I proceed with the deferred, it doesn't go on my driving record, nothing like that, as long as
correct. As long as you don't get that ticket, it'll be dismissed.
Awesome.
I mean, not like it didn't happen, because it'll be a record that you had one of these. You can't do it in 7 years, but that is just dismissed other than that.
Awesome. Thanks, sir.
Of course.
Told you, this court has no mercy.
And is there a James Fogel?
On Zoom, maybe?
How about a Sean Hampton?
No.
Is that?
It's CN.
CN.
Yeah,
I'm
it's okay.
so sorry.
It's okay.
I'm so
no
sorry.
worries. It's okay.
This is cause number T002463031, one count of speeding in a school zone. Any questions about how you'd like to proceed?
Just one. If I request a deferment, do I need to explain my circumstances or no?
No.
Okay. Can I see if I qualify for the deferment?
I don't think you can defer this one, right? Speeding in a school zone? This one's pretty serious. Not looking good.
So I do see that you used a deferral
just
back in 2019.
Judge, that's 7 years.
8/27/2019. That unfortunately puts you still within 7 years.
Oh, no. Ouch.
So fortunately, we can't do the deferral. It's a ticket that can't be mitigated either.
Oh, so either way, you're going to lose. Way to give her hope, Judge.
So would that leave my only option to contest it?
Yeah.
All right, let's do it, I guess.
I'm going to read the police report and then swear you in.
Read out loud, Judge, just for our benefit. This is speeding in a school zone.
Please raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
What would you like me to know?
So I was I live in that area. The way that I was traveling, the school zone signs that are posted say when children are present or when flashing, and school had started. So there were no kids present. I didn't see any. I was surprised when he pulled me over. I even asked if he was pulling me over because he had stopped 2 cars at once. And he said, yeah, you're doing 35 in a school zone. I thought I was doing the speed limit. The speed limit's 35. And I follow the rules of the road. I work in corrections. I try not to get tickets. I do the best that I can. And so I was shocked when he told me that, yes, he was indeed pulling me over. He let the other car go, gave me a ticket, and that's it. I mean,
I appreciate you letting the court know that. I do see that he measured you at a particular distance, and a calibrated speed measuring device, a LiDAR, and does have you within 300 feet of the school zone. The school zone is 300 feet either direction from the crosswalk or the edge. I do think under preponderance of evidence that this was committed. So
even though sorry, I don't mean to interrupt you. Even though the light on the sign wasn't flashing and there's no children present, because that's what the school zone signs indicate. That's what confuses me about those.
Yeah. So what I don't have in front of me, I understand your testimony that the light wasn't flashing. I do have the officer putting you in a school zone at a particular time. I pulled up, we had this discussion about an hour and a half ago, and that's why I sound so well versed in it. It's just look through this and still have the tabs open. Speed zone may only include the area consistent with active or school play use. So there's nothing in the WAC about whether or not the lights are flashing. I just do think that under a preponderance of evidence, I can find it committed here. If you just please take your slip from the clerk.
Okay.
Guilty. Cha-ching. This judge is right. Does he get a cut? Does he get a cut of all these fees? So the sign is wrong.
Next is Kimberly Johnson.
I have to admit, I don't like the sign. Because then if you just didn't see the kids, then it's okay
Molly
to speed.
Markham.
How about we just say who is here?
How about a Kendall Rice?
Kendall. Come on up, Kendall.
This is cause number T002418911. One count of using an electronic device while driving. Do you have any questions about how you'd like to proceed?
No, Your Honor.
What would you like to do?
Mitigation, please.
Okay. What would you like me to know?
I was driving home from work and my grandma had called. My grandma's not one to call, and I know my uncle's been struggling with some health problems. She's currently taking care of him, was at the time taking care of him. And
I think this is getting sad.
I kind of panicked and answered my phone. My Bluetooth is super fidgety. I have to unconnect and then reconnect back to my Bluetooth. So I didn't want to mess with that. I was kind of just panicked and answered the phone. It turned out to be nothing. She just needed me to pick up something from the grocery store. But as I was finishing up the call, that's when he got me.
Appreciate you sharing that. Of course, you haven't met the definition of the infraction. I am someone who's super sympathetic to picking up when grandma calls. I'll just reduce this to as low as I can go, which would be $93.
Appreciate it. Thank you, Your Honor.
Of course.
93. We should have been ringing this up. This court's making some bank today. Just
next is a Jaden Somerville.
Jaden.
Cause number T000617775. One count of speeding. Any questions about how you'd like to proceed?
Yes. First of all, before we begin, I'd like to warn you, I do have a slight stutter, just to let you know.
Okay.
And I originally signed up for a mitigation hearing, but I believe that I would like to go with a deferral. I like to ask one question about the deferral.
Of course.
So does I know you said the deferral goes on my record. What exactly does that mean? Does that mean an insurance company would see that, or?
It's a great question. And, on the record means a couple different things, So if you are successful in the deferral, then your insurance company won't be reported to them in a way that affects your insurance. If you're not successful on the deferral, then it will be.
Okay. I would like to ask for a deferral then.
And I'm just going to check a couple of things as fast as the system loads.
One of the things he has to check is how fast.
I see you look at your record. I don't see you've ever used a deferral.
Good. That's good.
And you do not have a commercial driver's license. So your deferral fee would be $150. You just get a slip from the clerk. Any questions about how to do that?
So as long as nothing else happens, this is all gone.
Yes. No tickets in 6 months.
Okay. Yeah.
6 months. I thought it was 6 years.
For some reason, I thought it from here. Or
from her. No, you were right.
See, I had one of these. It wasn't called a deferral. When I did it, it was called a plea in abeyance. I was about to leave the country.
Karen Valenzuela.
Karen. Come on down, Karen. You're the last one. But it doesn't mean you're least important. Every case is important, Karen.
Call number 2196001. Do you have any questions about how you'd like to proceed? No? What would you like to do?
Mitigation.
Mitigation?
You already used up your deferral? Judge is going to read the report. Where's the police report? Do you have the police report?
Okay. Anything you want me to know?
Were you reading my email note?
Oh, no, I'm sorry. I just, I pulled up your notice of infraction. Let me see. There's an email in the file.
Yeah.
There's just 1 second, please.
Judge is like, I apologize. I was counting up how much money we made today. What were you saying? Thurston collects the bank. I mean, this is Thurston County. Cha-ching, cha-ching,
Okay.
cha-ching.
I understand. I can reduce this. There's one thing in that email I can do and one thing I can't from this position. The thing I can do is reduce the infraction. I can cut it in half to $14.
Okay.
Yeah.
And you cannot tell the city of Olympia to fix their parking meters so we can see how much we've paid for?
My role in this at this moment is just determining the infraction.
We'll tell them, ma'am.
I'm so mad at you. Thank you.
$14. Expensive parking. Fix your meters, City of Olympia. Fix your meters. Well, Thurston's all done. See if we have anybody else who's... Judge Simmons. Hang on, what's happening in Judge Simmons' courtroom?
I can't smell it, but she's kind of talking like.
Okay, this is call number 30017179441
Let's back up.
She didn't really look me in the eyes at all.
We're going to back up a little bit and try to see what's up with this hearing.
Really on the motion.
I have they reevaluate me every
OWI prelim. Okay, we're going to watch that.
You swear from the testimony you're going to give us
a vehicle accident.
Okay, we're just going to watch the body cam. Here we go. Roll tape. We're watching this just like an officer rolls up on the scene. We're just trying to see if we can pinpoint the violation, or if this is a roadside test. See if you can grade her for points. Points are bad. The eye jitter, that's going to be a point. The losing balance. Hey, hello, sir.
keep your computer muted.
Yeah.
That'll stop the feedback. But when you go to share, you can click share sound.
Judge Simmons knows how to run tech in her courtroom. She has a curved monitor, which I'm sort of jealous of, although I have a straight desk, so I'm not sure if the two would work together. I'd need a curved desk for a curved monitor. I'm thinking about getting a 4K monitor because I have a 4K switcher system. And I can't see the picture that comes out of it because the resolution's too high.
It should be on the side. It says shoes.
Just put it in the corner. I could, but it would block my view, like right there.
Are you on share screen? If you could bring your computer to me, I'll show you what to do.
Judge says I can fix it for you.
Go to share screen.
The first one's free, sir, but after this, you have to learn how to do it yourself. Share screen. Boom. Courtroom.
And then share sound is on the side.
Share sound.
Click that.
Click
and
that.
then you'll click whatever video you're trying to share.
Here we go. Watching some dash cam video. We're inside an ambulance right now. Let's see. I'm not sure exactly what's going on here, but watching it frame by frame. Maybe rewind a little, or we're 42 minutes 56 seconds into the video right now.
Is that playing? May click play.
Click play.
It's up on our screen.
We see it. Yeah. Just click play. Space. Oh, yeah. We've got a female officer. How can I tell? I just know things. Oh, wow. Okay. Looks like there was a fender bender. I'm calling it. A fender bender occurred. You can see 2 cars, both crashed out.
Okay, and for the record, I'm starting Officer Hyde's body-worn camera at 2 minutes and 50 seconds. Officer Hyde, do you recall this portion of your body? Well, is this does this accurately reflect your body-worn camera on November 9th, 2025?
Yes.
And what do we see here?
You can see the first vehicle when I arrived, which, and the other, it's hard to see in this, but there's 2 vehicles on the other side of that silver sedan.
That'll buff out, though. That's not too bad. Little polish and elbow grease. You're fine.
A few clips. I'm not going to play the entire thing. I'm going to omit the entire video. I'm going to play some clips and just have you describe it.
Okay.
Okay, over there. It was snowing. I can confirm it was snowing.
Share sound.
Share the sound. Can't hear a dang thing. Cop just parks right in the middle of the intersection. Makes a mess of everything for everyone. Directing traffic, forcing them to turn right. No left turn on this side. Ooh, there's... Maybe that white truck might be involved, or maybe as a witness. I can hear now. Oh. It's snowing still. Still don't have sound. Looks like a bit of a garage sale on car parts. There in the intersection. Got a few bumper stickers. We're rewinding for the dramatic effect. Officer says, I'm arriving. Gets out of the car. I'm not sure if we're going to get to see this. At least hear it. So let's point over there. Why don't we have sound?
My sound doesn't work when I play it on that. I play it at home. I don't know why.
I see one crock on and one crock off in this shot. The female driver looks visibly shaken up, but not otherwise harmed. The car appears to be full of items, or possibly something in the back seat came into the front seat. Little 4-door sedan. What was the make? Is this a Nissan? We've watched this part already, but we'll do it again. Felony case by Jessica Lane. Is that like...
Do you have any head pain or anything like that, sweetheart?
Yeah, there's a lot in that car. We were hearing that just fine. Sir, if you can just roll tape. That would be great. Now we can't hear it all. It was working before.
Left leg, chest pain, and a possible head injury. Can you copy a plate? David, X-ray David, 7341.
Calls on the
24,
plate.
can you copy a temp plate? Who is in this car? Okay. 9258 Robert 20. It's gonna be black in color. The first one I gave you is silver. Okay, are you injured at all?
I just think my ankle hurts a little bit, but I think I am fine. Bowie, do you hurt anywhere? No. I'm just upset, yeah.
Okay, give me just a second so I can check on them, okay?
Okay, at least 3 vehicles
Copy a
involved.
third. It's gonna be David, Mary, Victor, 733. It's gonna be teal. We're gonna need flatbeds for all of them.
Delta Mike
Okay,
Victor.
are you in this car?
I was on the driver.
Are you okay?
I have some minor bruising, and my passenger has some minor bruising, but I think we're fine.
Okay, but you guys are good?
Yeah.
Did you hit your heads or anything like that?
We had air flags deploy all the way around, so I think we're okay.
Okay. Was he in the car
Soft
with you, or was he
landing.
just...
No.
Were you in the other one?
I was just stopping by to make sure everybody was okay.
Okay. Did you see what happened?
I didn't see anything that happened. I
Okay.
just noticed that there was cars
Okay.
facing the wrong
All
way.
right. Thank you.
Then please leave.
Do you guys
leave
have
that.
your IDs on you?
I'm gonna pause the video at ordinance. Officer Hyde, does this accurately describe what
DMV.
you encountered on? Does this accurately depict the accident?
Which car do
as
you
you
think
saw
caused it?
on November 9th?
Yes.
And
Who do you think caused it?
back it up a little bit and ask you if you can identify a few people.
Her?
Do you remember who these individuals were here that you see on screen?
I don't remember their names, but I do know do recognize the lady in the shirt. It was right at the sweatshirt.
And okay. Do you remember who this individual is here?
In the pink plaid shirt is Miss Jessica Bai, standing next to her.
Oh.
And what vehicle was she driving?
The black SUV.
The one going the other direction. So the black SUV is at fault. The blue car and the other one with the lady in the Crocs.
Do you remember the names of these two individuals?
The short hair is Miss Cheryl. I don't recall the last name, and I don't recall the first name.
Yeah, we need to see skid marks, direction of travel, and maybe some
play this
intersection
portion
camera.
And then ask a question.
I do see a camera way up there.
Were you in this
top.
car?
I was on the driver.
Are you okay?
I have some minor bruising, and my passenger has some minor bruising, but I think we're fine.
Okay, but you guys are good?
Yeah.
Did you hit your heads or anything like that?
We had air flags deploy all the way around, so I think we're okay.
Okay. Was he in the car with you, or is he just...
No.
Were you in the other one?
Two of us. I was just stopping by to make sure everybody was okay.
Okay. Did you see what happened?
No, I didn't see anything that happened. I
Okay.
just noticed that there was cars facing the wrong way.
All right. Thank you. Do you guys have your IDs on you?
Dismissal.
You want me to go through here? Or?
No.
So
Do you want me to stay
this
here?
This individual here, she was just involved in that.
The Bass Pro Shops. The Bass Pro Shops kids.
That individual there, was she the driver of the blue car?
The female?
Yes.
That's it, yes.
That's Pink Coat. Pink Coat was the driver of the blue car, not Bass Pro Shop's kid. Oh, no, never mind. Not Pink Coat. The blue coat. Pink Coat was the driver of the black. Whoa, her car got a lot of damage. Can we hear this part? Yep, sounds on.
In my phone, but I didn't see where it went.
Okay, if you're
It's a felony. What's the felony? I'm not detecting DUI quite yet. It's still possible, but reckless. When it goes full screen, I guess we can't see anything. Ooh, fire truck, shiny. Cat dad. People getting checked out by the EMS. The broom has been delivered on scene. It's ready to do a little sweeping.
It's okay. No, we're gonna get you checked out.
Hi there. Were you able to find your ID?
Yes.
Okay.
She's tell you how fast she was going southbound.
Which one? No, I didn't talk to the silver car.
Okay.
I talked to blue car. Jones right there, the one that's walking this way, he talked to a silver car.
I think she might be a little bit intoxicated.
Oh, sorry. You're good to go. Miss Jessica, what's your phone number?
My phone number is
867-5309.
Okay. Can you kind of tell me what happened today?
I think that I was distracted. I was having a conversation with my kid and we were driving. I assume that I must have missed traffic coming.
Okay, which way were you going?
Across here.
Okay, so you were on Olds going across King?
Yes.
Okay, did you come to a stop at that stop sign?
Honestly, I feel insanely shooken up. I don't know. Like I just was driving regularly and then all of a sudden I was in an accident in my perspective.
Okay. Did you have your seatbelt on?
Yes.
Okay. And then where was she sitting at?
Bowie was in the passenger seat.
In the front seat?
Yes.
Okay, can you spell her first name for me?
Yeah, Bowie, B-O-W-I-E.
What's her middle name?
J-A-Y.
Last name?
Metz.
David Bowie. Like David Bowie.
What's her date of birth?
Date of birth is always February 29th, about 100 years ago.
Some of their paperwork hasn't, like, we have been working on a name change, so that some of their paperwork hasn't gone through, so they might be listed. Well, that is the legal name, but we haven't gotten it, okay, so, I believe it to be the legal name currently, but their birth name is Clementine Elise.
Okay, so we've got some name issues. There is some slurred speech.
Oh, were you wearing your seatbelt?
Yeah.
Yeah, okay. Do you have a phone number at all?
We do. I have it in my phone. I'm sorry. No, it's not your fault. I messed up. I don't know what I did. I don't even know. This is so confusing.
Miss Jessica, I just have to ask, okay, because I have to ask everybody, okay? Have you been drinking at all today?
I did go to, I did, oh, God.
24, does anyone have a PBT?
I did go to Cypher and had a drink there at a Long Island iced tea.
Long Island iced tea?
2 hours ago.
Okay, so 2 hours ago you had a Long Island iced tea?
Yeah, or I ordered one 2 hours ago.
Okay. Okay. Do you have a PBT?
can get him out. All right, we'll go to the game. Let's get you out of the cold for a little bit. How about that?
Thank you.
Watch your shoelace.
Did you get their phone number?
I did.
Okay.
Did you have anything else to drink?
No.
Okay. So you had one drink and it was a Long Island iced tea. It was about 2 hours ago?
Well, I ordered it 2 hours ago and over the course of 2 hours.
Okay, so you had one drink.
Just finished it.
Yeah.
Okay.
But stupid drink. Oh my god.
Okay. All right. Give me just a second. Why don't you get in that ambulance with Zoe, okay? Just that way you can warm up, all right?
Yeah, that's bad. She'll be over the limit. We'll wait for the attorney to figure out the tech. Oh, we're going to back up and do it again. We did hear slurred speech. It's the drink that has all the booze. Iced tea, is it 5 liquors in it? Long Island iced tea. Long Island lunch is commitment. It sounds like she was just finishing the drink when the accident happened, which is wild. Guesses on blood alcohol content 2.1. I'm going to go 1.6. I don't know. I don't know any drinks, so I have no idea based on her size. 2 points. A 0.16 is what I've got. 0.16. 0.19. Gin, vodka, tequila, light rum, and a splash of Coke. It's all alcohol. Whoa, man. That's a lot. That is each amount, is each like the vodka and the rum and the tequila and the gin, is that each like a drink size in and of itself, so it makes just a massive mug of alcohol? It was the first drink I ordered at the bar when I was 21. I think I can still taste it. And they let her drive after that? Really does taste like iced tea. Well, I guess that's why they call it that. Okay. Attorney is still wandering around the courtroom trying to figure out how to fix things. We might have to just jump to live. I don't know. Should we jump to live and see if they've resolved this one?
All right.
We're at live now, and he's still fighting this. Let me go back and see if they did the breath test yet. Oh, yeah, we've got to watch see how she does on the roadside sobriety test.
Testes.
This lawyer is absolutely the worst at running audio and video. I would dismiss this case with prejudice. Now we can't get it to play. Says, ma'am, can you step out here? We need to do a couple tests. Bring your coat.
All right. over here, okay, to this line.
Kicks the firefighters out.
Borrow this for a second. All right, just because
you told me you had a little bit to drink, we're going to do a couple tests to see if you were fit to drive today. This is a DUI accident, yes. Attorney is trying to get it to play. Oh, he's talking in court. We just don't get to hear. We're only hearing the audio from the computer.
told me that you have been drinking today, I do have to inform.
Just let it play, sir. Just let it play.
So what I'm going to do is I'm going to do what's called the HGN, okay? I have to ask you a few questions, okay? I'm starting SFSTs. What? Can you let them know? Okay. Okay, yeah. Okay.
Standard field sobriety test.
What's that mean?
SFSTs means...
No, I mean, why did you shake his head? Or something?
No, it were just...
Different thing.
Different thing. So... to ask you a few questions, okay?
Get your mouse off the screen, dude. This guy needs a media assistant in a bad way, Driftwood. Now he's just closing other tabs randomly. He does have Elton John, the YouTube video, pulled up. Interesting. I wonder, see the URL up there? I wonder if somebody could grab that URL and access this whole video. Oh, it is secure. Not sure if it would let you in or not. The thoughts, I think.
I have asthma. I have a thyroid condition. Scoliosis.
Okay. Do you have anything that would prevent you from walking normally, standing on one foot?
No.
Okay. Any issues with your eyes or anything like that? Cataracts? Glaucoma,
I mean,
anything?
I have astigmatism.
Don't do it. Don't do it. I just wondered out loud. You guys, we're going to have to bail on this one. It's just not. He pauses every 2 seconds, so.
I mean, I have astigmatism.
Follow the pen with just your eyes Start here in a couple seconds. See if she turns her head. It's going to be the
Your eyes and your eyes only, okay? Do you understand?
Yes.
All right.
There goes the head. Yeah, that's
All
1
right.
point.
Again, only with your eyes and your eyes only. Look at the tip of your pen, follow it, okay?
Little turn of the head.
I'm gonna have you turn this way so that way the flashing lights aren't in your eye, okay? All right, we're gonna try this again.
There goes the head
All
turn.
right, again, only with your eyes and your eyes only. Look at the tip of the pen.
There's the head turn again. The head turn again. I can't see the jitter.
All right, the next one that I'm gonna have you do is the one leg stand, okay? So what I want you to do is put both your feet together like this. Put your arms
Down at your side. Attorney's going to mess with the camera again because he can. We're going to skip ahead until she starts.
We do this, okay? All right, just stay in that position until I tell you to do something else, okay? So then what I'm going to have you do, when I tell you to,
Do you mind if I move on to like a more steady?
Yeah, no, you
That's
can
a
come over
point.
here. Let's go over here, like right here.
Sorry.
No, you're
Like
good.
split in the middle.
No, you're good, okay?
I'm sorry.
You keep your feet together, hands at your sides, okay? Don't begin until I tell you to, okay? So when I do, you're gonna put your foot up, either one that you choose. I'm gonna choose my right, okay? You're gonna lift it 6 inches off the ground. You're gonna point your toe, keep it parallel to the ground. You're gonna do 1, 1,000, 2, 1,000, 3, 1,000 until I tell you to stop, okay? Does that make sense?
Yep.
All right, give me just 1 second.
I predict 2 seconds before she falls. It takes a step.
All right, and then again, hands at your side just like this. Yep, perfect. All right, when I tell you to begin, I want you to begin, okay? 1, 2, 3, begin. Count out loud.
1, 1,000, 2, 1,000, 3, 1,000, 4, 1,000, 5, 1,000, 6, 1,000, 7, 1,000. How many do I
Keep
have?
going
8,
until I tell you to stop.
1,000, 9, 1,000, 10, 1,000, 11, 1,000. 12, 1,000, 13, 1,000, 14, 1,000, sorry.
Okay, keep going.
15, 1,000, 16, 1,000, 17, 1,000, 18, 1,000, 19, 1,000, 20, 1,000.
Okay, you can stop. Thank you. 30, 47. All right.
30, 47 to count to 20. So they timed her on that one. She wobbled. She used her hands to balance a little bit. And she didn't follow instructions because she didn't just keep counting until she was told. So there are 3 points there. I'm completely invested in this video. I can't pass these. I make a terrible roadside test subject.
The next one is called the walk and turn.
The walk and turn, or the pause and wait, as the case may be with this lawyer.
Line, okay? Go ahead and stand on this white line for me, just like this. Feet together, okay? Take your right foot, put it in front of your left foot. Heel to toe. Go ahead and do that right now.
Okay, right foot in front of left foot.
Heel to toe.
Sorry, this is my right hand. I have dyslexia.
All right, and then, nope, just...
That's 1 point.
Yep.
When she starts before she's supposed to, that's a point they count against you. Here we go.
Heel to toe like this. Hands at your sides. Stay like that until I tell you to stop, until I tell you to begin, okay? All right, so what I'm gonna have you do is I'm gonna have you take a series of 9 steps, heel to toe, and it's gonna look something like this, okay? 1, 2, 3, 4, so on until you get to 9, okay? When you get to your 9th step, you're gonna take a series of small turns, and you're gonna begin again.
I always fail
1,
this one.
2, 3, and so on, okay?
Okay, I'm sorry.
Do you have any questions?
Yeah, I walk 9 steps and then I do like a full circle and tiny steps.
Yep, you take a series of small steps and then you walk back another 9 steps.
Okay.
Okay, so again, it's going to be heel to toe like this. 1, 2, 3, 4, so on. And then when you get to your 9th step, you're going to take a series of small steps just like this. And you're going to do again. 1, 2,
Is she going to walk to 9 or is she
and so on.
going to turn on
Until you
4?
get to 9 steps, okay?
Sure.
All right, do you understand my instructions?
I believe so. I believe so.
All
I
right,
believe so.
go ahead.
Hands out at sides.
You're
That's
going
1
to have to count
point.
out loud.
Sorry, okay. 1, 2, 3,
sides.
6, 7, 8, 9. Then this is the series of small steps like this. So now I go backwards and do another 9. Okay. 1, 2, 3, 4, 5, 6, 7, 8, 9.
Okay. You got that? All right.
Now we have a special balloon we need to inflate. It's an invisible balloon. And you just need to blow in the straw until this imaginary balloon fills up. And I'll tell you when it's full up. That's what we're going to do here.
Miss Jessica, I'm going
to read the instructions, which are laminated for the instructions protection.
You're under arrest for driving while intoxicated. Go ahead and put your hands behind your back and release your fingers like you're praying, all right?
All right. They didn't tell us what the results were here. Perhaps when they're done with the video, they'll tell us. Judge, can you turn the audio back on? You can tell there's no audio, right, Judge? Jump to current. Okay, we're vested in this one, but we're just not getting the results we need.
Okay, thank you.
There we go.
It was muted. Just a moment.
I'm not a Zoom genius either, so
I have to give you permission to share your screen.
Okay, new attorney, defense attorney now. We do need a bus chase. 6-Volt, are you volunteering? Do you have a bus?
Okay, let's see.
6-Volt, you'd be impressed. I replaced
you know how to
a
share
GFI.
At the bottom of your Zoom, there's a share with the arrow pointing up in the middle of the Zoom.
Yep.
When you click that on the left, the right side, it'll say share sound. There's a box. You should, so you'll click that and then it should populate to whatever you want to share, but then it has to already be open for it to populate. And then you click it.
And include audio.
I hear.
It was shocking, right?
Oh, what is it? Oh my God, I'm hearing myself repeat.
It's not playing yet.
These are the victims.
It's my computer. What is going on with these computers today? Okay, this is what I'm going to do. Did that address it? Check, test. I think that.
So it's not.
You can hear it?
No,
I can't.
it's not just you.
Yeah, I turned my volume down, so whatever.
I know there's a way to do it, to mute the computer, but
Oh, mine's is mute. My computer was playing back here, so we can hear it appear. I think yours should be fine. You keep your computer muted so it doesn't echo or
that's
give
what
that
I'm trying.
piercing.
It won't play the audio if my computer's muted though. Don't know why.
Should go over the HDMI.
Mine's, no, I didn't mute mine. No, I just turned the computer on the actual
We've been
the
doing
computer
Zoom since
volume
2020.
down, but the Zoom I'm not muted.
2020. We've been doing Zoom. We need to know how to do these things.
There's supposed to be sound on this.
Yeah, I'm muted. So.
Did you share sound? because I don't think the judge told you to share sound. This is the same accident. We've got a blue car, a black car, and a gray car involved. 3 cars.
24, we're going to need an additional medic. I do have another female here with possible.
Same issue, but we'll make it work.
Play.
Yeah, let me see what's going on here. Participants.
Yeah, I'm muted.
Yeah, he's muted in Zoom. I don't know why it's doing that.
Are you still in?
No, I'm out.
No, he is there, but he's muted.
This is 2026.
We'll make it work.
Okay.
Which means it's going to be awful audio. Just play it all the way through for us, and then we'll bail.
Okay. Good afternoon.
Remember in the beginning,
Where'd you get
when we
married?
started 110 years ago?
We gotta get a new last name.
I'm gonna hide there.
Oh, okay, good, 'cause so I can know when social much comes to who you are.
Okay. Mr. Smith went through some of these, so we're gonna get caught up. Are you familiar with the field sobriety student manual that I'm holding? Okay. I'm assuming you use this as part of your training and certification. Okay. So we
have
might
to
be
bail.
referring to that. I just wanted to.
We have to bail. We have
established that everybody knew what it is, and you.
And so that matter will be dismissed.
We have small claims in Thurston County.
Thank you, Your Honor.
We have small claims
You're
in Thurston
welcome.
County. You can't. The echo was too bad, guys.
May I disconnect?
Yes, absolutely.
Thurston County small claims. This is our best bet of having a foliage Friday case.
Chase.
Something about trees.
All right. And then my next one-party case is Puya Alenehad versus Hearthstone Tumwater.
Yes, Your Honor.
All right. And I do not see Hearthstone Tumwater present.
So you win by default.
Okay. And what I'm looking for, sir, is if there's proof that the other party has been served. And I have a certificate of service here. Service by mail.
Okay, we're going to fast forward this one. There's no opponent. We've got to get caught up.
All right, sir, is the only proof of service you have this return? Oh, I'm sorry. I'm finding it now. Just a second here. Okay, this return receipt does not contain the signature of the party served. Not sure who this person is or how they're potentially affiliated with the corporate defendant.
Okay, we're going to skip forward then.
So, sir, do you have any other evidence of service of your lawsuit on Hearthstone Tumwater?
No, it's only the return receipt that signed by Claire Matheson, and she declared that she's an agent. Like she's authorized to get the mail on behalf of Ronald Nimi, the registered agent.
Okay. All right. I can't issue a default judgment based on that service, so I will give you the option of resetting this.
Yeah, it's going to reset.
Okay. And then next is Warren Yeck.
Warren, you're up.
There we go. And again, calling last call for Timmy and Smith. Okay. And there's no response.
I'm covering Jarvis down here, if that's all right.
Okay, number 39507. And there is, that's the notice.
Okay, this one also.
Here we go.
Not showing up.
$, and then your service fee.
He's going to award the whole thing to him.
It's number 2 on the calendar.
Okay.
As well as number 6.
2 and 6. Oh. And let me take up a second. I've got to open up my display again. I think I'm going to start with 39503, which is Jarvis versus Adams. And let's see, I see defendant Adams is here. I see plaintiff Jarvis is here. Now, there's something about this case that I want to address up front, and Ms. Jarvis, I'm going to ask you about it. Your claim is for $591.17, and the basis of the claim is assessments by Homeowners Association for electrical repairs. Is that right? Oh, you're on mute.
Yes, that's right, Your Honor.
Okay, thank you. And then the defendant in the case is identified as Carolyn Adams, and Carolyn Adams is an individual and not a homeowners association, and may be I don't know if she's a board member or something, but it strikes me that, and again, I'm looking to you to answer this question for me. It strikes me that Ms. Adams may be the improper defendant in this case.
Ms. Adams is the HOA manager, and she represents our HOA association.
Mm-hmm. Okay, but your homeowners association is an entity, correct? A business entity or a condominium association?
It's a condominium association.
Okay, so
you need to sue them.
Ms. Adams is not the condominium association. She's an officer, and ordinarily, and again, unless you explain to me a legal reason that this is incorrect, ordinarily you can't file a lawsuit against an individual when the action they are taking is on behalf of a corporation or an organization.
Can I move to amend this?
No, but you can file a correct lawsuit and serve the correct party.
Okay. So if Carolyn is the representative for the HOA association as an entity, who would be the correct party?
Well, based on everything that you filed here, it looks to me like the party you want to sue is the homeowners association, and that you can do that. I mean, that's certainly an appropriate lawsuit to file, but Miss Adams is not the homeowners association. And so you would need to, file against them in the correct way. And I don't have the ability to give you legal advice on how to accomplish that, but that's something that you can do. And that may be something within the jurisdiction of the court. Again, I'm going to leave that to you. But if Miss Adams is just somebody who acts on behalf of a corporate entity, she does not bear legal responsibility, and you can't collect a judgment from her. Right? There's an organization that you believe did something that causes liability that you're owed that money for. It's the difference between suing Microsoft and suing Bill Gates.
Yep. Good example. But Bill Gates is dead, and Miss Adams looks to be alive.
I'm not hearing anything to counter that, and so I'm going to dismiss this claim without prejudice. Ms. Jarvis, what that means is there's no harm in this. It doesn't preclude your ability to file against the correct party and pursue your case that way.
Okay, thank you, Your Honor.
Normally these civil cases are great. Oh wait, I was thinking I just killed off Bill Gates. I was thinking the Apple dude instead. Tim Cook? Steve Jobs. Steve Jobs, that's the guy. I gave Steve Jobs all my money.
Number 2 is case 39496, and that's Elizabeth Duenas versus Karen Landsberg.
Keep killing people off before their time. I apologize.
And I want to make sure, as I always do, that I'm pronouncing people's names correctly. And Miss Duenas, am I pronouncing your name correctly?
No.
It's okay. It's Dueñas, but that's perfectly acceptable.
Dueñas.
Thank you.
All right. I'm fully capable of pronouncing your name correctly, and I will make sure I do so. So it's Dueñas.
Yes, thank you.
Okay.
And Your Honor, my name is Karen.
Karen, okay. And I'll be addressing you as Ms. Landsberg. So.
Okay, that works as well.
Okay. Very well. All right. So I will get the case file open for you and identifying the claim here. This is Ms. Dueñas's claim for $1,500.
Please be
and it looks like this is based on a rental deposit. Okay. We're going to get started with that. All right. I'll sort of lay out some expectations and ground rules for you. So the way this will work is I will swear the parties in, and I'll hear from the plaintiff first, and in this case it's Ms. Duenas, and then the defendant second, Ms. Landsberg. You have the opportunity to present your case, and during the time that the other party is presenting their case or their defense, I'll ask you to not, interrupt them or do anything to stop them from doing that. Just keep in mind that you either are going to get a chance to present your side of the case in a few minutes, or you've already presented your side of the case, so I already know that. Address your comments to me, to the court, not to the other party or to anybody else. And I will hear your case by the testimony that you give, the exhibits and evidence that you've submitted to the court, which should already be submitted. And if you have witnesses and I need to hear their testimony, I'll swear them in, and that will also be part of your case. After I've heard from each side, I will make a decision, and then I will tell you the basis for the decision so that you know that I'm following the law. I will probably have to ask you questions from time to time, so I may just kind of jump in and interrupt you and ask questions. I'm doing that to clarify so that I make sure I understand the nature of your claim or the nature of your defense, or to orient myself to any exhibit that you may be referring to, just so that I'm tracking what you're saying and keeping the case maybe focused on the facts and issues that are going to help to resolve it, as opposed to other facts that may not be leading us in that direction. And then I'll announce my decision for you. So we'll get started here on that. Can I have both of you raise your right hands, please? And do you each swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right, Ms. Duenas, go ahead, please.
All right. So I rented Miss Lansford's unit between December 21st and 2024 and May 3rd, 2025. And when we moved in, we didn't do an inspection. And so she sent over via email a written checklist, but we never actually did the inspection. We didn't write down the condition of the unit. And I never signed a checklist. However, she still collected a deposit of $1,500 from me without the signed checklist. And so my concern here was that this does not follow RCW 59-18-26-0 that specifies that a written checklist signed by myself and Ms. Landsberg needed to be documented in order for her to collect the deposit. Our lease also shows that an inspection was required. It specified that the landlord and the tenant would be completing this inspection. However, we never did so. I moved in on the evening of December 21st, and Ms. Landsberg left on December 22nd and was gone through January 4th. You can see this in her house notes, which are Exhibit O. So right away, no inspection. She left, still collected the money from me. Later on, after I had moved out, she wrote to me that she would not be returning my deposit. And this, I realized, was not in compliance with the law. So I sent her a letter detailing why I should be receiving my deposit back. She responded with an email. I then sent her a follow-up email and then another email letting her know why I needed my deposit and letting her know that I would be opening a small claims court claim if my deposit was not returned. So there was a request already placed for my deposit to be returned before we came to court.
Did she return any portion of it?
Nothing. Okay. And then in her email, she let me know that she alleges that I had caused damage to her floors. She charged me, I think, for a shovel, for all sorts of miscellaneous things. I think she charged me for oats.
Oats?
In her initial email, not in this claim, but in the initial email, she wanted to charge me for some oats that had spilled on her floor. And yeah, so overall, that's where I'm coming from. That is my claim, that we did not fill out a rent checklist. She did not reach out to make the time to go through and inspect the unit. There is no documentation of the status of the unit, of the specific condition of the unit.
Let me kind of stop you there for a second, because that issue that you raised may be dispositive of the case. And it looks like your claim is only based on that amount.
Yes, my claim is only based on that amount.
So the only amount you're requesting is the deposit, and the basis that you're saying the deposit should be returned is that there was non-compliance with the requirement for the move-in checklist.
Correct.
Okay, I may return to you, but I'm going to stop there because typically a thing like this can be dispositive of a case. I don't know if it is.
We have to pause just for a minute because we have a phone call.
Okay.
Kayla, welcome.
Yes.
How are you doing?
Thank you. I'm okay. It's a privilege for having me on again. Thank you.
What are you doing?
Well, right now I'm on my couch, but The boyfriend has secured a cement goose. He drove all the way to Michigan to get this.
If he doesn't
from Indiana,
if he doesn't deliver it and say Happy Mother's Day, I don't know what.
Well, he won't be back till Sunday.
That's Mother's
Day.
Perfect. It's going to be it's your Mother's Day present.
That's exactly what I wanted.
It's awesome. I only bring this up because the poll is still open on Facebook, and not enough people voted for Greeners. So if you can,
Guy,
I'm not trying to sway this one way or another, but
Greeners, the gander goose.
Yeah. Jump over on Facebook and vote in the poll. You'll find it if you dig around a little bit. There's the link.
And then I will paint it, and I will make a placard, and then I will reveal it.
Yeah. Okay.
That's all I wanted.
That's all. We're going to jump back to court now. Thank you, Kayla. I appreciate it.
You're welcome.
Right.
Bye.
But I'll find out. I'm going to give Ms. Landsberg an opportunity to talk about that issue.
I want to find out about the spill notes.
I may be able to make a decision in the case just based on that. So, Ms. Landsberg, why don't we just zero in on the issue of this move-in checklist? She claims that there was not one, and that may be dispositive. So can you tell me your version of that?
Could I ask for a definition? I'm not familiar with the term dispositive. I'm not a legal. We've never worked in a legal environment.
Sorry. That may be the single issue that decides the entire case.
Okay. Thank you. Yeah,
that just keeps the focus down on one thing.
Yeah. So I would like to point out that I filed a counterclaim as well. So that should be in all your materials. I submitted a number of exhibits that should be uploaded. Your Honor, I
just a second here. I need to open your counterclaim. All right, Here we go. Oh, yeah. Okay. So it was filed just last week, it looks like.
I received.
Did you know that, Ms. Duenas? Did you have this counterclaim?
Yes, I received it on May 5th.
Okay, I've got it here.
Yeah, Your Honor, I received notice of this case on April 28th. And so it took me about 2 days to get my materials together and file things with the court, and then submit materials to submit the counterclaim or send that to Ms. Duenas.
I got it. I see that there's the counterclaim file.
Yeah.
It's like some things kind of got put in the file late, so I didn't see them. And it looks like this was put in the file last Friday. And there are a couple things that were put in the file yesterday, which I also haven't seen. So.
That is the return receipt from my certified letter to her, serving her the notice of the counterclaim. It came in yesterday.
So, then if the reason I'm bringing this up in this way is that even if the issue of the move-in inspection were to be determined in favor of Ms. Duenas, that would then preclude the deposit from being retained on that basis. But it does not preclude the defendant, in this case Ms. Landsberg, from filing her own counterclaim based on damages. Okay, so that and I know those sorts of things can get confusing in a hurry. So Ms. Duenas, do you understand what I mean by that?
Yes.
Okay, good. So that means that we would then have to go into the issue of whether there was damage to the unit above and beyond, wear and tear, that sort of thing. So, Ms. Duenas, are you prepared to deal with this counterclaim? Did you get notice of it in time to deal with it?
Yes.
Okay. All right. Well, then, Ms. Landsberg, unless you have anything else to say on the issue of this move-in inspection, I think that we can determine that right away and move into this counterclaim issue.
I guess I would like to make a statement on that. I did include a form with the lease that they could fill out. I approach this as a little bit of a less formal rental situation. I'm not I mean, I do have an ADU, but this is not something I do professionally. I was renting out my home during the legislative session, and I was also unaware that it was a legal.
During the legislative session?
I guess my understanding is there was a change in the law in 2023 requiring the checklist. I was unaware of that change. And I was doing my best to act in good faith on this. The checklist was provided there. Ms. Duenas and her co-tenant had the opportunity to fill it out, take pictures, whatever they wanted to do as well. So.
Okay. All right. The burden of the compliance with that section of the landlord-tenant law can't be shifted in that way. So right away, I can determine that the deposit was not properly withheld because there was a failure to comply with the requirement for the move-in checklist. That's just simply not been complied with. So that part, the claim, the initial claim, Ms. Duenas, is going to be determined in your favor for that $1,500, but that doesn't determine the counterclaim, of course. That's a separate issue that has to be determined. Let me ask the both of you, though, before I proceed with that, if the determination of the initial substantive claim creates an opportunity for the two of you to resolve the entire claim, counterclaim included.
I think she's DOT.
The mediators are still here if you want to go back into the room and see if you can't hammer this out.
I think we've come to an impasse, Your Honor.
Okay. All right. Fair enough. I just wanted to give you an opportunity to do it if the hang up had to do with the compliance with that move in. Okay, then let's move on to the counterclaim. And Ms. Landsberg, go ahead. You can present that, and then Ms. Duenas, I'll give you an opportunity to respond to it, okay?
Thank you. Thank you, Your Honor. So my counterclaim is about the 2 floors that were damaged during the tenancy, and at the documented cost of $5,253.89 to replace those and the associated costs.
And the oats.
When the tenants vacated, I found that the bathroom floor had swollen and separated at the seams, consistent with sustained water exposure. The most significant damage was in front of the center of the bathtub, and that was something beyond normal shower splash. I had let them know that sometimes I got some shower splash at the end of the curtain, but this was water damage in a different area. In the laundry room, the marmoleum flooring failed at a seam. It was lifting up and creating a tripping hazard. During their tenancy, the co-tenant showed both damaged areas to me directly, explained that there was a detergent spill in the laundry room that caused the damage, and presumed that water caused the damage in the bathroom. I documented those admissions in my letter to them on May 23rd, and that's in Exhibit F. And the damage has never been disputed by either tenant to me in their communications since then. I've lived in this house for 9 years without causing similar levels of damage. There are a number of pictures there in Exhibit M showing the floors before and after their tenancy. You can see the same distinctive cork pattern in the bathroom floors. So there's bathroom pictures from 2021 and October of 2024. There are laundry room photos from 2022 and 23 that show the marmoleum intact. Amy Robinson cleaned the property on December 20th, the day before the tenants moved in, and again on December 5th, 2 days after they left. December 21st and then, or 20th and May 5th. And she provided a letter, which is my Exhibit L, and she described her observations of the house before and after the tenancy, including the conditions of the floors. I've also provided some photos showing the general condition of the premises after the move out, just showing the general level of care exercised during tenancy. Abbey Capital Floors and Interiors explained that the laundry room floor could not be repaired because the detergent that caused the flooring to come up would prevent it from adhering properly if it were re-glued, and so the floor had to be fully replaced. The work was completed in December 2025. The paid invoice is Exhibit J, and that totals $4,373.14 for both floors. I had to have a plumber reinstall the bathroom sink and the hot water heater after the flooring work. His invoice is Exhibit K, and that's $766.16. All of my costs together were $5,253.89. Subtracting the deposit for that, my counterclaim was for $3,753.89. And so, in addition to the RCW for the checklist, there's also an RCW 59-18-130 that requires the tenants to not negligently damage the premises. And finally, I notified the tenants promptly that I was retaining their deposit. I've offered to discuss the matter multiple times, sent a detailed certified letter. I've submitted the dispute to the Dispute Resolution Center last spring. They confirmed that they reached out to both tenants to no response, and that's in Exhibit H. I feel like I've really reached out to try to have a conversation about this, and at every turn been told, no, I have to return the deposit. I have to return the deposit. They've not denied the damage that was done, and so I ask that you find in my favor for
$3,000, whatever.
I guess the $5,253.89, disregarding the deposit issue.
All right, Ms. Duenas, can I hear your response to the counterclaim for the damage?
Yes. So to begin, I would respectfully ask that the court not give weight to Exhibit L, which is Ms. Robinson's letter. Ms. Robinson's letter is not addressed to the court. It also does not include a statement signed under penalty of perjury. The statement is possibly biased because she is employed by Ms. Landsberg. She does their cleaning, and they have an ongoing relationship, which makes her partial to be supporting Ms. Landsberg's claims. So I would like to say that to begin. And then I would like to state that neither I nor the other tenant caused the damage to the laundry room flooring or the bathroom floor. This damage could have easily been caused by the pre-existing humidity levels that were very high within Ms. Landsberg's home, or it could have been caused by Ms. Landsberg herself. If you will look at Exhibit O, which are her house notes, Ms. Landberg writes, "For some reason, I sometimes get pool of water outside the tub when I take a shower. I haven't figured out exactly what I'm doing to cause it." So there, you're able to see that she is also getting water on her bathroom flooring frequently, and has not figured out how to stop it. Then in her house notes, she also shows that there are pre-existing high humidity levels. She writes, "A few years ago, I had some mold issues due to inadequate attic ventilation."
I hit her.
She also instructed us to use a dehumidifier, which we did. Followed all of her instructions. And she shares, "I currently have it set to dehumidify at 35%, but it is only sensing the air around the device. It has been reading lower than other parts of the house." So in both of these statements, we are able to see that there are pre-existing high humidity levels. There has been humidity issues within the home. And she has also been getting water herself on her bathroom flooring, which could have caused the swelling that she says she sees in her home on the floors. She did submit some images. However, I'm concerned by these images because they weren't taken directly before I moved in. The image in Exhibit M8 was taken in June of 2023. I moved in December 21st of 2024. This is many months after that image was taken. So in that time period, between when that image was taken and when I moved in, that damage could have occurred or could have started to occur. Image M5 is unclear and it's too far to see the floor in detail. And finally, the other images, which are images M1, M2, M3, and M4, were taken in March of 2021. This is 3 years before I moved in. These images do not document the condition of the home before I moved in. What would have documented the condition of the home is a written checklist signed by myself and Ms. Landsberg, which is absent because she did not schedule an inspection properly.
I think the tenant might win this one.
So that's really, overall, I don't believe that there is enough evidence to really prove that I or the other tenant caused the damage to the flooring.
All right. Thank you, Ms. Duenas. All right. I understand the nature of the claim and the nature of the defense. So I've already resolved the issue in the primary claim.
Your Honor,
and
could I provide a little bit more information?
No, you provided your case. She provided her case. It's just like I explained in the beginning.
Okay.
Thank you. That's how this goes.
Yep, just sit back and lose.
So I decided the primary claim filed by Ms. Duenas as plaintiff and the award is $1,500, which is the amount of the deposit because it was not collected in compliance with the statute requiring the move-in checklist. Then any potential offset to that, I'm going to move on to the counterclaim filed by Ms. Landsberg for the damage to the floor, claiming that the floor was damaged due to water and other material on the floor that caused it to, it's like come up or buckle up and require repairs. So in this case, I would have to find sufficient evidence to be convinced by a preponderance of the evidence that the damage to the floor was caused by Ms. Duenas or her co-tenant. And in this case, I don't have sufficient evidence to determine that by a preponderance of the evidence. There are some pictures and those are not, they definitely show the floor, but they're in and of themselves not persuasive to the level of preponderance of the evidence to show that the floor was not damaged prior to the time Ms. Duenas took possession of the property in December of 2024, or the mechanism of the damage being consistent with the allegation that there was water and or a detergent on the floor to cause the floor to buckle. It's actually not at all proved to that level of satisfaction, the mechanism of the damage to the floor. I don't know how old these floors are. I don't know what the characteristics of these floors are. I don't know if floors like this are subject to damage in the way that Ms. Landsberg claims that they were. All I see is how much it costs to repair them. So I'm going to enter judgment in favor of Ms. Duenas for the $1,500 on the deposit claim, plus her filing fee, which was $50. I don't know how much your service fee was, Ms. Duenas. Can you tell me how much it costs to have the notice served on Ms. Landsberg?
$35.
Yes, it was $11.07.
$11.07. Okay. And on the counterclaim, I'm finding in favor of Ms. Duenas, the plaintiff counterclaim defendant, and there would be no offset to that award. So the total amount of the award in Ms. Duenas's favor is $1,561.07.
Karen is not happy. Karine. I was it.
Okay, that'll be the judgment of the court. That'll be filed by the court clerk and available to both of you later today.
Thank you.
Good luck getting your money,
Right,
ma'am.
thank you both. All right, do we have any update on 4 and 5?
Yes, we do. So case number 5 on our calendar, they did reach a DRC agreement.
Mm-hmm.
Number 4 is still in mediation.
Okay.
It sounds like they're pretty close to reaching a resolution.
Okay. And did we ever get any parties for United Finance versus Lopez, number 3?
No.
All right, then that claim will be dismissed because neither party is present.
Anybody else here, Judge?
No. So that just leaves number 4, and we'll.
Judge says no. Got some news. Sorry, I was just texting there. Sad news. Podcast is not a go tonight. Thomas, the thing that he had going today got extended, and he's not going to make it back in time. He was pushing it already, and we knew this because he was trying to get home like 5 minutes before the podcast started, and he said, "I'm going to try. I'm really going to." And he just texted me and said, "It's not going to happen. I just can't get there." So. Sadly, no podcast tonight. It's sad news. It's sad news, right? Anyway, would you be surprised to know that they're still trying to show the same video in that other court? I'm sorry. They're still struggling with the same video. Let's see if we got anything else for today.
You operating a motor vehicle, sir?
Yes.
And at that time, had your driver's license been suspended or revoked by the Secretary of State?
Yes.
All right, Jim, give me a factual basis to accept your plea. I will do so. We'll impose fines and costs here. The fine is going to be $200, state costs of $50. Statutory cost of $250, crime victims' rights fee of $75, and there is
crime victims' rights fee.
It appears.
Whoa! Who's the crime victim right fee going to when he drove without a license? Who's the victim?
That's a total of $725. I'm going to give you 90 days to pay that, but if you need additional time, you can just call the court clerk and set up a payment plan, and they'll help you set something up monthly that you can afford. Otherwise, sir, you're all set for today. You may leave the courtroom. Thank you.
Thank you.
In your orange Crocs. Well, there's. I'll see your orange Crocs and raise you an orange jumpsuit. There we go.
Good afternoon. What is your name?
Anthony out.
This is case number 261180ST. Counsel?
Thank you. Elizabeth Peterson on behalf of Mr. Ott for the limited purpose of arraignment. We did have an opportunity to review the complaint and would waive a formal reading of that today. I'd ask the court to enter a not guilty plea on his behalf and set the matter for a pretrial. He was evaluated for a court-appointed attorney and does qualify. We are asking for a PR bond in this matter.
And Ms. Peterson, if this is set for trial, would you want that to be a jury trial or a bench trial?
Jury trial, please.
All right, sir, you have been granted a court-appointed attorney. That person will be your attorney for the remainder of this case. Doesn't look like a bond has been set in this case yet. So I will go ahead and set one at $300 personal cognizances. And one of the conditions of your bond is going to be no driving unless you obtain a valid driver's license. Do you understand that, sir?
Yes, ma'am.
Great. Your attorney has provided us with an address of 418 Garfield Street, apartment 104 at Otsego. Is that still a good address for you?
Yes, ma'am.
All right, information regarding your upcoming hearings will be sent to you at that address and also to the public defender, so be sure to stay in contact with them. You're all set for today, sir.
Thank you.
Thank you. Good afternoon. What is your name?
Bradley Snyder.
This is case number 261389FT. Counsel?
Thank you. Elizabeth Peterson appearing on behalf of Mr. Snyder for the limited purpose of arraignment here today. Did have an opportunity to review the complaint and penalties with Mr. Snyder. We would waive a formal reading of that today. We're asking that the court enter a not guilty plea on his behalf and set the matter for probable cause conference and preliminary examination. He was screened for an attorney and qualifies. With regards to bond in this matter, there is not an amount he can post at this time as he is currently unemployed. However, he does live locally, has never failed to appear, and the only prior offense he has, he was successfully discharged from probation, and he's established that he can follow court orders and follow through. So we're asking that the court consider a PR bond in this matter.
I do have some concerns given the nature of the charge, trying to flee from the police, going 76 miles per hour in a 25 mile per hour zone. But given the lack of the defendant's history, the fact that this isn't an assaultive crime and that you do have a local address, I will go ahead and amend this to PR bond. It's currently set at $1,500 cash surety. I'll amend that to $1,500 PR. Your attorney has provided us with an address of 2719 Nelson Lane in Allegan. Is that still a good address for you?
Yes.
All right, information regarding your upcoming hearings will be sent to that address and also to the public defender, so be sure to keep in contact with them. You're all set for today, sir. Good afternoon at the jail. What is your name?
Zachary Stetson.
This is case number 253799FY. Counsel?
Thank you, Your Honor. With regards to this file, I did have an opportunity to review the matter with Mr. Stetson. I'm appearing on behalf of him today for the limited purpose of arraignment. He does understand the complaint as well as the possible penalties, and we'd waive a formal reading of that today. I'd also ask that the court enter a not guilty plea on his behalf and set the matter for probable cause conference and preliminary examination. He was screened for an attorney and qualifies. It's my understanding that he does have some family members in the area and needs to make a few phone calls with regards to bond. However, he's never failed to appear for court previously. These appear to be allegations from 2017. He does have a place to stay in the Grand Haven area. It would not be leaving the state, and he doesn't have any violent history that I'm aware of. So I would ask that the court consider a lower bond in this matter.
56 over? It's crazy. The thinker pose doesn't do much for the case here, sir.
Given the nature of the charge and the victim being of the age that the victim was, I'm not inclined to do a PR bond, but I will lower bonds. I'll do a $2,500 cash surety. I am going to put a condition on your bond, though, if you are able to post it, no unsupervised contact with anyone under the age of 18.
Sounds fair.
All right. And sir, I don't remember if I told you, but you haven't granted a court-appointed attorney. That person will be your attorney for the remainder of this case. And do you have an email address or anywhere that we can send your notices of hearing?
Yeah, my
father, his phone number or email.
Okay, can you tell us that email address? Or do you not have it yet?
I don't have it yet.
Okay.
I'll get it.
Okay, once you make those phone calls, please relay that information to your attorney so your attorney can relay that information to the court so that we can make sure that you get your notices of hearing. But all of that will also be sent to the public defender's office since you're being represented by them. So they'll have a copy of it as well. So be sure to keep in contact with them. But you're all set for your arraignment today, sir.
Thank you.
Thank you.
It's a lot of people here.
Ms. Peterson, the other two females are here now too, so I don't know if you want to call them for their interview or just go into a breakout room or whatever you guys decide.
What's easiest for the court? Are those the only ones left?
We can just log off. We can just like basically put you guys both back in the waiting room, have you guys make the phone call so we can't hear it, and then just let us know when you're ready and we can come back.
All right, we'll do.
Okay, thanks.
All right. They're going to log off for a second. Just going to watch the judge. She does her thing.
I don't know what to expect, how long it's going to take.
Well, it's going to take however long it's going to take, Judge. Got a state pretrial going on up in Thurston. See what else they have. Small claims court is over. Sadly, no trees. Miss R.A. my wife is buying a car from a lady, and that lady is in the middle of a divorce. And the car is shared property. And the husband, who my wife does not have any fond words for, is a lawyer. And so she's like, they agreed on a price. She talked him down to a price that we like, which is great. And my wife's like, okay, I've got the paperwork here. Let's go ahead and do it. He's like, you can't just buy a car the same day. And she's like, yeah, you can. I sold mine one day. It's no problem. I just did this. And he's like, no, you've got to have it noted. She's like, yeah, and here's how to do it. And she goes through and says, here's how to run it. He's like, no, we need another statement that shows that we have no implied warranty on this sale. She's like, fine, I'll sign. And he's like, and I'd need you to be there for the notary. And she's like, fine. We can do this. This is fine. And the guy's like, what's her big hurry? Why does she need the car today? And she's like, because we have cash and money talks. Now get your butt down to the bank and sign the paperwork. Anyway, so that's what we're doing right now. That's what she's doing. She called me for that. All right. Meanwhile, I was showing you some cool gaming videos, which are fun, but not court. Let's watch Caddyshack. Was that on there? I think that was up. She's like, give me the keys. Yeah. In North Carolina, they have screwed up laws. Let me just say, North Carolina makes things difficult that don't need to be difficult. And car buying is one of them. First of all, if you drive to North Carolina and you're coming through on vacation, you see a car on the side of the road, he's like, that's my dream car. I've always wanted it since I was a kid. It's for sale. It's for like $5. I have the $5 on me right now. The owner's like, I've got the title right here in hand. No, you can't buy it. I'm sorry. First, you have to move to North Carolina and become a resident. Why? I have no clue. But you have to be a resident to buy a car. Probably for tax purposes. But anyway. Yeah, that's just the beginning. And then there's all the paperwork and the signatures, and you've got the extra odometer disclosures and damage waivers and everything. It's a pain in the butt. I moved people to North Carolina. It's so annoying for expats who just arrive and you pretty much need a vehicle. Yeah, you're forced to get a rental. I'm sure it's a law that was made by the rental companies. You just have to rent a car for a month or whatever it takes to become a resident. I talked my way around it, but it still took like 33 signatures in 3 hours to buy a car with cash when I moved here. But Georgia is better to buy a car. I'm banned from the state of Georgia. I can't do that. Also, North Carolina does not win in the books when it comes to police body cam footage and dash cam footage. Good luck getting that.
From the state of Georgia.
Good luck getting that. The only people who are allowed to see that, other than the police, who can see it whenever they want, are victims or defendants in a case where that evidence is going to be used against them. They're allowed to view it at the police station, but not get a copy. And as far as a FOIA requests, no, they don't do that. Bill Gates is definitely not dead. Thank you for that. He'll probably take offense to that, and he's never going to sponsor the channel now. North Carolina sucks in teacher pay too. They're not the best. We just had a big, huge rally. The teachers went to the state capitol and rallied for better pay. It's not a strike. It's not a walkout. But all the teachers called in sick, and the school district said, we're going to give you a teacher preparation day so you can go protest. Ricky C. gifted 5 memberships. Ricky, thank you very much. Appreciate that. Massachusetts doesn't even wear body cams. It's all right. It's all relevant. But the big news this afternoon is that we don't have a podcast this afternoon, unfortunately. Let's see. Do we have some more court? Not that one. How about 6? That one? Nobody's there. Let's try the other courts. Simmons is still going on. Who's this guy? Let's try this guy.
In exchange for your guilty plea to 1 count of assault in the 4th degree, appears the prosecutor is going to recommend a 12-month suspended sentence, 364 days in custody, 351 days suspended, credit for 13 days that you've already served, that the $5,000 fine be suspended. Conditions of suspended sentence that the prosecution has indicated they're going to recommend is that you complete 8 hours of anger management counseling.
Yeah, that should be good.
And that you have law-abiding behavior.
That means
it's 4 hours of anger management counseling, not 8. And that you have law-abiding behavior. Mr. Buffington, is that your understanding of what the prosecution has agreed to recommend as a sentence?
Why does this prosecutor look like he has a hairband?
And sir, you understand that is only a recommendation. The court is not required to follow it.
Like a rock
court can impose up to 364 days in jail and up to a $5,000 fine.
Yes, sir.
Mr. Buffington, have you discussed with Ms. Arnold that if you're not a citizen of the United States, this guilty plea could have negative immigration consequences?
Yes, Your Honor.
Paragraph 11 of this document asks you to state in your own words what it is you did that makes you guilty of the crime of assault in the 4th degree. That statement reads as follows. On January 16th, 2026 in Lakewood, Washington, I did make harmful or offensive contact with another, Alan Harrington. Mr. Buffington, is that a true and correct statement of what you did in this case that makes you guilty of the crime of assault in the 4th degree?
Yes, sir.
Mr. Buffington, did you read this guilty plea form yourself? Did Ms. Arnold read it to you or both?
She read it to me, Your Honor.
Okay. Did she answer all of your questions regarding the contents of this document?
Yes, sir.
Mr. Buffington, finally, sir, has anyone threatened you in any way or made any promises to you that have left you in a position where you feel like you are being forced to enter this guilty plea here this morning?
No, Your Honor.
Okay, you feel like you're doing this of your own free will?
Yes, Your Honor.
Okay. Mr. Buffington, for the charge of assault in the 4th degree as charged in count 1 of the criminal complaint in this case, at this time, sir, how do you plead? Guilty or not guilty?
Guilty, Your Honor.
Court is going to accept Mr. Buffington's plea of guilty at this time. The court is satisfied that based upon the record that Ms. Arnold has made, as well as the court's conversation with Mr. Buffington this morning, that he is entering his plea of guilty to the charge of assault in the 4th degree, knowingly, intelligently, and voluntarily, after having had an opportunity to consult with his attorney. It does appear to the court that Mr. Buffington understands the charge of assault in the 4th degree, the elements of that crime, potential consequences of his plea. He has provided a factual basis to support his guilty plea, and the court will enter a finding of guilt at this time. Pursuant to the pretrial negotiations of the parties, the court is going to grant the prosecution's motion to dismiss count 2 of the criminal complaint, charging Mr. Buffington with 1 count of criminal trespass in the 2nd degree. That charge will be dismissed at this time. Ms. Tuaninga, is there anything further that the prosecution would like to add to the sentencing recommendation as it appears in the plea form?
No, Your Honor.
Ms. Arnold.
Yes, Your Honor. First, I would like to make a quick correction. So in recalculating his credit, he does have 11 days already served. He did originally get charged. It was a felony decline, I believe, or of some sort. He has credit that are not accounted for in our case that we just want to make aware. So the correct credit on our case is 11 days. Moving towards sentencing now, we're asking the court to follow the agreed recommendation. His assault history is serious and recent. However, we want the court to take into consideration that he's currently on DOC probation, and his conviction will likely result in further consequences beyond the days that he has spent in custody on this case, and then when it was originally charged as well. Additionally, as a result of this case, his dog did pass away, so he's been grieving the loss of basically a family member, a loved one. So for those reasons, we're asking the court to follow the agreed recommendation. Thank you.
As a result of this case, his dog passed away?
Very quickly before I hear from Mr. Buffington, Ms. Tuaninga, the assault in this matter, it appears the alleged victim is Alan Harrington. Are these Mr. Buffington and Mr. Harrington? Did they know each other? Were these was this a stranger contact? What was the?
This was an assault which took place at a motel where Mr. Buffington happened to be located.
Say that last part again.
Where Mr. Buffington happened to be located. Mr. Buffington and his dog happened to be located. The felony decline is the assault in the 3rd degree from where Mr. Buffington's dog happened to attack the officer.
Ah, okay.
The officer killed the dog?
What prompted the assault in this matter that Mr. Buffington perpetrated upon Mr. Harrington?
There's not much in the report that shows what contributed to the assault aside from Mr. Buffington being particularly angry and the motel staff were not able to get Mr. Buffington under control, for lack of a better term.
All right. Mr. Buffington, sir, you get the last word. You don't have to say anything. I'm not going to hold it against you if you choose not to make a statement, but you do have the right to make a statement. Is there anything you'd like to tell me before I impose sentence in your case, sir?
If you want to explain the situation, you can, but you don't have to.
Yeah, I was trying to return my dog to my girlfriend. She stays at the motel, you know what I mean? And it's our dog, and they're, it's kind of like a shelter, you know what I mean? And they're just, I guess, because I'm a stranger or whatever, they came aggressive. And that's the situation, really.
Okay. All right.
Judge Simpson now. All right, let's make a quick jump. I was going to go to Minecraft Court next, but I will do Simpson.
So, Mr. Buffington, you know, it's always odd for me you know, you're clearly a very well-spoken person. You seem like a very intelligent person. You're conducting yourself this morning very respectfully.
Sorry, we have to bail to go to Judge Simpson.
Okay, it's dismissed.
Let's back up here a bit. How far back? Josh? Let's see if we can find it here. There we go. Start when they came right back off break.
Honor, at least according to my copy of the complaint.
Versus actually Peterson.
Peterson.
And Asia Riggs. And Asia Funderburg.
We have familiar people? Hang on. Who do we have here?
Hi, it's just me. I'm Ashley Peterson. My brother and sister are not present.
Your brother and sister.
Yeah, Brian Riggs Jr. is my brother, and Ayana Asia Jeans is my sister.
Okay, I don't have Brian as a defendant.
We have familiar people. Who is this? I'm trying
What
to
I
remember
have
the
are
case.
you and two Asias. So, all right.
Afternoon, Your Honor. Noel Sala appearing on behalf of the plaintiff, NKSK Properties LLC.
All right. And
I have lost. Okay. Honor, at least according to my copy of the complaint, Brian Lamont Riggs Jr. is listed.
yes, you're right. Actually, there's only one Asia.
That's it.
Well, I have Asia Jean.
It's Your Honor. Asia Jeans.
All right. They need to correct this card stock because I think I see what they did. Don't know why. Okay, I do have Brian. Okay.
Your Honor, this is a complaint for non-payment of rent.
Yes.
Defendants have in fact vacated the premises.
They have.
Subsequent to the filing of the complaint, but on April the 13th or thereabouts. I'm not uncertain.
I'm sorry?
We vacated the premises before April the 13th.
What day did you vacate?
I would say the 2nd.
Of April. Okay. So this is just a money judgment claim.
Yes, Your Honor.
So what's the claim?
Well, the claim is, Your Honor, that there was a lease.
I got that part, but how much money are you claiming?
Well, we're asking them, there was, for April, there was, for March, there was $1,000 owed. For April, there was $3,000, and May, because it is now May, there is $3,000. There's also a one
surrender. What? How long did the lease run?
The lease ran through August of 2026.
All right. And so how much are you claiming for May?
For May, $3,000.
All right. So your total claim is $7,000?
Plus there's a water bill of $1,001. And that was also included in the rent, and I have that printed out from Pittsfield Charter Township.
Okay, we can get to that. I'm just trying to figure out what your claim. Okay, so it's a water bill. You basically have $7,000 in rent, $1,000 and some little over $1,000 in a water bill. What else? Is that
$220? We did not claim for property damages, and we would. So the only thing in the supplemental complaint was for the rent, the contractual rent.
All right. What's your position on this?
Well, I was actually proud. And I won't say exactly the words that he said to me.
Who?
The landlord, actually. But I had for the month of March, I had told him earlier in December of 2025 that I wouldn't be able to make the rent every first of the month. And he said, okay, that's okay. We talked further because he had came by to fix the doorknob. He said, okay. And I said, eventually I may have to move out and break the lease. He said, okay, make sure you give me a 60-day notice and blah, 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 blah. Well, blah, 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 blah is make sure you give me a 60-day notice and or something, whatever. So we got that done. And all I know is from that day forward, he had been basically harassing me about the rent. And I told him, you'll still get your $3,000. I just won't be able to pay it on the first like I was because I had help from my citizen. Now, prior to March happening, I had sent him a couple of text messages about things that were failing in my house, which is like the draining. When you turn on the shower, you could hear draining in the master bedroom. You could hear it in the living room, other things of sort. As far as the bathroom, other issues, faucets and stuff, it was just basically maintenance that was pushed off and ignored. But he had ended up texting me or contacting me and telling me that somebody will be by to look at it. So this particular day was, it had to be like March 27th,
okay,
26th. So around that time, I was actually I had to take my kids to Chuck E. Cheese for one of their signals.
Hold on a moment. So you're claiming, before you get into everything, you're claiming that you don't owe this money?
Yeah. I'm claiming that I don't owe them.
Okay, and your basis for claiming that you don't owe the money without going through the whole story is what?
Well, in the month of March, I gave him $2,000. Earlier that day, we had an argument because he had sent, basically he sent.
Well, I think they're agreeing to that because they're only saying 1,000 for that one.
The 1,000 and the other 4,000 we've been talking about. I don't know why they're even claiming that because after he told me, invested me out and told me to get my things, to get my children and get out, I did that within the same week I was going.
When did that happen?
March 22nd. He cursed me out. I asked him why. He still came by, picked up the money with his wife, and I proceeded to ask him, like, what was the issue? Because I didn't do anything but put in a request for my home to be fixed and looked at the things that were falling apart. And he called me on my phone and said all types of belligerent things, calling me names, and told me to get my stuff and get out. Therefore, that same night, he came by, picked up the $2,000. I went online, found me in the house. I was out before then, I signed my lease and everything, so I don't have anybody to pay. Oh, and as far as the, I'm sorry.
Did the other folks leave also?
The other folks left before.
Before you did?
Before Christmas, and I lived in the. That's why I said, I don't know, I was getting their half of the rent.
Gotcha. Okay. I gotcha. So counsel, I mean, basically what she's saying is effectively evicted in essence from the premises already. Your client resorted to self-help in terms of evicting her from the premises.
I don't think I heard that, Your Honor. She volunteered. I don't know the details of the discussion between the two of them, and I will have my client testify as to that, but that's not a constructive eviction when she said he asked for 6.
If a landlord goes by, tells you to get out, threatens you, calls you names, and you vacate the premises, that certainly can constitute a constructive eviction. I'm not making that finding. I'm just saying that's what she's claiming, that she had to leave. Yes.
Right.
Please.
Right.
This is.
My name is Majid Kahala. I'm the landlord. So I got everything, between me and Ashley. We never called on the phone except one time, and I got it recorded, and she knows I was recording. She said I called her names and stuff. That's not true because I got it recorded in my phone. and she left the house and April 13th, she just texted me, your key in the mailbox. You have a nice life. Prior to this, never mentioned she's leaving the house. She said she's.
You guys tried to re-rent the premises or no?
Yes, Your Honor, we will, but there was substantial garbage and damage done to the property. And
she left everything in the house. Even, the fridge was full. Closing the dishwasher.
So we have not been able to put it back on the market yet. We do have an estimate from Nash Brothers, an invoice from Nash Brothers Services, talking about the amount of work that they had to do in order to clean up the property.
Where's that from?
Nash Brothers dumpster rentals, snow removal.
Have they been apprised of that?
No, Your Honor, that they've not, because we do not have any, other than a telephone. We were not given a forwarding address. We don't know where to forward anything.
Again, she wasn't picked up.
So there are additional claims other than this $8,000?
Yes, there will be additional claims for property damage.
So when are you going to have that number?
The number I got an estimate from the others. This one we already paid, the 6,000.
When are you going to have the number for the total of your claim?
I got them.
We could have it within 2 weeks, Your Honor.
Court has set a final settlement conference on this case for June 2nd, 2026, 9 a.m. That's in person. The other parties need to be here also, because I guess they were under the lease on this. All right. Thank you.
Thank you, Your Honor.
Peninsular Place versus Keebaugh Henderson.
Good afternoon, Your Honor. Rebecca Austin for plaintiff.
Hello. Keebaugh Henderson. They are not checked in. Would you like to take a default, counsel?
Your Honor, this again is the gentleman who serves in the military, and he was on training at the last hearing. And I will tell you, since we were here last on April 24, we did receive $2,000 that I think Mr. Henderson had been waiting for. Unfortunately, now May rent is due, so I don't know what the court wants to do. I mean, so now owes May rent. I don't know if you want me to dismiss and refile for May, but then he's going to incur court costs again, or if we just want to adjourn this maybe one more time and we can kind of get to the bottom of May rent, because that's really all he owes at this point.
I apologize. This defendant emailed me earlier today. He was getting on to Zoom.
Did he say he was deployed someplace or he was having problems?
He just said he was unable to connect to Zoom today. He didn't give any other reason.
All right. I don't know if you heard that, counsel, but he contacted the court, said he's having problems getting online with us. So why don't we try to get May straightened out? Let me adjourn this to the end of the month, May 29th.
Okay, thank you, Your Honor. What time?
May 29th, 2026.
12 noon.
12 noon.
Perfect. Thank you, Your Honor. Have a great afternoon. Have a great weekend.
All right. You do the same. Is that it for you, Holly?
That is it for today.
All right. Very good. Take care. Have a great weekend.
Have a wonderful weekend.
Town Center Place versus Viola Hines.
Good afternoon, Judge Mark Wasbury for plaintiff.
And I have counsel, I don't know where he is, Alex Henry, is supposed to be here with legal aid. I've been emailing him since last week.
You say Mr. Henry representing you?
Mm-hmm.
Did he say that?
Yep. He sent me an email. Asked me, did I still need his services? And I told him, yeah, I called him this morning and I emailed him this morning and I didn't get no response. Because of legal aid, they don't have walk-ins anymore. You have to call. And he said he was going to help us get the other documents that she need. They sent her birth certificate application back. Social Security closed.
Okay, we're going to jump to another one. We're going to go back to McBurney here. Just 1 second.
If you've got any questions, if someone says something that doesn't make sense or you don't understand, or you just got a question about something, you need to make sure you let us know that. Will you do so?
Yes, Judge.
Great. Ms. Smith?
Yes, Judge. Before starting, would you like to know about the reductions in this case?
Yes. So you ask every time. You should just tell me in the future. If there are reductions, say, Judge, before we start, here's what we're doing for Ms. Johnson.
All right. Well, Judge, before we start, here's what we're doing for Ms. Johnson in this case. For count one, we're going to reduce that charge to simple assault. That is OCGA 16-520. For count three, that would be a no cross.
So count two stays the same and count three goes away. Excellent. Got it. So this is a misdemeanor plea.
It is. Ms. Johnson, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Raina Lonice Johnson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given today?
No.
How old are you and how far have you gone to school?
I am a PhD student and I am 43 years old.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with his services?
Yes.
Counsel, are you satisfied that your client has an understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
I do.
Ms. Johnson, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 24 months probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Your Honor, I might say here that what we intend to propose for the court's consideration is a nolo contendere plea. I know that counsel is referencing what is reflected in the forms that we signed off on, but I made a correction on there. So I just wanted to state that for the record.
Okay. Ms. Smith, do you have any issue with this being a nolo plea?
No.
Okay.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you a United States citizen?
I am. Yes.
Do you understand that you're waiving any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Pushed out to like June or something.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Ms. Johnson, has anyone forced, threatened, or promised you anything to get you to enter into this plea today?
No.
As to indictment number 24 SC 000602, how do you plead to count 1, reduced charge of simple assault, and count 2, battery?
No.
Is this plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to directly appeal from this guilty plea?
Yes.
But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you also understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Ms. Johnson. Your Honor, if this case were to proceed to trial, the facts would show that on May 18th, 2022, officers of the South Fulton Police Department responded to 6015 Landmark physical altercation. When officers got there, they spoke with Ms. Pamela Nelson, the victim in this case, who stated that her her brother's girlfriend had just beat her with a rifle gun.
What?
The officer then asked Ms. Nelson what happened. Ms. Nelson told the officers that the two had been getting into verbal altercations lately for the past 2 weeks at that time, and that Ms. Johnson, the defendant in this case, was throwing Ms. Nelson's shoes and telling her to leave the residence since the defendant in this case shared that place with the victim's brother. Ms. Nelson advised that she attempted to stop Ms. Johnson from grabbing her hands. And once she grabbed Ms. Johnson's hands, Ms. Johnson began to physically hit her in the face. Ms. Nelson stated that after she hit her in the face, Ms. Nelson started walking down the stairs to try to leave the home. But at that time, the defendant grabbed a gun and started to point it at Ms. Nelson, telling her to leave. Ms. Nelson said that while still walking down the stairs, she tried to leave the home, but then Ms. Johnson hit her in the face with the gun. She stated that Ms. Johnson told her, the victim stated that the defendant told her that if she came back to the residence that she would kill her. The officer then went back and she spoke. The officer did speak with the other officers on the scene, who decided to then charge the defendant in this case for the charges we have in front of us. Ms. Nelson at the time did have lacerations on her finger and by her ear that they could see she was possibly hit with something. When the EMS got on the scene to evaluate her, she did refuse to go to the hospital, but she was treated on scene. And that concluded the facts of this case we have in front of us. Regarding the negotiated plea between the state and the defense, we've agreed to, for count 1, a sentence of 12 months probation, and for count 2, 12 months probation to run consecutive for a total of 24 months on probation. Regarding the special conditions of probation, we are asking for the defendant to stay away from the victim in this case and also to complete an anger management course. I did get a chance to speak with the victim in this case multiple times. We talked about the reduction in this case, going from ag assault to simple assault. She was okay with it because of how long it has been since the incident happened, the fact that she hasn't had any run-ins with the defendant since, and just an overall outlook on what happened. The biggest thing for her is that she just does not want any contact with the defendant, but she was okay with the reductions in this case. She was given the Zoom link, but she said she has to work, so she was okay with me giving you her statements on how she felt in the case. But that is all from the state.
Got it. Thank you.
What a case.
Ms. Harvey, any criminal history information on Ms. Johnson?
She has 2 cycles out of Georgia, Your Honor, 1 out of Florida and 1 out of Louisiana. There does not appear to be any felony convictions, and nothing further.
4 misdemeanor.
What's the most recent cycle?
May 23rd, 2022, out of Florida. That was a fugitive arrest.
All right. Thank you.
And yes, Your Honor, you're welcome.
What the most recent Georgia one, is that this case?
It was a phase to appear on this case from March 2nd. Yes, Your Honor.
Okay. Thank you.
You're welcome.
So, Mr. Hardwick, is the arrest in Florida related to this? Because it was like 2 days after this.
It is.
Okay, so Ms. Johnson retreated to Florida and was brought back here.
She was in the armed services, and that's what she was working out of.
Got it.
Yes.
Okay. I'm ready to hear from you.
Well, Your Honor, obviously, Ms. Smith and I have spoken a great deal about this matter. I have been representing this young lady since the inception of her arrest, appeared at the bond hearing that took place following her arrest. The significant thing that I want the court to also consider is that everything that Ms. Smith related is from the victim. There was a strong disagreement from our perspective as to the facts and how they sort of evolved. But we recognize that, as counsel stated, and apparently as the victim agreed, it's been 4 years. So we just want to move on. And I think that this is a fair way to do it. She does not have a record of any significance at all, save for this case. And we would respectfully request that the court accept the negotiated plea as proposed.
All right. Ms. Johnson, it sounds like at the time this happened, if I followed the facts correctly, you and Ms. Nelson's brother were in a relationship?
That's correct, Your Honor.
Got it. So your connection to Ms. Nelson would be, I'm dating your brother.
Yes, Your Honor.
And were the two of you, Mr. Nelson, would that be the right last?
Mr. Smith.
Mr. Smith, were you and Mr. Smith living together at the time?
We were.
So then Ms. Nelson came to live with you all?
Ms. Nelson lived there prior to me coming there.
So you joined them?
Yes.
Mr. Smith said, let's live together. You said, great. Oh, but by the way, my sister lives with us as well.
Yes, Your Honor.
Okay, got it. Okay. Do you know, Ms. Smith, if Mr. Smith was present when all this happened?
I'm not too sure.
Because he could seem to kind of resolve. It sounds like there are two different versions of events, but if he was there, he could say there was a rifle, there wasn't a rifle. All that stuff.
Isn't there a movie about this?
She talks about the altercation of two hands, but she never mentioned it.
Mr. and Mrs. Smith?
Okay.
For the court certification, he was not present.
Okay. And there's nothing for me to resolve. It's a plea. I just always try to get a little more context to what was happening.
Sure.
All right. Ms. Johnson, you are getting your PhD in what field?
History.
That's exciting. You'll be Dr. Johnson. How soon?
29.
Oh, okay. You got a ways to go.
You got 4 years.
And where are you enrolled?
Clark, Atlanta.
Okay. Super. Anything you want to add?
No, Your Honor.
You ready to be done?
Absolutely.
Okay. Are you and Mr. Smith still an item?
Item.
Well, do you and Mr. Smith, are you still dating?
We're friends.
You're friends, but it's a different nature of relationship.
Yes, Your Honor.
I might also add, for the court's desire to have a full picture, my client and Ms. Nelson have not interacted, spoken, seen one another in any way since the date of the incident, and she does not anticipate that that scenario will occur.
Well, that's why I asked about Mr. Smith, not because I'm prying into your business, but if you and Mr. Smith still spend time together, that puts you potentially in Ms. Nelson's orbit. That's the only reason I was asking. But if your relationship is less involved now, then you can go to dinner. You're just not going to be, if he and his sister still live together, that's not a place you can go.
Yes, Your Honor.
Okay, sounds like you understand that. Well, Ms. Johnson, if you don't have any questions about anything, then I'll accept your plea. I find there's a factual basis for it. That's not me saying it went down exactly as Ms. Smith said it did, but if Ms. Nelson were to come in to testify consistent with what she told the police, with the injuries she had, a jury could find you guilty of simple assault and of battery. So I can understand why you're pleading NOLO, and I'll take that. I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about. You know what voluntary means. No one's forcing you to enter this plea. Do you agree with both those statements?
Yes, sir.
Okay. Mr. Hardwick, can someone in my office sign the indictment for you?
Sure.
Indicating the NOLO plea?
Sure, absolutely.
Ms. Smith?
Yes, Judge.
And Ms. Johnson, can we electronically sign your name indicating the NOLO plea to simple assault and to battery?
Yes, Your Honor.
We'll do that. I'm going to sentence you on count 1 to 8 months of probation and count 2 to 8 months of probation. Count 2 will run consecutive to count 1. So it's a total of 16 months probation. Special condition number 1, no contact with Ms. Nelson. Just maintain what you've been doing. Don't reach out in any way. And the only potential question mark is, insofar as you still spend time with Mr. Smith, you need to not have Ms. Nelson be a topic of conversation, because if he were to go back to his sister to say, let me tell you, Ms. Johnson wants me to deliver this message, that's you communicating with Ms. Nelson, and that needs to not happen.
Yes, Your Honor.
Okay. The other condition is that you complete an anger management course. Probation can help you identify one if you don't find one, but that's it. I don't think this is going to be a particularly heavy lift for you. Ms. Smith, anything else in Ms. Johnson's case?
Nothing further, thank you.
I'm trying to remember. There is a form that Ms. Johnson needs to fill out. She did already. Excellent. To have, I need to verify another signature then as well. So you've already filled out what we call the JCS, Judicial Correction Services form. They will contact you. I don't know if it's an email or a phone call, but be responsive to that initial outreach, because that'll establish your connection with probation, and then you'll take it from there. You also completed a plea of guilty form with your lawyer, Mr. Hardwick. You initialed a bunch of things, and I need to confirm that on page 4, this is your signature. It kind of looks like your initials, but that's also your signature?
It's my signature, sir.
Okay. And Mr. Hardwick, you had a chance to discuss the items on the plea of guilty form with your client?
I did.
And you, in turn, on page 5, gave a very lawyerly signature.
Yes.
That's your signature?
It is. Yeah.
Okay. Excellent.
I don't know if it's lawyerly, it's ugly.
Okay. But it's all there. I can see it. I think we've completed everything then. Anything else from you, Mr. Hardwick?
Nothing further, Judge. Thank you for, as always, being thorough, attentive, and understanding of this situation.
That's what I'm supposed to do. Ms. Johnson, good luck with the PhD. Stay on it. It's a few years, but it's quite an honor to get a doctorate. So I hope that works well, and you're at a great school.
Thank you.
What are you doing in the meantime? PhD doesn't put bread on the table.
I'm working, sir.
What are you doing?
Amazon.
Okay.
Logistics.
Great. Well, they're a valuable employer in our community. So good luck with that. And the PhD, are you going to teach history once you get that degree, or what's the plan?
I'm going to make history, Judge.
That's an option, teaching history.
Yeah.
I'm exploring other options.
Okay. Well, good. Well, good luck with whatever it is you decide to do. Thank you very much.
Your Honor, Ms. Johnson has requested a copy of the documents that we signed off on. Is that doable?
Yes.
Okay, we're going to bail from Judge McBurney and go to Judge Satterfield to see what she's doing today. Hello, Judge.
About your case and whether or not the state would be successful in proving you guilty or not. If you want to enter a plea, and if I hear enough evidence to think one reasonable fact finder may have found you guilty based on that information, then I'm going to find you guilty based on your no contest plea. Thereafter, you're treated the same as anyone who originally pled guilty or was found guilty by a judge or jury. In other words, there's no distinction after I find you guilty for purposes of sentencing, post-trial, conviction issues, or probation or anything else. There's no distinction. Do you understand what I'm saying conceptually? It's just a matter of how you get there. Okay?
Yes.
All right. Now, I need to tell you there are no mandatory minimum sentences that I have to give you if I find you guilty of possessing paraphernalia in this case. And I'm not seeing what the, okay, it was some kind of smoking bong, glass smoking pipe or smoking bong, one or the other, which they believe had residue or appeared to be such that it's used to inhale or ingest or otherwise introduce an illegal substance into your body. But there's no mandatory minimum provisions for that. The maximum sentence you could receive, because it is a Class B non-person misdemeanor, is 6 months in the county jail and $1,000 fine. I do value the recommendations of counsel in terms of what kind of sentence you could receive. In a felony case, I am required to follow the Kansas sentencing guidelines established by the legislature and sentence within those guidelines. I don't have those kind of parameters in a misdemeanor. I am free to impose whatever sanction sentence that I see fit. As I indicated, I do value the recommendation. I often follow them. Again, I'm not familiar with you, your record, your history, specifics in your case or anything like that. So I do think that the attorneys are in a better position to suggest to the court what the court should do. But I'm also supposed to let you know that the decision is ultimately mine. Do you understand that?
Yes, ma'am.
All right. Do you have any questions? There's no special registration. There's nothing else that I can think of that is special with this particular offense that I should advise you of. But do you have any questions about the possible penalties you could receive?
No, Your Honor.
Now, the other thing that I might just throw out there as I'm thinking about things is sometimes if you are already on felony probation, generally not parole, but it could be, but if you're on a felony probation, if they find out you've been convicted even of a misdemeanor offense, that can be a basis for them to file in any county a revocation request based on a new misdemeanor conviction. So that this case could have some implication potentially there.
I don't have any.
You're not on probation?
No.
All right, very good. Very good. All right. Now, I'm gonna go over your jury trial rights with you, and then I'm gonna ask you some personal questions about your state of mind and the voluntariness of your plea. So, what we're gonna do next week, I'm not sure that I talked to you about this in full, but I'm sure your attorney did, is we get together at the courthouse where the crime's alleged to have occurred in Greenwood County. We've got people lined up to appear on Tuesday and report at 8 o'clock. We get a group of those people together. We swear them in. We start asking them questions. We excuse some for cause if they cannot swear to make a decision based on the facts presented in the courtroom and apply the law. We make sure they can be fair and impartial and that they're suitable. And then your attorney and the prosecutor get to eliminate, if it's a misdemeanor 3, felony, this kind of felony 6, people just for whatever reason they want to, as long as it's not discriminatory in nature. So that's how we taper down and end up with a number of jurors that we need to try the case. Then the state goes first because they have the burden of proof. They have to present their case in chief. And they have to call witnesses in under oath, subject to cross-examination. They have to ask for the admission of evidence. Your attorney gets to object, and most importantly, gets to cross-examine these witnesses because you have a right of confrontation. In other words, things can't be going on behind the scenes that convict you. It's all got to be in open court in your presence with your involvement and participation. You cannot be compelled to testify because you don't have any duty to, and you have a Fifth Amendment right under the Constitution not to. The jury's verdict would have to be unanimous. It'd have to be based on the evidence. And if you were found guilty, you'd have a right to appeal and have a higher court review the trial transcript because they want to make sure that we're doing things right and that you receive a fair trial and that nobody violates your constitutional rights and that there is, sufficient evidence to support the jury's verdict. So you do limit your right to appeal if you don't go to trial as well, even if it's legal issues such as Fourth Amendment issues. They're only preserved if you go to trial and raise them on appeal. So, do you wish to waive your right to trial, jury trial at this time, and essentially limit your ability to appeal?
Yes.
All right.
All right. She
Last but
waives
not
her
least,
right.
I do
We're
want to
gonna
make
bail
sure
on that
you're
as well. Trying to find a good one. Civil trial just started. Josh, thanks for finding this one. Civil
you're
bench
welcome.
trial. Don't know much about it. Been in this courtroom once before.
All right, on the record in Caleb Willis versus Cars on Demand LLC, 2505070 GC. You are Caleb Willis. Parents, please.
Tom Tupper on behalf of defendant Cars on Demand LLC.
Thank you. Today's the date for the bench trial. It's my understanding we're proceeding to a trial. Mr. Willis, you bear the burden of proof today, so you have to prove to me by a preponderance of the evidence that you should prevail in this case. So you'll go first, presenting your evidence before the defendant has an opportunity to present theirs. Each witness you call, they get a chance to cross-examine, of course, and we'll go from there. Are there any preliminary matters before we begin taking testimony today?
Yes, Your Honor. Defendant moves to sequester witnesses.
Okay. Sequestration means that people who may be a witness in this case have to sit outside the courtroom during testimony of other witnesses so that their testimony cannot be influenced by other people who are testifying. It's pretty common for sequestration of witnesses to occur just to keep the testimony from being tainted by what others say. Do you have any position on sequestration, Mr. Willis?
No.
Do you have other witnesses here with you today that you intend to have testify? Besides yourself?
Other than my wife. No, I don't.
You said it's your brother?
My wife.
Oh, your wife? And is she going to testify?
I don't think I will need her today, so no.
Well, today's the day. So are you going to need her during your trial? No. Okay. All right. And then as for you, Mr. Tupper, do you have witnesses here in the courtroom right now?
I do. I have one witness, Your Honor. But if...
Okay. Well, your witness is sequestered, so have your witness step outside. Okay. Sequestration has been ordered. Any other preliminary matters before we begin taking testimony? Anything from you? No?
None for defendant, Your Honor.
All right, Mr. Willis, it's your case. You start first. Since I'm already kind of familiar with what the issues are in this case, I'm going to dispense with opening statements and go right to testimony.
Makes it a
and
little
evidence.
harder for us.
Mr. Willis, your first witness
Me.
will be.
I don't have to witness.
Well, are you going to testify as a witness?
Oh, I'm a witness.
Okay. If you're going to testify as a witness, then because you got to have some evidence today, remember you have the burden of proof. Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes.
Okay. Now, if you want to, you can testify from the table or you can testify from the witness box. What would you prefer?
I can testify from.
Okay. You need to stay in front of a microphone so that we can get good recordings of you. Okay. There's microphones a couple different places. We need to always have a microphone. Okay. State your name for the record.
Caleb Willis.
Okay. Mr. Willis, you're going to provide your testimony and then Mr. Tupper's going to get a chance to cross-examine you. So remember that you're not done when you're done. And then you'll get the last opportunity to sort of clean up your testimony a little bit. At the end, we call that redirect. Go ahead with your testimony.
I've prepared one. So is that okay if I read off?
Generally, you need to testify from your personal knowledge. So no, people don't read their testimony to the court. They tell me what they know. Sometimes you can look at notes to refresh your memory about dates and things like that, but you need to tell me what you know.
Okay. I have evidence of prior structural damage to this.
Okay, that's not how this works. This is a trial and you have to start at the beginning, providing all the evidence. So you need to start with the day you went and bought the car.
Okay.
Start at the beginning and tell me everything that happened.
Okay. I purchased the car November 8th, 2024. The same night I drove it home, I had to check engine light, so I went to AutoZone and I have the paper.
Okay, you're gonna have to back up again. Where did you buy the car? What kind of car? What price did you pay? See,
I
So
purchased
37 questions just on that one issue. Okay, start at the beginning again.
Okay, I purchased a car from Cars on Demand LLC. It was a 2016 Chrysler Town and Country, and I purchased
That's
it
a
for
minivan.
$13,000.
You said it was a 2016?
Yes, 2016.
How many miles on it?
Where is Cars on Demand?
On Waverly, South Waverly Road, I believe it is.
Was this your first time seeing the car?
Yes,
Or
when
did
I
you
purchased it.
look at it a couple times and then buy it?
It was my first time seeing it.
Okay. Tell me about the purchase. What do I need to know about what happened that day when you made the purchase?
Okay, so I initially walked onto the lot and I seen the vehicle. I had been looking for vehicles for my family because I was just having a son, so I needed to upgrade cars. So we decided we're gonna get a van. I went to their lot, I seen a van with low mileage. It looked very clean. I noticed one of the headlights looked brand new, one was foggy, and I also noticed that the bumper was misaligned with the car. So then I'm looking at the car, the salesman comes out to me and I ask him about the car and we're talking. And I ask him what all has been done on the car. Has there been any previous accidents? I was told that it had been in a very minor accident, and I asked what had been replaced in the accident, and I was told it was just a bumper and the headlight that had been replaced. So from there, I decided to test drive the vehicle. After I walked around and I looked at it, I seen the vehicle only had about 87,000 miles on it. So I test drove it.
When you test drove it, no lights were on the dash?
No lights were on the dash at the time, no.
Okay. How long was the test drive?
Roughly about 10 minutes or so.
Okay.
And after I got back to the lot, I'm sorry, I noticed like a few things that before I would purchase this vehicle, I would like to be looked at, maintained. And one of those things were the brakes and rotors, which I do have a receipt that they did replace the brakes and rotors before I purchased it.
So you asked them to repair or replace brakes and rotors before purchase, and they did?
Yes, because the brakes were already squeaking, and I had noticed that upon the test drive. And it sounded like the rotors were also grinding. It was making a very noticeable noise.
Okay, so you didn't buy it right that second then if they had to do that work?
Correct.
Okay, so tell me what happened next.
I then put a $500 deposit down to secure the van, that telling them I'm going to purchase the vehicle after we had already agreed that they would fix what needed to be fixed on it.
Okay.
So after they fixed it, everything was squared away. I then began doing all the paperwork after we had already started the paperwork, after I put my deposit down. So we had started some. I purchased the vehicle. The night I drive home.
So how much time went by from the first, when you saw it and you asked for that work to be done, and then when you go back to
I believe it was a day.
A day.
I got off of work and we had started looking for the car, so it was already getting to be late.
So one day later, you went back to make the purchase?
Yes.
Okay.
After they had already fixed everything.
So it was only one day for them to make the repairs?
It might have been over the weekend. I'm sorry.
Okay.
It wasn't very long.
Okay.
So after we squared the paperwork away, the first night I drove home, I had a check engine done. And I immediately contacted the salesman that I had spoken with. And he was helpful and he was willing to help me with that. Well, a week later, before I took it to him to get that fixed, something else had went on the van, an electrical problem with the radio, I believe it was. The camera was not working with the radio, so when you back up, you can't see the camera. So I had also took it in there for that. So that was two things that I took it for.
It was a lemon.
Shortly after that,
it's making me nervous about my wife buying a car right now.
I began having more problems with this vehicle. And this is only within the first 2 months of owning it.
Okay, but back up. You said the check engine light came on while you were driving it home.
The first night.
So it wasn't on when you pulled off the lot.
No.
But as you drove down the road to your house, it came on.
Yes.
And then you said before you could get it in to address that, the backup camera stopped working.
Yes.
Then you said you took it in. So did they fix it at that point?
Yes.
So that next week when you took it in, they fixed both issues.
Yes.
Okay. At no cost to you?
I don't believe so.
Okay. So that gets fixed, and then what happens next?
Okay, so in January, around the time I had my son, we weren't driving the vehicle much. It was snowing a lot. And I went to go start it, and it wouldn't start it. So then I had obtained my warranty to go use it and make my claim. And then they called me back saying that they can no longer cover me for this vehicle because this vehicle has been totaled, which was new information disclosed to me. Because I was only told that it was in a minor accident. And I was under the impression I had a clean title with only a minor accident. So Athena, the warranty company that I went through, they dropped me through coverage because it was a totaled vehicle. They don't cover totaled vehicles.
Excuse me, sir. Your Honor, I object. It's hearsay from what Athena told the witness.
Okay.
Okay.
Well, I have the paperwork saying that they don't cover.
But that would be hearsay. Like hearsay can be written or spoken. It's any statement made outside of court offered to prove the truth of the matter in that document. So if you're offering a letter they wrote you that says we drop you because it was totaled, to prove that it was totaled, that would be classic hearsay, unless you meet an exception.
Okay.
Okay. How did you get this warranty though? Did you get that through Cars on Demand or did you buy it separate?
I had waited like a week or so and then I had purchased it.
Okay, so that wasn't anything where Athena talked to Cars on Demand.
No, that was when they recommended that I get a warranty, and he said I could wait a week or two if I decide, and I ended up going with it.
Sure. So you're the one who called Athena and provided them information about the car to buy the warranty coverage.
Yes.
And did they ask you about like if the car had been in an accident?
No, I have been making monthly payments on it. It was only when I went to go use
I gotcha. I'm not asking you about whether you paid for your warranty coverage. I'm asking you about what they asked you in order to give you a warranty.
Sounds like a salvage title.
I only had to provide them with the VIN number, I believe it was.
And when you provided that VIN number, they granted you the warranty coverage until you tried to use it, and then they said, "Oh, just kidding. That VIN number comes back to a totaled car."
Correct.
Okay. Got it. Okay. Then what happened?
So I take it to Chrysler.
When was this? Like approximately, you don't have to be very specific if you can.
It would be around January of 25.
Okay, and by Chrysler, you mean a Chrysler dealership?
Yes.
Okay.
I took it there to get a diagnostics done, which I have the paperwork for. I'm talking to the salesman at the time, and he recommends that I go to their mechanic so it would be cheaper. So I then tow the car from Chrysler to the mechanic that they recommend.
To?
Carzilla.
Carzilla, because Cars on Demand recommended it.
Yes.
Carzilla,
And
reputable,
they connected me
well-known
with service manager Rada that they go through, is what I was told. I was told that I could go here and the service would be cheaper.
Where's Carzilla?
They have 2 locations. I believe they have a location close by their shop, Cars on Demand.
Mm-hmm.
Like, I believe it's like right down the road. And then they have a main location by South Holmes Road.
Okay, so which one were your car taken to?
my car was towed. I never seen, so I'm not sure which location it was.
You don't know where it went to be repaired?
No, it was. I just know it was at Carsville. I didn't know that they had 2 locations until I had to take it there multiple times.
Okay. Well, you got it back from Carsville at some point, right?
Yes.
Well, where'd you get it back from?
They had towed it to a different location. I got it back from the South
shady.
Holmes location, I believe.
We're just going to hide your car somewhere and we'll bring it back to you when we're done.
And upon that, while the repairs are being made on my car, the mechanic also points out that the ECU was bent, and that was due to previous accident history damage on the vehicle.
And I object to the hearsay, Your Honor. What the mechanic said, that's offered for the proof of the matter, sir.
Sure. Did you see this with your own eyes?
Yes, and I also have the mechanic's written statement.
Again, hearsay, remember? Out of court statement. It's not here to testify. Offer to prove the truth of the matter, sir. It's classic hearsay unless you give me an exception. But tell me about what you could see yourself.
You're not going to be able to get an exception.
The ECU, which is the computer of the car, was physically bent. It's supposed to be straight, and it was bent in a C shape, as you can see in the pictures of the previous damage that.
We haven't admitted the pictures yet. If you'd like to admit the pictures, you can do that.
Okay, I thought that was what the sticker was.
The sticker is so that they can be admitted. We're preparing for the hearing where you try to admit them. So
Did you
if
need
you
to
want
watch
to admit
just like one or
pictures,
two
you can,
cases?
but you'll
before
have
you
to
do
just
this?
kind of tell me what the pictures are supposed to be, and then we can see if there's any objections from the other side. So for each picture. So start with the first one. What's the sticker on it? Is it Exhibit 1?
Yes, Exhibit 1.
Okay. What's that supposed to be?
This is the first picture of the damage of the vehicle before I purchased it. And it shows all bumper.
Hold on before you tell me what it shows. Mr. Tupper, you have objections to Exhibit 1?
I'd like to see it, Your Honor.
Okay, show it to him so he can take a look and decide. Yeah. Okay.
It's a rough way to learn about the court system with a lot of money on the line.
I'm not going to object, Your Honor.
Okay. To any of the photos in the packet?
Or Exhibit 1, correct.
Okay, Exhibit 1's admitted. Okay, now you can tell me what's important in Exhibit 1 you want me to notice.
Okay, in Exhibit 1.
And that's all of them. So you can tell me about each one, what you want me to notice.
Okay.
If you think there's things in there that if I notice them, it will help me make a decision.
Is it okay if I give it to you?
Well, first, kind of show me from there and then give me the packet and I'll look through them.
Okay.
Okay.
So on the first picture, you can clearly see that the fender is not perfect. The hood, the bumper is completely missing. The radiator core support, which holds the radiator, is missing. The ECU, which is right here, which is one of the main computers that controls the vehicle, that piece is bent and all the brackets that hold it are broken. In the next picture, it shows a clearer picture of the front end. You can see all of the components that are hanging. This picture also shows the rest of the damage. It's more so to the front end of the car. This is a front end damage.
Can I see the picture just to compare it to what? Yeah.
It's the same picture.
It's the same picture. You already saw it.
And I also have the VIN showing you that this is this same car. And this is the mileage of the vehicle as it sits.
The day that that picture was taken?
Yes.
Okay.
So I'm going to give these to you to look over now.
Bailiff says, or clerk says,
thank you.
Be in the middle.
Now tell me, since you pointed out the mileage was 87,089 when those pictures were taken. What was the mileage when you bought it?
I have that. The mileage when I bought it, there's a lot of discrepancies, so bear with me. So this is the Secretary of State title that I purchased from Secretary of State. This is the title that they submitted to the courts.
Okay, well, those are marked as exhibits. So let's start with the first one you mentioned. It was labeled as exhibit number
11. And this is the Secretary of State copy that I purchased to present to the courts.
When did you purchase it?
I purchased it when we started this trial.
Today?
I don't have a
You mean
specific.
when you started the case? Because the trial started today.
Yeah, yes, when we started the case.
Okay, so
that's exhibit 11?
11.
Okay, can I see that, please?
My wife did not buy the car. The stubborn husband stalled and stalled and stalled, and now I guess they have to drive home.
Okay.
It's only a 2-hour drive.
okay, so any objection to exhibit 11?
No objection, Your Honor.
11 is
Okay, now
admitted.
this is the Secretary of State copy, so I'm going to give you the mileage on this copy. The mileage on this copy is 87,089 miles.
Okay, same as the picture you gave.
Correct. Okay, now the copy that they submitted to the court,
Which is marked as exhibit
12.
Exhibit 12, the copy that you received from Cars on Demand.
Yes.
Any objection to exhibit 12?
Nope. No objection.
Okay, 12 is admitted.
Okay.
Okay.
Now the mileage on this one is the same,
Okay,
but there are also title discrepancies between these two titles that they have submitted and the title that I bought from Secretary of State.
Oh, that's a problem.
So to look at the two title applications now that go with these titles, I have also two of those. Now this is where it starts to change. So this is the title that I had signed the night of. Stock number 1001. This mileage on this application that I signed is 87,095.
okay.
Different from this title.
6 miles, you took a 10-minute test drive.
Okay.
Can you get a number for that exhibit, please?
Exhibit 9.
It has not been admitted yet. That's your application for title?
Yes.
Are you moving for admission of that?
Yes.
Any objection to exhibit 9, the application for title?
Depends on the purpose for which it's being offered, Your Honor.
That's not how it works.
This was never submitted to the Secretary of State. That's
You never submitted an application for title to Secretary of State?
not that one.
Well, I have two.
Yep.
Why?
One was so he could get financing from MSUFCU.
Mm-hmm.
He needed
That
that
sounds
information,
shady.
but then the mileage to get his financing. That's why it's dated the Secretary.
But shouldn't they be the same?
Yes.
You wouldn't submit a different document to the bank than you submit to Secretary of State.
I think it was just printed off from the information they had. It was not part of the actual sale package. It was for him to get financing before the sale was consummated.
Exhibit 9 is admitted.
Okay. Now exhibit 10, which is another title application. This one has stock number 1000. The other one was 1001. Okay. So the mileage on this one states 87,195.
The mileage thing
And
is.
there are also other title discrepancies, and I'll hand these to you so you can look over them yourself. I have already highlighted them.
Any objection to exhibit 10?
I haven't seen it, Your Honor.
87,000 is low miles for the year.
No objection.
10 is admitted. Would you please obtain exhibits 11, 12, 9, and 10?
I may have some questions on those exhibits for cross-examination, Your Honor.
That's fine. They're exhibits. You can do that. Judge is reviewing the same.
Okay, go ahead.
Okay, I also have the original listing, Exhibit 6, which shows the mileage and the condition and how the vehicle is presented.
You mean the sale listing?
Yes.
Okay.
At least he's got all his paperwork. Some pro se individuals struggle with this part. Just want to just blurt out what the problem is.
No objection to Exhibit 6.
Okay, Exhibit 6 is admitted.
Give it to the judge. The judge is the jury here. It's a bench trial. 2019 Subaru Outback has only 17,000. Whoa. Have you never driven it? That's like a 1 to 2 years worth of miles. Well, now she's saying he just showed up. So now my son's going to miss work tonight because dude can't get his act together. Might still buy a car. It's a red flag. She's going to buy it anyway. She likes it. You need to know this about Mrs. Ari. She used to manage fleet vehicles. She's worked in repair shops. She knows a lot about
I
cars,
also
more
have
than I do.
Exhibit 3, which they had submitted to the courts on our last. And this is just showing everything that they had repaired on the vehicle, which was not presented to me.
What is Exhibit 3?
All of the repairs made to the vehicle.
Is it an invoice? What is it?
Yes, it's an invoice.
An invoice? Show Mr. Tupper.
Where'd it come from? Where did the invoice come from?
I have no objection to admitting Exhibit 3. I just object to the characterization that that's all.
Okay.
Oh, well, that's new information.
Exhibit 3 is admitted.
That's new information.
And on this list, you will find all of the things that were fixed on this vehicle. But what you'll also find when I
I'm going to
asked,
object to the foundation.
when
This witness is qualified to say that that was all the things that were fixed.
I understand that that's your position about the exhibit, but he can provide his testimony and 3's been admitted, so he can say what he wants about it. Go ahead.
So upon when I asked them to submit this to the court of everything that had been fixed on the vehicle, I was presented this paper. So this is new information that this possibly might not be everything that's fixed, because I only have this paper. And on this paper, you will see that it does have a fender, it does have a bumper, but it also has more than just a fender and a bumper that have been repaired on this vehicle. And in our last deposition, Mr. Tupper said that it was new information that I had told him that it was only a bumper and a headlight that was repaired. In our last deposition on line 20, I also state, this is on page 23, I also state that it was a bumper and a headlight that had been repaired. This is what I was told by the salesman before I made my purchase.
Mm-hmm.
I was not presented this paper upon purchase. So we can submit this one.
Okay.
It's already in. Gonna get your steps in today, ma'am.
Yeah.
Okay. I also have the history that I've obtained from this vehicle through databases such as Carfax, Cars for Sale, and Been Verified. All of these databases go through the NVMIS, the National Motor Vehicle Title Issuing Agency. On these
I'm just going to object to the website printouts, Your Honor. Those are hearsay within hearsay. In terms, they're reporting on other insurance company records, so they are not records of regularly conducted business by the website. They're relying on information from other sources, number one. Number two, I object to the relevance of them. This information was never provided to Cars on Demand.
Well, I also want to say
First, tell me what's relevant about them.
Okay, it documents the total loss. It shows the severity of the damage in the report. It shows the date it was deemed a total loss vehicle. It shows the mileage. It shows that the damage was so severe that it had to be towed from the scene of the accident.
They still might have just bought out at an auction.
Okay, so to his other objection that document contains hearsay. How do you respond to that?
Well, total loss is material information.
It's an exception to hearsay. How do you respond to his position that that document contains hearsay?
Do you need to know the exceptions to hearsay? And it's not for the truth of the matter. Yes, it's for the truth of the matter.
These documents are submitted through federal databases.
Okay, so business
documents. Each and
documents.
every one of these should be admissible in the court because it is used in the national federal database. This isn't just any website. This is what the federal database goes off of.
But what information, what is the source of the information that ends up in the website? Where does that information come from?
It comes from the VIN of this vehicle.
Well, the VIN doesn't say words. So where does the information come from?
That's who your witness should be. It's not coming in.
It came from when the car got into the accident.
So somebody put information somewhere that got loaded into that website. Where did they put that information?
They put it on the Carfax and they put it on other multiple databases.
Somebody's entering this information in multiple databases. Doubt that. Try again. Somebody is not sitting at their desk going to Carfax and this database and that database and loading that information in there.
Insurance company.
Where does the information come from?
Insurance company. She's trying to teach you.
I guess I can't answer that question.
Well, until we can figure out where we believe that information comes from, we can't rely on it. I can't even make a decision about whether it's hearsay when I don't know where it came from.
This is reported through insurance and everything.
There it is. Insurance.
When this vehicle was crashed, it was insured. So the insurance had to deem it a total loss, and the total loss got sent to these databases.
Do you have information from the insurance company?
I can't obtain that information because I wasn't in the accident. I tried to call, but since I was not in the accident, they won't give me any information on that. I can only see what's in the reports that the insurance listed.
Okay.
I have all of the different databases that they list from.
The court order could get past that, though.
If I could interject, Your Honor, that information is available via subpoena. There's nothing privileged or anything. You could subpoena the insurance company.
Why do I need 3 different documents for one accident?
Because each one gives you a little bit more in detail of the accident.
Where do they get that detail?
from the
shows
national database.
I didn't ask you what the detail was. I said, where do they get the detail?
from the insurance agency.
And how do we know that it came from the insurance agency?
It was sold at an IAA, an insurance auto auction.
Does it say on the document, this information has been provided from insurance company records or something like that?
Yes, I believe so.
Not I believe so. Yes or no? Look at the document.
Law School 101 is in session. The judge is teaching today. It's a hard
Yes, it
lesson.
shows that the source is the NMVTIS.
Which is?
The National Motor Vehicle Title Issuing Agency, issuing service.
So it's a business
record. And where
record?
do they get the information?
Where does the NMVTIS get it? They're the federal database.
Right. Where do they get the information?
They get the information from the insurance company.
Have something that shows that.
I don't think you got it, bud. Doing really well.
I don't have it highlighted, but I do know when I did call, it had the insurance on here because I figured out what insurance the accident was through. But when I called them, they told me they can't disclose the information to me because I was not in the vehicle.
You already said that.
Right.
We're not just repeating the same things over and over again. We're answering new information.
It says, if this VIN has been recorded in the junk/salvage or insurance information, then the business that submitted the VIN to NMVTIS deemed the vehicle to be either a junk, salvage, or in this case, or in the case of insure, a total loss.
Start that again at the beginning.
There's your answers in there.
Yep, from the beginning.
And which exhibit are you reading from?
19.
It's not admitted yet.
It's
Then verified.
cars for sale. It says, if the VIN has a record in the junk/salvage or insurance information, then the business that submitted the VIN to NMVTIS deemed the vehicle to be either a junk, salvage, or in the case of the insurer, a total loss.
She's Googling it. she's Googling it. She's gonna find she's like, I found the answer just right here. I think he can win without this. I mean, it's key, but he needs to prove that the car dealership knew it was a total loss and sold him a car under false auspices. Is that the right word?
I'm just trying to find
It's a word I've never used before.
something on the obligation. It says it's federal law, so.
It's federally mandated reporting.
Can I also read this off while you're looking at that?
Yes.
This is on the same paper. It says all states, insurance companies, and junk and salvage yards are required by federal law to regularly report information to NMVTIS. However, NMVTIS does not contain information on all motor vehicles in the United States.
So Allstate reported in the course of the regular business, so this would be a business record exception if you can authenticate the business record, maybe. I'm good at totaling vehicles. That's awesome. Deal with total vehicles all day long. I hope to not deal with any totaled vehicles. I'm really hoping the one that my wife's trying to buy right now is not totaled. She knows well enough to not do that, but didn't total my vehicle. The ambulance that ran into it did. Oy.
Based on what appears to be federal law that requires
she's going to allow it.
Recyclers, junkyards, salvage yards to submit reports to NMVTIS if they deal in 5 vehicles or more. And that being that if a vehicle makes it into there, it's because it was required to be reported, although not all vehicles are reported. If it is in there, it's because of business record requirements. I'm going to go ahead and admit the exhibit as a business record.
Which exhibit is that, Your Honor?
That is going to be,
He's
I
gonna
believe is
win.
Exhibit 19.
He's going to win.
Which you said is the Ben verified one, correct?
Cars for sale.
Oh, cars for sale. I thought it was either Carfax or Ben verified.
Those are the other 2 documents that.
Okay. And the cars for sale one is the one that references that the information came from the NMVTIS.
Yes.
Okay. 19's admitted.
Whoa. He just won his case, I think. I think you're right.
And then the been verified and the Carfax I have here just as extra evidence that just show a little bit more information on the accident that had took place.
Well, where do they get that information from?
The insurance agencies that also report to the NMVTIS.
Well, if they're reporting to the NMVTIS, why is it not all the same information?
It is all the same information. There's just some categories that one paper might not have.
Might not show.
What number are those exhibits?
18 and 20.
Mr. Tupper, you have objections to 18 and 20?
I do, Your Honor. It's now, it looks as we're now getting into 3 levels of hearsay. Carfax report that references the NV, whatever the initials are, report that is in itself based on a 3rd level of hearsay, some records that is not identified in the report anywhere.
Business record exception, though?
They're not saying this insurance company reported it on this date. They're just saying somewhere someone said it was salvaged.
I don't know that that's required. The insurance company is required to keep business records of,
They are.
and then the insurance company or the salvage yard is actually required to report to the NMVTIS. So that's also a business record.
For salvage vehicles? You're saying? I agree with that, Your Honor.
And so all of these things are covered by the business records exception. So what is different about the Carfax report, or what's the other one called?
Been verified.
Been verified.
One just shows that the accident severity made it have to be towed off the scene, and the other one might not say that.
And we get the numbers from them as well.
18 and 19.
Which was 18?
18 is Carfax.
It's not 18 and 19. It's 18 and 20.
Or, sorry, 18, 20. Been verified is 20.
And verified is 20.
Correct.
This kid has to win. He's tried so hard. Plus, part of me feels that if he wins, then my wife's going to manage
18
to
and
pull
20
off
are
this
admitted for the
purchase
same
alone.
reasons I stated that 19 was admitted.
And I have the differences of everything already highlighted.
he's doing pretty well, but just the simple mechanics of the court process are new to him. He's picking up fast, though. He's a quick learner. Yeah, I'm rooting for the underdog for sure. The attorney is self-soothing. He's rocking back and forth. Oh, man. Worst case scenario, I believe not knowing.
I also have
the state law. I don't
the
think you can be on the
paperwork
hook
for
for
the
more than about
repairs that I have made on the vehicle.
the repairs plus the purchase cost. I think that's going to be all he can
Tell me what
get.
repairs you made.
I initially had to pay for diagnostics. I had to pay for the battery, spark plugs, and the ECU, which had previously been damaged in the accident prior to buying it.
So is that exhibit that you're trying to present invoice for those expenses?
Yes.
What's the exhibit number?
Exhibit 15.
I like that he's got everything numbered.
Show it to Mr. Tupper.
And I also have 17.
17.
That's another invoice of repairs that have been made to the vehicle.
What repairs are on that?
These are the spark plugs and the ECU.
What was on the 15?
They have the fuel module.
Ricky, glad we can help. Thank you, my friend.
We're reading off of 15 now?
I'm asking him to tell me what's on 15 because he said 17 was for the spark plugs and the ECU. That's true.
I think we're a minute or two behind. I might just try to skip ahead if I can. We'll be up to the second.
And to find out that it was a total fault, I had payments and the.
He was about to start talking. Okay, there we go. Gets handed up to the judge.
And then I also have all of my insurance payments and the tires that I have purchased for the vehicle.
Tires are wearing
So
tear.
it's not your position that the tires were damaged in the crash, right?
Correct.
So what's the point?
All of the tires were bald. I had to buy new tires.
Okay,
Doesn't matter.
but you
You
bought
bought
it
it
with
as
ball
is.
tires.
Yeah.
And that would have been open for you to see, right?
Correct.
They didn't hide the bald tires from you.
Correct.
So why are we talking about tires?
Well, I had purchased the tires. I was trying to maintain this vehicle, and I came to find out that it was a total loss while I'm putting more money into this vehicle. So if the court deemed it justifiable, if I could get that money back for the tires.
Probably not. But I like his argument.
Which exhibit number is the receipt for the tires?
Exhibit 23.
Is there a date anywhere for this exhibit? Yes.
5/10/25 at 2:59 p.m.
I'm sorry for the number again.
Okay. Any objections to exhibit 23?
No objection.
23 is amended.
I don't think he's
And
going to
then
get
I also have
money
all
for
of the
tires.
insurance payments showing that I've been maintaining payments on a vehicle that has not been running for over a year now.
So he's trying to get everything.
What exhibit is that?
Everything he's
Exhibit
dumped into the
24.
car.
Why are you keeping it insured if you're not able to drive it?
I have to have full coverage on it because I still owe on it.
It's a requirement of the loan. The lien holder requires
Okay,
full
exhibit
coverage.
to Mr. Tucker.
Okay, so now his costs have basically doubled the cost of this car.
Any objection to 24?
I do object, Your Honor. That's not included in the complaint, in the document production that we requested, or in his deposition. This is a new element of damages that has not been disclosed to the defendant before today.
Mr. Willis, is that true?
That is true, but again, Your Honor, if the court deem it justifiable, I have been making payments every month on this vehicle. I did forget to include it in my initial statement, but I do have the documentation showing I have been paying for it.
Sure, but you didn't ever send that to him or include it in your claim. It's a notice pleading state. If you didn't give him notice, you're not going to get it.
Okay.
Not going to get your insurance money back.
And then last, I forgot this one. This is my first one to Champion Chrysler, the diagnostic report.
What's exhibit number?
14.
Exhibit 14. You're saying that's the diagnostic report from some Chrysler dealership?
Yes, this is when I took it to Chrysler and then they recommended that I take it to their mechanic.
Show that to Mr. Tucker. Any objection to 14?
No objection to 14, Your Honor.
14's amended. Okay.
Okay, that's all the evidence that I need to submit.
Okay. Are you saying you're done with your testimony or you have more things to tell me about this?
I have more things to say.
Okay.
So, back where I left off at, when I brought the vehicle to the mechanic that they recommended, they replaced all of those things on the vehicle.
Replaced all of what things?
The spark plugs, the ECU.
Carzilla did.
Carzilla, yes. They replaced my fuel tank. They cleaned out the fuel filter, they cleaned out the fuel tank, replaced the fuel filter in the car. I had to buy a new battery, and I believe that was all of the repairs that they made on my vehicle. Everything is on the invoice.
Okay.
Now, after they fixed all that, that's when I went to go purchase the tires, because at the time I thought my vehicle was going to be running. Obviously, I needed tires. And I thought all of my problems were done. So I purchased the tires. Shortly after that, my vehicle began stalling out on me. It became inoperable. So I took it there for the second time, and then they replaced all the other things on the invoice.
When was that?
That's the one with the ECU. That was when they determined that it was the ECU, and we've come to find out it was bent from the previous total loss accident.
So this June one, maybe. So you went back in June. Okay. So you went back in June and they did another repair.
Yes.
Okay.
So after it began stalling, I had gotten back in contact with the salesman, and we took it back to Carzilla. Carzilla, then the Rada service manager, the guy that they connected me with, had told me he was gonna have a Chrysler specialist come out and donate an hour or two of his time. And they did that, and they were not able to find the problem.
She bought the car.
I then contacted the car salesman that sold me the car, and I got no response. And this vehicle has been sitting ever since my last repair. As the report state, it stalls out. The initial problem was it wouldn't start. We got it to start. Once I started driving it, it started to stall out while driving.
It's a fuel issue, I think.
So I determined that this vehicle is no longer safe or reliable, so I parked it, and it's been sitting ever since. And I've still been making my monthly payments of insurance. I've still been paying for the tires on the car. And I've still been making my monthly loan payment on this vehicle while it's been sitting.
I don't even know what color of car it is. Our new car. Nor do I know what to call it. I know it's a Highlander, and the other car is named Savoy. So what do we name the Highlander? Thanks, Fran. Yeah, I'm hoping that's not the case here. Well, we sold Chip to buy Savoy. I don't think we can reuse the name. Hi-hoy. Just call it Sean Connery.
In Exhibit 17, the last thing they say is after they've replaced the ECU, and you said you're still having a problem, they recommended going back to Chrysler for further diagnostics. Did you do that?
That was when they had their Chrysler specialist come out.
We've requested third-party tech to assist with diagnostics.
That's the Chrysler specialist.
Right. So then it ends with, at this time, fuses, testing the computer, fuel relearn, and misfire monitor system reset have been done. Tech recommends Chrysler dealer to further diagnose vehicle. Did you go back to the Chrysler dealer as they recommended for further diagnostics after all this work has been done?
I didn't have any more money to spend on the vehicle after that. I did not go to Chrysler again.
So we don't know why the car still won't run.
After the Chrysler specialist looking at it and him telling me he doesn't know, no.
What relief are you seeking? Are you seeking just like
What gives him the supposed label Chrysler specialist
That's what I was told through them, their service department.
from Cars on Demand?
From Carzilla.
From Carzilla. So he's not from a Chrysler dealer, and we don't know why they're calling him a Chrysler specialist.
From my information, he's from a Chrysler dealership. And they work with each other, and he was just donating his time to come and look at it, to help give Carzilla, the place that they recommended, insight on this problem.
But the car is sitting and you don't know why it doesn't run.
Correct.
So you don't know if it doesn't run as a result of the accident.
Well, the ECU, which is the main computer, is damaged prior to that accident.
But it's been replaced according to the documents you've submitted to the court.
It had been replaced with a used unit, correct?
Because you wanted it replaced with cheaper version.
That's what they recommended I do.
That's what it says. It says, exhibit you admit, it says we ordered a used one because the client wanted to save money and they programmed it and it seemed like it was going fine. And then now you're saying the car doesn't run, but you haven't found out why.
I was told by them, instead of spending the extra $600 to $3,000 for a computer alone, that we should go with a used one so they can reprogram it.
Sure, but none of that is going to be Cars on Demand's fault. So how do we know the current problem with the car is a result of the accident?
Because the damage was still there from the prior accident when they...
But you had it replaced.
Right.
So how do you say that the reason it won't run is from that accident?
Because they didn't replace all the damage from the prior accident. They replaced some of it.
Well, you have since taken it in and had them do what repairs they could do. So tell me what is not working that's causing the car not to run?
The main computer.
The one that you replaced.
Correct. And before it wasn't working because in the statement it shows it was only getting 6 volts out of the 12 volts. So it could possibly be an electrical issue as well.
So you don't know?
I'm not a mechanic. I can't.
And you didn't bring a mechanic to testify today?
Right.
Even though you have the burden of proof?
Yeah.
Right.
Yeah. Okay. Anything else?
No.
Cross-examination?
Thank you, Your Honor. I do have a copy of Mr. Willis's deposition transcript. If the court would like to have a copy to follow along.
That's what you're going to be using? Sure.
It is. Thank you. How would you like to proceed, Your Honor? You want us to just
dismiss the whole case or what?
If that's comfortable enough, as long as you're in front of a microphone, I think my assistant will accept that.
All right. What did you say previously, and how badly is this going to go for you?
Counsel proceed, Your Honor.
Go ahead.
Mr. Willis, you've never been employed at a car repair facility?
No.
You've never been employed at a facility that sells cars at auction?
No.
Never been employed by an insurance company that deals with property damage, is that correct?
Correct.
You're not familiar with how the state of Michigan handles branding on motor vehicle titles?
No.
You're familiar with that term branding though, aren't you?
Correct.
That describes information that has to be included on the title, such as salvage or junk, that type of category?
Yes.
You've had an opportunity to review the state of Michigan Secretary of State records regarding this 2006 Chrysler Town and Country?
It's a 2016.
2016, I'm sorry, you're right. You had a chance to review those records?
Yes.
There's no record of this vehicle ever being branded or labeled as a salvage vehicle, is there, sir?
No.
You have no reason to believe that Cars on Demand was ever advised that this was a salvage vehicle, do you, sir?
I don't have that information, no.
My question was, you don't have any reason to believe it from any source?
No.
Listen, you did test drive the Town and Country, correct?
Correct.
Did that take an hour?
No.
Didn't you do it a couple of days before you signed the sales contract?
I signed paperwork so I could put my down payment securing that I would have the vehicle.
Listen to what I'm asking you though. The test drive was before you signed the purchase documents. Is that correct?
Correct.
Okay. When you did the test drive, the buyer's guide is posted on the vehicle. Is that correct?
Yes.
As
You
is.
signed the sales documents on November 8th, 2024.
Yes.
Okay. Is it possible that you took the test drive earlier that week?
I don't believe so.
Okay. Did you bring a copy of your text messages that you sent to me?
Yes.
Okay. So look at the first page. This is just to refresh your recollection, Your Honor. You have the first page that starts with, "Hey, Caleb, this is Joe."
Yes.
Okay. And that is dated November 4th, 2024, correct?
Yes, correct.
That's 4 days before you signed the contract, correct?
Correct. So then, yes, I did test drive the vehicle before I did sign the paperwork. Correct.
And it sounds like the test drive was about 4 days before you signed the paperwork, correct?
Yes.
At any time during, and on the day that you test drove the vehicle, you learned that this vehicle had been involved in a previous accident, correct?
I did not learn any of that information. So yes, this is correct.
At any time during those 4 days, between the time you did the test drive with the buyer's guide displayed on the vehicle and the time that you signed the purchase agreement, did you do any research into the motor vehicle history?
No. I had no reason to further investigate. He had already told me that it had been in a minor accident, and he had told me that they only replaced a bumper and a headlight.
Oh, and you didn't include that information, they only replaced a bumper and the headlight?
I have it in the deposition.
Yeah, I'm talking about your complaint?
Yes.
Okay. Do you think you were gone for about an hour?
No, I would say I was gone 10 to 30 minutes max.
Okay. Did you tell the folks at Cars on Demand you had to put down the down payment before they let you take the car, right?
No.
No? Okay. Did you tell the folks at Cars on Demand that you were going to have your own mechanic look at it?
No.
You were aware that you could have your own mechanic look at the car, correct?
Correct.
You elected not to do that?
Correct.
You still have that page of the text in front of you?
Yes.
And the quote that you get on November 4, 2024 is $13,532.00, correct?
Correct.
Do you have a copy of the buyer's guide present in front of you? If you don't, I have an extra copy. Did you mark it as an exhibit? Is what I'm trying to find out.
No, I did not.
Okay. I'm just going to show you an extra copy. This is the copy that we marked at your deposition. Does that look familiar?
Yes, this front page does.
Okay. You actually marked it as Exhibit D, included it as Exhibit D to your complaint, correct?
Correct.
Okay. And you can confirm that that's your signature on the second page?
Yes.
And that's dated November 8th, 2024?
Yep.
Okay, Your Honor, I move for admission of Defendants A, the buyer's guide.
Any objection to Exhibit A?
No.
A is admitted.
Thank you, Your Honor. Right before the big capital letters where it says buyer's guide, it says, important spoken promises are difficult to enforce. Ask the dealer to put all promises in writing. You see that?
Yes.
You never ask Cars on Demand to put anything in writing about anything about a minor accident or headlights, or what was the other thing you said were fixed?
The bumper.
Headlights, the bumper. You didn't ask them to put anything in writing, correct?
Correct.
Okay. The next section that has there's like a box with a check in it. You see that?
Yes.
It says as is, no warranty, correct?
Correct.
You understand what as is means, right? You're buying a vehicle in the condition that it is, correct?
Correct.
Cars on Demand is not making any warranty as to how long the car is going to last or what your experience is going to be with the car, correct?
Correct.
Okay, right below that, it says you will pay all costs for any repairs, correct?
Correct.
The dealer assumes no responsibility for any repairs, correct?
Yes.
And right underneath that, in bold capital letters, it says, regardless of any oral statement about the vehicle. True?
Yes.
If we go down to the bottom 1/3 of that first page of Exhibit A, there's some bold writing that says, ask the dealer if your mechanic can inspect the vehicle on or off the lot. Do you see that?
Yes.
This is the same buyer's guide that was posted on the vehicle when you did your test drive days before you purchased it, correct?
Correct.
Did you ever take the car to a mechanic?
No.
You had the option to do that, did you not?
Yes.
The buyer's guide, the next section of the buyer's guide says, get a vehicle history report and check for open safety recalls. You see that?
Yes.
It says for information on how to obtain a vehicle history report, visit gov/used cars. Do you see that?
Yes.
This is the same buyer's guide that was posted on the vehicle 4 days before you signed the closing documents?
Yes.
And any time within that 4 days, did you ever search any of the websites that you brought with you today? Carfax, Ben Verified, any of those?
No.
You had the option to do that, true?
Yes.
You had the information to enable you to do that, true?
No, I did not have the vehicle's VIN number.
Didn't you have to have the vehicle's VIN number to get your financing from MSUFCU?
That was after I purchased the vehicle. I didn't have the VIN number of the vehicle. Those 4 days, I didn't have the vehicle with me though.
When did you sign your loan with MSUFCU?
That had to have been the night I drove it home.
You had to have had that financing in place in order to buy the vehicle from Cars on Demand, right?
I came with a ready loan check. I didn't need any of that information from MSUFCU.
Right.
So all I had to do was fill out paperwork. I didn't even have to go back to the bank. I was already pre-approved.
In any event, the VIN number is displayed on the buyer's guide as well in the upper right-hand corner, correct?
Correct.
So you did have the VIN number available to you and the source to look up safety information, correct?
Correct.
You simply made the decision not to look up the safety information, correct?
Correct. I had no reason to further investigate after I had talked to the salesman. He had the duty to disclose accurate information when he came to sell the car to me. So when I asked him what had been replaced, I was told a bumper and a headlight. I was never presented the paper.
Excuse me, sir. Let's just do it in a question or answer format here. Now, when you were testifying earlier, I thought you said when you first looked at the car, you saw something off with the bumper and something off with the headlight, correct?
I seen that the headlight was foggy and I seen the other one looked brand new. And I seen that the bumper did not look brand new.
Okay, I thought you said it didn't look level or even.
It didn't look new. It was misaligned. Yes.
Okay. And so that was enough for you to
ask the question of what had been repaired on the vehicle, correct? And if it was in an accident.
Yeah, and he told you it was in an accident.
He told me it was in a very minor accident.
Well, he told you it's in an accident. You saw differences in the headlights. You saw differences in what you call the discrepancy in the bumper, correct?
Correct.
All right.
And again, I was not presented the paper that you guys submitted of the repairs that was made. I was only told it was a bumper and a headlight. So I was told partial truth.
Okay, but you never had them to put that into writing.
Correct.
Okay. And we talked about before about the branding records. Let me show you exhibit number C. This is just kind of housekeeping. If you would turn to the second page of exhibit C, that details the history of transactions for this vehicle by the VIN number.
While they're doing this, we are looking for a little bit of news today.
Yes.
And it says there was no brand that was placed on any title issued by the state of Michigan. Is that true?
Yes.
Okay. Move for admission of exhibit C, Your Honor.
Any objection to C?
No.
C is admitted.
Thank you. Let's talk about
The Tyler
the
Robinson
websites
camera
that you
issue is going to be
referred to
ruled
earlier.
on today, so see what happens here.
Do you have the cars for sale printout in front of you?
No, I do not.
Does the court still have that exhibit? Madam Clerk, Your Honor. Exhibit 19. If you would just look at exhibit 19 while we're going through. Exhibit 19 looks like it was prepared on January 5th, 2026, correct?
Where do you see that at?
Upper left-hand corner.
Okay.
Right. Let's look at the first page on the right-hand column. It says title data provided by NMVTIS. Do you see that?
Yes.
Title brands, 0 records. Correct?
Yes.
That means there's no title branding record of salvage or junk, correct?
Correct.
Let's go to page 2. There's a block there that says insurance records. Do you see that? You see that? You have to answer out loud.
Okay, yes.
Okay. And the source for the insurance records was NMVTIS, correct?
Yes.
The next line says date of total loss declaration or date total loss claim paid. You see that? It's the very next line. Would you like me to point it out?
Yes. Okay.
You see what I just quoted you?
Yes.
Did I read that correctly?
Yes.
What is the entry on the cars for sale website that you have offered as exhibit 19 for the date of total loss declaration or date of total loss claim paid?
It says no total loss record found.
No total loss reportings found, correct?
Correct.
Okay. Let's turn to page 3. There's a large bold capital letters that says title brand information. Do you see that?
Yes.
And there's about halfway down, there's a category for collision. Do you see that?
It's a bad day for me to have bought a new
And
car.
to the right of that, it says no brand reported, correct?
Got my fingers crossed.
Next, 2 lines down from that is disclosed damage, and that is described as the vehicle has sustained damage to the extent that the damage is required to be disclosed under the jurisdiction's damage disclosure law. Did I read that correctly?
Yes.
What does the cars for sale website say for that category?
For which category?
That category I just read, disclosed damage.
It doesn't have any disclosed damage on their website.
No, it says no brand reported, doesn't it?
Yes.
Okay.
The vehicle has a clean title. There's no brands reported. We already know that.
We do. Well, there's not only no brands, but there's also no total loss.
It has junk and salvage descriptions.
We're going to talk about that in just a minute now. You got to wait for the question here. Let's look at the couple pages down. We go to Page 4 is a category like 2/3 of the way down that says junk. Do you see that?
Yes.
And the description for junk is the vehicle is incapable of safe operation for use on the roads or highways and has no resale value except as a source of parts or scrap, or the vehicle's owner has irreversibly designated the vehicle as a source of parts or scrap. The vehicle shall never be titled or registered, also known as non-repairable, scrapped, or destroyed. Did I read that correctly?
Yes.
And the entry for cars for sale says no brand reported, correct?
Correct.
All right. Let's go to a couple pages down to page 6.
But I do also want to state it does
No,
have.
sir, you have to wait for
descriptions.
questions. You have to wait for
Okay.
questions and answers, sir. Look at page number 6 at the top. Very top page says prior non-repairable repaired. You see that?
Yes.
And that's described as a vehicle constructed by repairing a vehicle that has been destroyed or declared to be non-repairable or otherwise declared to be not to be eligible for titling because of the extent of the damage to the vehicle, but has been issued a title pursuant to state law after falling within the criteria for this brand on the face of the certificate of title. Did I read that correctly?
Yes.
And that says no brand reported?
Yes.
Let's go down to the bottom of that same page, page 6. There's a category that says salvage, damaged, or not specified. And it's the description is any vehicle which has been wrecked, destroyed, or damaged to the extent that the total estimated or actual cost of parts and labor to rebuild or reconstruct the vehicle to its pre-accident condition and for legal operation on roads or highways exceeds a jurisdiction-defined percentage of the retail value of the vehicle. Did I read that correctly?
Yes.
No brands reported for that category?
Right.
Go to the next page, page 7. There's a category there in bold capital letters that says totaled. Do you see that?
Yes.
It says a vehicle that is declared a total loss by a jurisdiction or an insurer that is obligated to cover the loss or that the insurer takes possession of or title to. Did I read that correctly?
Yes.
And the report on that is no brands reported?
Takes you back to the Johnny
That's
Depp
correct.
case. Did I read that correctly, right?
The only reference to junk and salvage information is on page 2, correct?
On this document, yes.
Yes, okay. And those are both from the same date, correct? Aren't they
Yes.
both July? So it's not really 2 reports. It's 1 report, or rather 2 reports, but they're duplicate. Do you think?
Well, one says to be determined.
Yeah.
I can't say if those are duplicates or not.
Okay. In any event, it says the category is junkyard. That's talking about who is making the sale. Is that correct?
I don't know if that's who's making the sale, but that's what it's categorized as
And there's-
junkyard.
Yeah, there's nothing else in this report, the cars for sale that you have marked as exhibit 19 that says this vehicle was junk, total loss, salvage, or damage to the point where it couldn't be safely operated. Is there, sir? And if so, please point it out.
On this reporting to the database, no, I cannot see any of that.
Okay. Do you have the Carfax in front of you?
I do not.
I'm going to ask questions about Carfax. Carfax and been verified.
Exactly. Please get those there. Sorry.
Don't have a bailiff. The clerk has to handle
Let's
all
look
this.
at, first, let's look at the Carfax marked as plaintiff's 18. You see that?
Yes.
And if you turn to page 3,
Slimy.
It
It's
has a
slimy.
category that says damage, brands, salvage, junk, rebuilt, lemon. You see that category?
This is lemon.
And for each category following that, it says guaranteed no problem, guaranteed no problem, guaranteed no problem. True?
Yes.
Let's look on page, go down to page 8, and there's page numbers on the lower right-hand side.
Ooh, Stephon Diggs. Now that his court case is cleared,
There.
going to sign on with the team.
There are reports that there was an accident on January 17th, 2025. You see that?
Yes.
That's after you had taken possession of the 2016 Chrysler Town and Country van.
Yes.
Reports damage to the front and to the right front of the vehicle.
Yes. No, it's damage to the one side, the front and the right, yeah.
Okay.
The opposite side of the previous accident.
Okay. Page 8 has records of service to the vehicle. Do you see that?
Yes.
Includes at the very top 12/2/24 thermostat and coolant flange replaced. Do you see that?
Yes.
Was that done at Cars on Demand?
That's where that was the first thing I took it for, and then they did it themselves.
So the answer is yes, and that's reflected in the service. Okay. And then the next entry we see is 3/26/25 Champion Chrysler Jeep. Do you see that?
Yes.
Vehicle serviced, engine checked.
Yes.
There's no entry for January 2025 at Champion Chrysler Jeep, is there, sir? The 3/26/25 service for the engine at Champion Chrysler Jeep is after you were involved in an accident with damage to the front end of the 2016 Chrysler Town and Country. Is that true?
Yes.
April 21st, 2025 is the next service. You see that?
Yes.
That's Carzilla Auto Care.
Yes.
That is again, April 21st, 2025. That's after you were involved in an accident with front end damage to the van, correct?
Correct.
Who was involved in the accident?
With respect to Exhibit 18 Carfax, you have no personal knowledge that anyone from Cars on Demand was notified of this information before the sale, do you, sir?
Well, they would have had to have this information before buying the vehicle.
Why would they? What makes you say that?
As a dealership, they would have superior knowledge of this vehicle.
How do you know? You never worked for a dealership, right? Didn't you tell us that?
Correct.
Okay.
But they sell vehicles, so they would have all the information on the vehicle to be able to sell it to the customer, because how would they be able to sell a reliable vehicle without the correct information?
Well, they'd have to rely on the person that they bought it from, wouldn't they?
Well, they bought it from the insurance auction, and the insurance auction lists it as a total loss vehicle already.
We'll talk about it. Do you have documents from the insurance auction that says it's a total loss vehicle? Not from somewhere else, but from the insurance auction? I'm not looking at the websites now. I want to know if you have something from the insurance auction.
I'm looking for when it was being the total loss. Okay, so it's right here.
You have to say where you're looking.
Okay. Page 2.
Oh, if
Which exhibit is that, sir?
Okay. Exhibit 18, the Carfax. Page 2. Under event 2, it says 8/6/2024 total loss vehicle.
Yeah, that doesn't say it came from the auction house.
It says 06/30/2024 accident reported with another vehicle, disabling damage reported, vehicle towed, airbags did not deploy. That was when it was deemed a total loss.
Well,
it hasn't dated.
Those are two different dates. One is 6/30/24 is the accident, right?
Right.
So the 6/30/24 says it's in an accident, had to be towed, but it doesn't say it's a total loss, right?
It says it's a total loss on 06.
But you're not answering my question, sir. Listen to my question. This entry for 6/30/24 doesn't say anything about total loss. Is that true?
On that line, it does not say anything of total loss.
The next entry is August 6, 2024, correct?
Correct.
It says total loss vehicle.
Correct.
Doesn't say the source of that.
No.
Doesn't say who determined it to be a total loss.
No.
Doesn't say what methods they used to determine it was a total loss.
No.
Doesn't say that information was ever communicated to Cars on Demand. Does it, sir?
No.
Okay. Let's turn to Exhibit 20, the Ben verified. You have that in front of you?
Yes.
Looks like that was created on February 3, 2026. You see that?
Yes.
Shows that the average market value for the vehicle was $11,275.
Correct.
Okay. Let's go to page 4.
And I want to state that that's the average market value, not the value for the VIN on this car. I have the value for the VIN.
Average means some are higher, some are lower, right?
Correct, but not with this accident history.
Okay, and then turn to page 4, the page is in the lower right-hand corner. You with me?
Yes.
Says there's a blue box with a check and bold writing that says no title brands found, correct?
Yes.
Did I read it? And the source is NMVTIS, correct?
Yes.
The categories are junk is one. You see that?
Yes.
Odometer discrepancy is one. It's down at the bottom of that list.
Mm-hmm.
You have to say yes or no for the
Yes.
court reporter. Junk automobile is at the bottom of that column.
Yes.
Inoperable vehicle is in the second column, about 2/3 of the way down.
Yes.
In the third column, collision is 4 lines down.
Yep, I see it.
In the fourth column, 3 lines down, salvage, damage not specified.
Yep, I see that.
So it didn't find any title brand information regarding any of those categories, correct?
Correct.
Okay. And then it does say one possible lien recorded by MSU FCU in November 2024.
Well, on page 3, it does show it has 2 records reported.
That is not what I asked you, sir. I asked you about the lien from MSU FCU.
I understand that. I'm talking about the title brands, but I'm
Okay.
saying it does state 2 records.
Okay, but you have to listen for my question. The MSU FCU lien was November of 2024, correct?
Correct.
I think he's wrapping up here. Hoping he does. This has been a long one. Didn't have an attorney because he can't afford one. He spent all the money on repairing this car that still doesn't work.
And then we look at what you just referenced on page 3. Is that what you're talking about?
Yes, it shows the damage severity. It shows the type of salvage records.
I don't see that. Where do you see that?
Well, we'll start on this
reported?
second line. It says 2 possible accidents reported. The first accident, 6:30, damage severity, disabled. I was told it was a minor accident.
I'm not seeing this.
Right here, under damage severity.
Okay.
I was told it was a minor accident. This states it was disabled.
Okay. But you've seen the photographs from, what was it called, bid something?
Bid car when it was
bid car,
damaged?
yeah.
Yes.
When it was damaged,
Before
sure.
it was
repaired.
Before it was partially repaired, yes.
All right, and then the second one is 1/17/2025, that's your accident?
Correct.
All right, and then below that, it says 2 salvage records
he had an
reported.
accident in this car.
But again, they're the same date, correct?
How did I miss
Yes,
that?
it says 0710, source NMVTIS. It
Right.
says type, junk, and salvage.
Right. So this is a report from Ben Verified, right?
Yes, this has been verified.
And Ben Verified is referring you back to NMVTIS as the source, right?
Correct.
And NMVTIS doesn't say what their source for the information was, do they?
Correct.
You're just going around in circles. One site has something and they refer you to another site and they refer you back to that site. There's nowhere in there that says the source of that information that it was somehow junk or salvage, right?
Other than these descriptions, no.
Okay.
All of these places report to NMBTIS, which is the National Federal Database.
Well, then we would seems like we would find the ultimate source of it somewhere, not just having these websites referring back and forth to each other, right? It seems like there would be one person who said this was either junk or salvage. Would you agree?
I agree, yes, but it has a clean title, but it has junk and salvage descriptions.
I don't know. What is their description?
It says right here, it says date obtained 07/10/24, and it says type junk and salvage.
Yeah, but they don't know. You don't know what criteria was used to reach that, correct?
Well, it had been through the insurance agency for them to put it under the type of junk and salvage.
I will move to strike. I mean, you've already told us you have no experience working for insurance companies dealing with property damage claims. Do you, sir?
Correct, but the insurance is the one that reports this information to these websites.
Well, it seems like we would see that somewhere, and it's not in any of the exhibits 18, 19, or 20. Now, with respect to exhibits 18, 19, or 20, the reports from Ben Verified, Carfax, or Cars for Sale, you could have accessed any of those reports between the day you did the test drive and the day you signed the sale contract on November 8th, 2024. Isn't that true?
That is true.
The information that you have in exhibit 18, 19, and 20 is contradicted by defendant's exhibit C, the state of Michigan licensing records, correct?
Correct.
And you have no evidence as you sit here today that any of this information that you've seen on 18, 19, or 20 was ever provided to Cars on Demand. Do you, sir?
No.
Okay. You were driving the van when you were involved in the accident on January 17th, 2025?
Yes.
January 17th, 2025 accident involved damage to the front end?
Correct.
Did you bring records from Champion with you today?
That's the worst thing. His
yes,
accident.
I have submitted them.
Okay.
All this could
and
be
the only
from his
record I
accident.
saw that you submitted was from March of 2025. Is that correct? My notes say that was that 3? Nope, 14. Do you have 14 in front of you?
Okay.
And this is going to be the initial diagnostic.
Nope, you just have to wait for a question, sir. I'm sorry. Let me show what you have admitted as exhibit number 14. That is the Champion service records, correct?
Correct.
March 27, 2025, correct?
Yes.
After your accident that caused front end damage to the van on January 17th, 2025, correct?
Correct.
All right. You didn't take the van to Carzilla until after the January 17th, 2025 accident, correct?
Correct.
The person at Carzilla replaced, with your permission, replaced the computer with a used computer, correct?
Yes, the computer that had previously been damaged in that accident.
Okay.
Yes.
And then once you replaced it with the used computer, they ran diagnostics on it, correct?
Yes.
Found that the previous issues were repaired, correct?
That is not correct. We got the vehicle to start, but we couldn't keep the vehicle running.
Is that reflected in the Carzilla records when they replaced the computer?
Initially, the vehicle came in, it states on his report, it came in with no start. They got it to start, but we couldn't keep it running.
Okay, didn't he took it for a test drive and he only had one instant of it stalling, correct?
Correct, it stalls at random times.
Yeah, and then after that, they did a diagnostic and were unable to find the source of the problem for stalling. Is that true?
That is true, they could not figure it out.
Okay, and then this guy, the service manager from Carzilla, had a friend who was a specialist in Chrysler vehicles, correct?
He was a service technician that was a specialist, correct?
Okay. And the service technician who was a specialist in Chrysler vehicles also tried to determine what the problem was, correct?
Correct.
He couldn't find the problem.
Correct.
You took it to Champion in March, and they couldn't tell you what the problem was that caused the stalling, correct?
No, I took it to Champion first.
Sure.
And then I took it to Carzilla, who they recommended I take it to.
I'm not suggesting the sequence. I'm just suggesting trying to do a list of all of the service
only thing
experts.
Champion did was diagnose.
You have to listen to my questions. No one from Champion has told you what the problem is with the stalling of the vehicle, have they?
No.
Right. As we sit here today, no expert in vehicle maintenance or repair has told you what the cause of the problem is with the stalling for the Town and Country van, correct?
Correct.
You're not claiming that Cars on Demand had a duty to tell you about the stalling problem, are you, sir?
No, I'm claiming they had the duty to disclose that it was a prior total loss.
Okay, well, we've already talked about that. Okay, and you have no information that would show that Cars on Demand was advised that it was a total loss, do you, sir?
Other than them buying it from the insurance agency, no.
Okay.
The insurance agency would have that information.
The insurance company would. I think that's what you're trying to say, right?
Correct.
Okay, that's fine. I don't want you to speculate as to what the insurance company did or didn't say. I'm just talking about your own personal knowledge. And in fact, you didn't start to have the stalling problem until after you had all these repairs done at Champion and Carzilla. Isn't that what you told us?
The vehicle wouldn't start at first. We got it to start, then began stalling.
Okay, but my question is, you first experienced the stalling problem after the work had been completed at Carzilla, correct?
No, that is not correct.
Okay. You first had problems with the stalling after the vehicle was involved in the front end accident in January 2025, correct?
No, not correct.
Okay.
I was in the accident due to stalling.
Okay. Had you taken anywhere for service for this stalling? I really think that you testified earlier that
Okay,
it
that's
started
different.
stalling after the repairs were done by Carzilla. Are you sure?
It was already acting up. It wasn't starting. It wasn't starting. It was already having symptoms of stalling. I could get the car to start, and then it just stopped starting completely. I had my son born in January, so I stopped driving the car for a short period of time. I have multiple vehicles that I drive.
The reason that you bought the new tires is because you thought the vehicle had been repaired, correct?
Correct. After I had took it to the mechanic, and it began stalling after they fixed the no start issue.
And you bought the new tires in May of 2025?
Correct.
Okay.
Judge is writing out her resignation letter. She's like, I don't get paid enough for this.
Let's talk about the odometer issues here.
The odometer issues aren't an issue, I don't think. He test drove it, had 1 mileage. He had a little paperwork initially about what the mileage was. He came back, it had a little more mileage on it.
Do you have exhibits number 11, 12, and 9 in front of you?
No, I do not.
What's the matter?
There's a Tyler Robinson hearing that's going to start in a little bit.
All right, let's start with exhibit.
Judge should decide if cameras will be allowed for that trial. We're anxious for that.
Exhibit number 11. And I'm going to direct you to the second page. See that?
Yes.
Okay, at the very top, it says mileage 87189. You see that?
No.
The second page?
Right here? That's not an 89, that's 101. 87101.
Isn't that 87161?
No, that's 87101. That looks like a zero. Yeah, because your copy is different than mine. There's two different titles. That's why I'm saying everything highlighted is a title discrepancy. So you're showing me something that's different on that title. This title is the title that you guys submitted.
Okay.
This is the title I bought from Secretary of State.
Okay. And let's look at that title.
Okay.
Even the title that you bought from Secretary of State says 87195 for the mileage, correct?
Here it does. That's correct.
Yeah. It still says 87161 above that.
That says 87101 right there. That's a zero.
Okay.
There's no line right
Okay,
there.
I got it. I do understand what you're saying. Is that your signature in the second box?
Crickets.
Yes. Okay. And the signature in this box doesn't match the signature in that box.
And do you see why? Because you wrote your name under the name of the selling dealer. You see that?
Yeah, and that's crossed out.
It's crossed out and then it's changed to Cars on Demand LLC because Cars on Demand LLC was the dealer, right?
Correct.
Okay. And then the next page is an explanation for that discrepancy.
For that one discrepancy?
Yeah, it says customer accidentally signed his name on the second assignment by licensed vehicle dealer section. Customer signature was crossed out by JTAS president and correction was made in the same box to read Cars on Demand LLC. Don't you agree that's what happened?
That's for that one box, yes.
Okay, okay. So I just want to make clear we're clearing up the title discrepancy. Let me show you what we have marked as Exhibit B. You recognize that document?
No, I can barely read this document.
Okay. Is that your signature on Exhibit B?
I can't even read it, so I can't say here if it is or not.
Let's see the previous exhibits and maybe that one kind of copy. Yeah. Since dated I'm sorry, Exhibit B, and the previous ones we were talking about are exhibits what?
I have Exhibit 11 in my hand right now.
Okay. Can I see that again? And what was the other exhibit? Was it 9?
You had it.
Mary R., welcome to the gallery. Look at that green courthouse. Love it. This is very tedious. We're hoping to get to the end of this here soon. Hopefully get to the Tyler Robinson hearing. That would be nice. I'd cut away from this for that, for sure. Mrs. R.A. bought the car. They were struggling to get the plate off.
You said you can't determine if that is your signature?
No, not on this document because the print off is too blurry for me to read.
Do you know if that was produced as a result of your response to our request for production of documents?
I don't know if I submitted this or you did, but I have the original document right there.
Well, maybe not.
Well, the stock number is 1,000. On the other one, the stock number is 1,001. So
didn't you say there was one that said 1,000?
yeah, there's two different title applications and there's two different titles.
Right.
The stock number on this title application says 1,000. So we need to find the one that says 1,000.
Right. And so which of your exhibits was the one that said 1,000?
It should be.
You have it open.
Exhibit 10.
Approach, Your Honor.
Sure. Mr. Worsley, will you just hand this over, please?
Oh, we've had to replace the bailiff, or the clerk.
Yeah, this is the one I was looking for, Exhibit 10. Is that your signature on Exhibit 10?
No, sir, that is not my signature.
Exhibit 10 shows all the information from MSU Federal Credit Union, correct?
Correct, it does.
And it shows information regarding, does it show your insurer?
Can I see?
Yeah.
Yes, it shows Progressive Insurance.
Do you attribute the difference in the mileage to the mileage you put on the car when you were taking it for your test drive?
Well, I know I didn't put over 100 miles on it.
Okay. Did you ever testify in oath that you attributed the difference in the mileage to the mileage that you put on the car during the test drive?
I obviously acquired mileage on my test drive, so yes.
My question is, did you ever attribute the difference in the mileage to the mileage?
Are you asking, did I look at the difference of mileages?
No, did you attribute the difference in the mileage to the mileage that you incurred, that you put on the car during the test drive? You ever testified under oath to that fact?
Earlier today.
I don't believe I did.
Okay. Do you have that copy of that deposition transcript I gave you earlier?
Yes.
Okay.
6-minute test drive.
Turn to page
100 miles.
43. There's actually 4 mini pages per page, but I'm talking about 43 in the miniature pages.
Okay, I'm on page 43.
Thank you. Page 43, I'm showing you the mileage as 87095 at the very top, dated November 8th, 2024. Do you see that?
Yes.
And then you agreed that you had the ability to go out and look at the mileage on the van on the day that you purchased it?
Correct.
Okay. The number that we see
This might end up in a murder
purchase
trial.
document November 8th is higher than the number on the title Exhibit 3.
Correct.
See that? And when I said that, asked that question, your response was, those are the miles that I put onto it when I test drove, correct?
Correct. I put some of those miles on there. Obviously, I didn't drive it over 100 miles. On the listing, it's at 87,089. I have the receipt of the night I drove home and got the check engine. I have the mileage on this document right here.
What is that?
It says 87,129 miles. That's the night I drove home and I had the check engine. So it's documented. It has my VIN number and it has the mileage of the night I drove the car home. So when I drove home, I had 87,129 miles. So how did I occur 87,195 miles?
I don't know. It looks like you signed it. You signed the document on your own Exhibit 11.
Okay, so then the mileage isn't correct. That shows it clearly. I have the check engine from when I drove it home. That's the mileage when I drove it home. I would have purchased it that night, and I would have drove it home with 87,000 miles and 129 on the dash.
Yeah, but the purpose to.
I didn't buy it with 87,195 miles. No, I did not go out there and check the odometer when I signed paper.
That's not my question. My question is, the purpose of the odometer laws are to prevent a dealer from selling you a car with an artificially lower odometer reading. Do you understand that?
Correct. So then they sold me a vehicle with more miles on it than it actually had.
Yeah. So
which wouldn't be accurate information.
Maybe, but it doesn't hurt you at all. It doesn't defraud you. They're saying that.
How if I drove home with 187 and 129 miles and I bought a car with more miles on it? That's a discrepancy right there. And I have over this whole paper that's highlighted has much more discrepancies on this application. So it's not just this one.
Right, but you did, that was your exhibit that you submitted, right?
Right.
Okay, did you sign that document that it had that many miles?
This is not my signature.
Okay, how about over here? Where are you looking at? Your exhibit number 11. Is that your signature on page 2?
I need that. Yes, that looks like my signature.
Right above your signature, it says 87195.
Which is not correct.
And why did you sign it?
I figured he did his job. He went out there and he looked at the mileage. I didn't have any reason to go double check him to make sure he wrote the right mileage down.
All right, you're not claiming that the odometer reading has anything to do with the damage of the vehicle, are you?
No, I'm claiming that it's the discrepancy of the title application alone itself. I didn't buy this vehicle with this mileage on it.
Yeah, but that doesn't, you haven't suffered any damage.
Other than not having a correct title or a title application?
I'm just talking about the odometer reading.
Well, that would be the damage, is not having the correct information, because this title discrepancy makes me question more on this paperwork.
We just went through the title discrepancy, which was...
This was one title discrepancy,
okay,
yes.
But you had signed it on the wrong block, right?
That's a different discrepancy than the mileage,
okay.
Yes.
Okay. And so you're looking at exhibit 10?
This is exhibit 10. Stock number 1000.
You're not claiming that you suffered any damage from stating the odometer reading was higher than you feel it actually was, correct?
Well, we know it was actually higher because in the original listing, you guys have the original mileage listed at what I test drove it at. This is a way bigger number than what the original listing showed.
My question is, you're not claiming that you were damaged as a result of that. Is that correct?
Well, I'm damaged to the fact that I don't have accurate information.
You had the ability to get the accurate information, right? You could go out and look at the odometer?
I could have, yes.
Okay. And you signed the document saying it was the higher odometer number?
Correct. I did not go out there and look. I had no reason to further investigate because I'm not a car salesman.
Mr. Willis, you're repeating yourself again. Remember what I said?
Yeah.
We're not going to keep doing that.
When you asked in your deposition, I said you don't have any complaint about the odometer readings, do you, sir? And your answer was not to my knowledge. Isn't that true?
That is true. Upon the time, I did not look into all the discrepancies.
Okay. The tires you bought after the repair work was done, correct?
Correct.
And after you had been involved in the January 17th, 2025 accident?
Yes,
You
correct.
certainly could have seen the condition of the tires when you bought the car?
Yes, that is correct. I tried to get new tires, but they would not give me the new tires.
Who's the they?
The salesman.
Okay. Because
so I was able to settle with the brakes and rotors being replaced, but I was not able to get new tires. None of the tires on the vehicle matched.
That's, and your understanding is that's what happens when you buy a vehicle as is, right?
No. You don't usually get tires on a vehicle that don't match on a as is.
You get whatever's on it.
Tires on the vehicle didn't match at the time you bought it, correct?
I did not do a thorough investigation. I asked the salesman everything that had been replaced. That was my duty of investigating. When he told me it was a minor accident, I had no
Sir,
further.
can you just wait for a question? Yeah, why don't you just wait for a question? And so.
I can see the judge splitting the baby here.
A copy of the title assignment similar to
It's going to be one of those over there that you have already.
Okay.
So you're going to have to look through
Exhibit 11. And are you saying the Exhibit 11 is not your signature?
I'd have to compare the two because there's a lot of discrepancies on these titles.
Mr. Tupper, you've asked him twice.
Yeah.
And twice he's affirmed that is his signature on number 11.
Thank you.
Ask a different question.
Yeah, it's because my Exhibit D was the same thing. So I just didn't know where we had a duplicate. Okay, I think that's all the questions I have for you, sir. Thank you for your patience.
Okay.
Yay!
Mr. Willis, now it is your turn to clear up any testimony you want to clear up. It's called redirect. Go ahead.
All right. I have provided the court with physical evidence supporting.
I'm sure, not sure. Are you reading me something?
What was that?
We're not doing that.
Okay.
This isn't closing argument. This is redirect. So you testified. Then he questioned you about your testimony, and there were times where he tried to ask you a question, and you tried to just volunteer information without there being a question, which was not proper. He cut you off. Now it is your turn to tell me those things that you were trying to say in response to his questions that would clear up the test.
Okay, let's take it back to night one. Exhibit 13, the first night I drove home. My check engine light came on before I reached home. So I drove to AutoZone. The mileage on that is 87,129.
I don't know if Exhibit 13 has been admitted. Has Exhibit 13 been admitted?
Yes. I think it was. It was
It says
diagnosed.
yes or no? No, Exhibit 13 has not been admitted. If you want to admit Exhibit 13.
Yes.
Lay a foundation for that.
I would like to, yes.
Lay the foundation.
Said Exhibit 13 is what?
This is the first night I drove the vehicle
No,
home.
it's not. It's a document. What is the document?
This is a document showing that this is the
receipt,
diagnostic
an
report
invoice.
of the check engine.
And where is it from?
AutoZone.
Any objection to the diagnostic report from AutoZone?
Again, this is the first time I've seen this, Your Honor. We sent a request for production of documents for these records. This was never produced before today.
Did you ever turn that over in the discovery?
I believe I brought it up, but I'm not sure if I actually submitted this paper.
Didn't give him a copy of it when you were supposed to be providing everything before trial?
I don't.
Well, I guess I'm not gonna let you give me the exhibit, but tell me what date that was?
It's November 8th, 2024 at 7:32 p.m.
Okay, so that's what you're saying is you went right to AutoZone.
Correct.
Okay. All right, and then what? What else do you need me to know?
I also don't know which title is the actual title. I just know that I bought this title from Secretary of State. But as you can see on the highlighted portions, all of the descriptions, some things filled out, some things not. Some signatures different than others. Some signatures on the paperwork that I know for a fact are not my signature. There's a lot of discrepancies.
This might be the
Even
biggest deal.
on the dates, the date is written out November 8th on one of them, and the other one, the date is written in all numbers.
Sure. So exhibit number 11, you said was from Secretary of State, and you said exhibit number 12 came from Cars on Demand.
Yes.
It is evident that your signature looks different on both of those. Did you sign both of those? Both 11 and 12?
I only filled out one title in one title application.
And which one bears your original signature, 11 or 12, or both?
Just the 11 has my actual signature that I know I signed this document.
What's on 12?
On 12, there are differences.
Are you saying that's not your signature?
Correct.
The judge is looking at it saying, I don't know, it looks the same.
You can see the differences of the signatures. This is exhibit 12. This is exhibit 11.
Okay, I'm sorry, Your Honor, I know I got confused. So you're saying 11 is your signature?
Yes, this is the copy I obtained through Secretary of State.
Then that's the title.
So why do we have two title applications and two titles?
You don't get to ask him a question right now. You get to testify. Okay, so you're saying the document they provided, exhibit number 12, that is not your signature.
Correct.
Okay? What else would you like me to know?
Also on the title applications, there's two title applications. Under the second line, the stock number on exhibit 10 reads 1,000. On exhibit 9, the stock number on this application reads 1,001. Is that two different vehicles?
Obviously, the VIN number would sort that out. You already explained that before. I'm not as curious about that. Let's talk about things that actually affect your case here today. So tell me, you went to AutoZone on November 8th, and then what you just testified to earlier is you called the salesman and he told you to go ahead and bring the car in and they made the repair.
Right.
When did they make the repair?
Order date 11/4/24 at 2:26 p.m. is when they ordered the brakes and rotors. When it was installed.
That was not the question though. The brakes and rotors were ordered before you bought the car. That's not what I just asked you about. I said on November 8th, you said you were driving home. The check engine light came on. Then you said before you could even get the vehicle in for them to address that, something else went wrong.
The radio.
The backup camera. And you took it in and they made a repair. What day was that repair?
I have it right here.
When baby judges are in baby judge school, do they tell them there will be days like this? Or is this just a complete surprise because they don't want everyone to quit?
This one, you can't really read the date on it because it's a receipt that's taken a picture of. You can see it for yourself. It's got the date there, but I can't read out the numbers on it. But you can see 2024. Oh yeah, right there, actually. Was that 11?
Referring to plaintiff's 5, Your Honor.
Yeah, 11/7/2024.
Well, it doesn't make sense if you bought the vehicle on November 8th.
Well, I guess I can't make that out.
It can't be fixing the check engine light and the camera based on your story on the day before you bought it when you're saying those things didn't become an issue till after you bought it.
I don't believe Exhibit 5 has been admitted either, Your Honor.
Doesn't matter. I'm just trying to get him to answer my question.
I had this radio problem after the thermostat. After the original night I drove it home.
Right.
Which was a few days after. And I couldn't get it to him because I was working during that week. So I've been still driving the car with the check engine light. And then this problem occurred. So I took it to him that following week.
So you believe that the repair of the check engine and the backup camera occurred approximately 1 week after your purchase on November 8th? So by November 15th?
Because those two problems are the two problems that they had took care of before I ended up having to go to Champion in Carsville.
So between November 15 of 2024 and January 17 of 2025, when you had your own motor vehicle accident, so approximately 2-month period, what service did you have done in that 2 months?
The thermostat that they replaced, the brakes and the rotors, and
nope. See, you're not listening to me. Listen to the
they
question.
Can't all be winners.
We've already
Josh.
covered that. Between November 15, when all that stuff was already addressed, and the accident you had January 17 of 2025, what repairs were done?
Just the thermostat and the radio at the time.
But you said those were done by November 15. So nothing after November 15.
Correct.
Until you crashed the car in January.
I had already started experiencing the problems.
But you didn't take it in for service.
I didn't. I was paying for my warranty through Athena.
So you didn't take it anywhere for service to address the stalling between November 15 and January 17.
Correct. I had purchased a warranty and I was waiting for my warranty to kick in. I had a 30-day period that I had to wait for my warranty to kick in.
That's not how
And
they
then
work.
after I took it to the shop, because I'm saving money at this point, I'm paying for the monthly payment and my insurance payment. So I had to save money on this brand new vehicle I just paid for. I waited for my
brand new vehicle, used vehicle. Let's be clear about what you got yourself into.
Okay. I waited for my warranty claim to kick in. I had to wait a 30-day period after I had already purchased it. I took it to the mechanic, Carzilla. At that time, I'm trying to use my warranty claim. I'm getting everything in order. I get a call from Athena telling me that this vehicle has been previously totaled. And since it's been totaled, they can no longer cover it. So at this point, I have no warranty anymore. I then am talking to the mechanic and he points out that the ECU had already been bent prior to this damage. Now, when I talked to the Athena people, the warranty people, they gave me the VIN, and that's how I obtained those pictures. The mechanic also searched my VIN.
No, you had the VIN by then. You got the VIN when you bought the car, right?
Right, but
you weren't waiting on Athena or anybody else to give you the VIN, because when you drove that car off the lot, the VIN is all over it. It's in the door frame, it's on the dash, it's probably 15 other places for parts, so people aren't just cutting pieces off. So you had the VIN.
Correct, but I had knowledge of a minor accident and a clean title, no total loss history. That's what was disclosed to me. I was under the assumption that the only thing that had been replaced on that vehicle was the bumper and
don't use the word assumption in here.
Okay.
Do not use that word.
I was told that there was only a bumper and a headlight that had been replaced on this vehicle.
Yeah, you said that.
With it being such low mileage, I did not see a bumper and a headlight being a problem. I was also told that this accident was minor. In the Carfax report, in all of the reports, it shows that it was disabling. It had to be towed from the scene. So that damage alone shows that it was so severe that it didn't even be able to drive anymore. So it had to be towed to the insurance agency, looking how it looked in the pictures. Then Cars on Demand bought this vehicle, and they have repaired what is on the invoice, in which is new knowledge to me that might possibly not be everything that they have repaired on this vehicle. I was told only thing that was replaced on the vehicle after the accident that was described as a minor accident to me was just a bumper and a headlight. I was not told that fenders were replaced. I was not told that radiator core support was replaced or any other things that might not be on that invoice. I also was not shown that invoice of the repairs being made. Initially looking at the vehicle, it looks like a great vehicle.
About
things that did not look new on that vehicle were the headlight, one headlight, and the bumper. The bumper wasn't in terrible condition, but I could tell when I walked up to it that it was not perfectly straight on the vehicle. It had some gapping in it. So that's when I struck the question, has this vehicle been in an accident? What was replaced on this vehicle? That's what I used to make my purchase of this vehicle. I relied on that information that was given to me by the salesman. He had the duty to disclose the full truth and the whole truth when he came up to me to sell me the vehicle. I was given partial truth, and I have the evidence of that because there's more than a bumper and a headlight being replaced on this vehicle. Now, I was not told that this vehicle had been considered a total loss as well. With that information, there's no reasonable customer that would buy a vehicle with this information in accident history reported on it. I paid approximately $13,000 for this vehicle. If I'd known that information, I would have chose otherwise.
You're kind of dipping into making argument. We aren't there yet. So could you just go back to testifying about the facts I need to decide the case?
Judge has heard enough.
I relied on what the dealership told me with them having.
I already said that, and you're arguing again.
This is correct.
Okay.
These are the moments when it helps to have a lawyer. You know what would have made this case perfect? If there was a tree involved. In other news, a Utah Supreme Court justice just resigned today. Stepped down. Apparently
Initially, when I purchased this vehicle,
having a relationship with someone, a lawyer who
I
was
relied
arguing in
on
front
what
of the
they
Supreme
told
Court.
Are we arguing again? Did I just tell you we aren't there yet?
Yeah.
Okay.
We're at the point of you providing your
I believe
testimony
I
about
said.
all the things that happened related to your claim.
Okay. Well, I
When
believe-
you're done, they'll get a chance to present their case, and then we'll have argument
Yeah, we're
about
at the
what
halfway
all
mark,
the things
guys.
mean,
Yay.
all these pieces of paper, the pictures, what you say happened, what they say happened. But are there any other facts that you have not told me that I need to know about in order to understand how we ended up in this spot?
I
Yeah,
believe
tell me.
I've told you all the information.
Okay, then you rest.
Okay. All right, well, it being 4:47, we're gonna recess the case, and I guess we have to set another day to continue the trial. There's a number of exhibits that were admitted, that were collected. I would like to have them back. I want 9, 10, 11, and 12 returned to me. Normally I let people keep the exhibits, but I might want to review them. And you get them at the end of trial, but I just want to look at them.
The defense exhibit admitted some exhibits. as well.
Yeah, there was definitely A and C came in. I have up here 3, 15, 17, 23, 6, 1. I'm missing 18, I believe.
Right here.
Kelly probably has a list than I do of what's been admitted and what hasn't.
We were foiled. We
Yeah,
were
18,
foiled in
19,
the
20
foliage
I need
Friday.
back, as well as 9, 10, 11, 12.
Make sure I
And A and C.
The camo.
A and B were not. I know B wasn't. I'm talking about
There's
C.
9, 10, 11, and 12.
A and C were.
Right. This is 18.
I definitely asked.
A and C were,
Yes, they were.
and that's it.
Right,
For him.
right.
And here's
A and
9.
C, got it. 12, 11, 10,
19, 20.
9, 18, 19, 20. Okay. We got it. Okay, so
Here's the
choices.
question.
I know Monday, if you're available on short notice, I have the afternoon available, Monday for sure. If not, we'll look for something further in the future.
I would lose my mind.
I believe that really.
What about you, Mr. Willis?
What time you said after 12?
The afternoon of
I'm going to end
Monday.
the poll.
It'd be the same time, Your Honor, too?
Pardon?
2?
1 o'clock, 2 o'clock?
1 o'clock, whatever, is whatever works for the court.
Let's do 1:30.
Sure.
Monday, 1:30?
That's this following Monday.
Yep.
Okay.
So we can just keep going before I forget everything you told me. Although I took a lot of notes.
Going and going. Buyer should get his money back. 40% of you say that. Split it, make them both pay 27%. I'm never buying a used car again. That's 17%. And the seller, because it was sold as is, just
If you
16%.
really want to, let him use the one over here. But yeah, we don't really have public restrooms up here, which is just one of the pleasures of our very old building.
There we go. Lawyer goes home, runs to the little lawyer's room. We are just at minutes away from what we expect to be an interesting ruling in the Tyler Robinson case. The judge in that trial is expected to make a ruling here in just a couple minutes, and it might be very fast, as a matter of fact. Tyler Robinson. Might be very fast, and it may we may find out very soon if we get to have cameras or not. Let's see. Who's there? See, I think we get cameras today. We're hoping anyway. I'm not seeing it yet. Okay. But we'll keep an eye out for that. What's this about a judge stepping down? Well, Utah Supreme Court Justice Diana Hagers resigned today, effective immediately. She stepped down after, there were some concerns. Maybe a little investigation was going to happen because she was involved in a relationship with a lawyer that argues in front of the Supreme Court. And the lawyer argues in front of the Supreme Court on an issue that lawyer won. He won the case in front of the Supreme Court. Now, she had recused herself, and I think she did that in time, but it just doesn't look good. This is in the great state of Utah, where we just had the Corey Richens trial. So that's exciting. New car's name is Greeners, but due to Grandpa Brain, Ari will keep calling it Red. I don't even know what color the car is. It's gonna show up here, and I just won't know. Need to live stream the arrival of the new car. I don't even know where they're going. I mean, I think they're coming home, but all right. Let's see. Spicy Judge waiting for some sort of that's not it. A purple Highlander? No. New car will be called Bob. Not sure. Great case you picked. Yeah. I'm worried sick that she bought a lemon. I don't think she did, but she didn't like the guy she was buying it from. Is there a name for the goose? The goose is being named Greeners, I believe. I'm not sure if that's final. The poll's been sort of neck and neck. I see what I did there. Neck and gooseneck. Ari has a full-blown news station in his office. I do, as a matter of fact. I've got everything going and a little bit more. So, welcome your new goose overlord. That would be Greeners. So after an entire day of talking to the wrong IT folks, now I'm waiting for the correct IT folks to contact me. Hey, Amber, you asked for the problems to continue, and they did. So you can't really complain. The car name is Cow, Highlander Cow. So it's a little tribute to the Scottish roots. Needs a Scottish name. Call it Loch Ness. Remember that its counterpart, the Yukon XL, which we owned, which we have right now, is named Sahoy, and so the two names have to sort of go together. I like Cow. Cow works. But what if it's like blue or purple? I've never seen a purple cow. I never hope to see one, right? But I can tell you anyhow, I'd rather see than be one. Matey, we decided. Matey is a good name, I think. Let me see if I can ask my wife what color the car is. Okay. Hey, can I put you on the air? Is that okay? Okay. Hang on. I'm bringing you on there so I can hear you. Say
What?
You're on the air. What color is the car?
It's dark.
Is it splotchy like a jersey?
It's not too splotchy. I can't get past my frustration with the human factor of it. So it's like a dark gray, and I want to kick the guy in the shins. That's about where I am on that.
And you gave him all the money?
Yeah, I did. And actually, he was very funny. As he's counting out the cash, he has a marker, and he's marking each one of the bills to determine whether or not they are fake.
Yes.
Oh, yeah, he's quite certain that I am just trying to screw him over. And as he's marking these bills, our son is watching him. He gets through all the bills, sees that none of them are fake, and has such a look of disappointment. He was so upset that he couldn't say they were fake or there weren't enough of them or whatever. Just thought, you are a piece of work.
Did we give him the two $20 bills that are worth more than their face value?
Heck no, we did not.
Good. We have two $20 bills that have, I think, like five. Oh, hang on. We need to take this. Sorry, we've got a hearing going on, Jen.
Oh, okay.
Okay.
That's okay.
I love you.
I love
see you soon. Bye.
Okay. Bye.
Sorry, we've got court. Court is about to happen here. Let's see. This is the Tyler Robinson here. I'm just trying to look and see who all's going to be here. The judge. Got some attorneys. I see Miss Nestor is there in the top right-hand corner. We've got some prosecutors. Okay, we'll be joining them here in just a moment. We'll keep an eye out on that as we're waiting. We've got the audio going, so when court happens. Nice job of adding the I love you before I booted her. Yeah, I know. Priorities. So it's gray. It's a gray car. Gray car. I think it works. Just saying I'd be okay if you named it Greeners. I'm not sure if Mrs. RA would roll with that. What more could you possibly add to your equipment? To this? Oh, where do you want the? Should I email you the list? No, there's lots of stuff. The Gray Goose. We could call it the Gray Goose, which I think we could get sued for. Isn't Gray Goose like an actual brand name and all that? Okay. Gray's the new green. Still weird how she didn't mention the death in her family in the Robinson motion, but she did in the Richlands request to delay. Who's popping on? We got some people here. It's gonna be crowded. All right, let's see. Give us a minute here. Sohoy and Mady. Mady's pretty good. This that we're watching out here is a WebEx. This is live. This is out of Salt Lake City, Utah, at the courthouse, and we are expecting. You see Miss Nestor. She was the attorney for Corey Richens. She's in the top right hand corner, way up there. She's also the attorney for Tyler Robinson. In this hearing, the judge is supposed to make a ruling, and I hope it's quick, but he's supposed to make a ruling. There's the judge on the cameras in the courtroom. He turned his camera on. He must be ready to go. Let's see if we can get everyone's cameras turned on here. There's Ryan McBride. Welcome, Ryan. Judge, I think the judge wants transparency. Here we go.
Good afternoon.
Hey, Judge.
Court is now in session. Calling case number 251-501-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Go alphabetically.
Ryan McBride, Chad Grunander, Jeff Gray, Chris Ballard, David Sturgill, Lauren Hunt for the state.
Good afternoon.
Michael Burt, Richard Novak, and Stacy Visser for Mr. Robinson.
Good afternoon to you.
Good afternoon.
Jeff Hunt and Carissa Erisk for the news media, Your Honor.
Way to go, Jeff.
Good afternoon. And Mr. Robinson, are you with us?
I think they waived his appearance.
Let's try again.
County
Mr.
Jail.
Robinson, are you joining us this
Bottom right.
afternoon? Good afternoon to you, Mr. Robinson.
Cameras off.
All right, before the court issues its rulings, the court is wishing for an update on the status of discovery to the state.
Yes, Your Honor. We continue to receive and provide discovery. The materials that were brought up at the last hearing, the DNA files, the ATF DNA files have been transferred. I think the defense is making their way through those. We provided much of those in digital format through an online sharing process. That wasn't workable, so we provided a jump drive with those materials from the ATF. We consistently hit the 100% mark where we provided everything that we have received, and material continues to come in, so we continue to provide that. So that's the status of discovery. FBI is still responding to the special discovery request. I expect to have that response within the next couple of weeks. They asked for some time when I spoke to them about 3 weeks ago. So we expect to have that response quickly as well.
Ms. Nestor, do you agree?
Defense, did you want the benefit of the record?
Special discovery matters that Mr. McBride was just referring to were the DNA files from the FBI. I just want to make sure we clarify that for Your Honor. And also, I think we just received 1,600 files either today or yesterday. I believe today. And that's all.
That's a lot of files.
Thank you.
Light reading for the weekend.
All right. Prior to the court's rulings on the two issues before it today, the court acknowledges the quality of the briefing and the professionalism and civility during the presentation of evidence and during the oral arguments.
Good job, attorneys.
The court has taken the necessary time to consider the evidence before it and balancing the constitutional rights of Mr. Robinson and Ms. Kirk. These rulings take into consideration these important constitutional rights. I will begin with the ruling in order on defendant's motion to vacate or continue preliminary hearing pending discovery and to permit constitutionally adequate time for preparation. And I will be reading from my order and will be uploading the written orders very soon after this hearing concludes. Per the state's request during December 11th, 2025 hearing, the court scheduled a preliminary hearing for May 18th and 19th and 21st and 2026, but noted that the date was not set in stone and could be moved if needed. Defendant now seeks to continue the scheduled preliminary hearing via his motion to vacate or continue preliminary hearing pending discovery. For the following reasons, the court determines that a continuance is both reasonable and necessary to safeguard defendant's procedural rights.
Here's a delay.
While ensuring the orderly and fair administration of these proceedings with due consideration for the interests of the victim representative, the parties, and the public. The purpose of a preliminary hearing is for the prosecution to present evidence from which the court may find a probable cause to believe the crimes charged have been committed and the defendant committed it. And I'm going to omit the citations, but that will be in the written ruling. A preliminary hearing serves the essential purpose of ferreting out groundless and improvident prosecutions early in the process. Indeed, the preliminary hearing is a fundamental procedural right guaranteed by Article 1, Section 13 of the Utah Constitution. The decision to continue a preliminary hearing rests within the sound discretion of the trial court. Generally, a continuance is considered reasonable when there is a showing of good cause and the request is made for legitimate reasons. The court notes that the May preliminary hearing dates, which allotted some 5 months between the scheduling of the prelim and the hearing itself, was set as a goalpost for the parties and to preserve time on the court's calendar. This is defendant's first request for a continuance, and given the volume of discovery, the request is neither unexpected or unreasonable. At the time the present motion was filed, the digital electronic discovery had reached 12 terabytes. The defense counsel estimated they would need at least approximately 60 days to conduct initial review and possibly hundreds of hours to conduct a comprehensive review. Substantial discovery continued to be produced as of March of this year. The court recognizes that additional delay imposes real burdens on the parties, the victim representative, and the public's interest in the timely administration of justice. A defendant's constitutional right to effective assistance of counsel is no less important at the preliminary hearing than it is at any other stage. Providing defense counsel sufficient time to review the extensive discovery is necessary to ensure effective representation, and under the circumstances presented here, establishes good cause for a continuance. The scope of a preliminary hearing, however, is admittedly narrow and utilizes the lower evidentiary bar of probable cause as opposed to beyond a reasonable doubt. Furthermore, the court must view all the evidence in light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution for purposes of making the requisite bind-over decision. The preliminary hearing is not the time to weigh credible but conflicting evidence. Accordingly, any future requests for additional delay to obtain further expert analysis, such as DNA testing, must be supported by a particularized showing that the requested analysis is reasonably necessary to the fair resolution of issues, particularly where the existing evidence is sufficient for the limited probable cause determination at issue. The court is also mindful of the impact a delayed trial or delayed hearing may have on the victim representative's constitutional rights. To mitigate this impact, under Utah Code Section 77-38-7 sub 3, directs the court to consider the interests of the victim of a crime to a speedy resolution of the charges under the same standards that governs a defendant's right to a speedy trial. The court remains committed to the victim representative's interest in the speedy disposition of this case, just as it is committed to protecting defendants' constitutional rights and maintaining the fair and impartial administration of justice. The court also concludes that the revised hearing dates reasonably balance defense counsel's need to review the presently disclosed discovery with the victim's representatives in the public's interest in the timely progression of the proceedings. Therefore, the court grants defendant's motion and reschedules the preliminary hearing for July 6th, July 7th, the afternoon of July 8th, July 9th, and July 10th, 2026.
So July
in order
6,
to
7, 8, 9,
protect
10.
the defendant's constitutional rights while minimizing unnecessary delay and preserving the fair, prompt, and impartial administration of justice. This is the order of the court.
And he says no
Counsel,
more
that
delays.
concludes the first ruling of this court.
Here's the second one. The second one's a big one. This is the cameras in the
Court
courtroom.
now turns to the second issue before it, ruling in order on defendant's motion to exclude still photographers, TV cameras, and microphones from the courtroom, and standing order on electronic media coverage requests. One moment, I need a little bit of water before I start reading the next one.
This judge, while he takes a sip of water, graduated from my alma mater, Weber State University. We got his master's degree.
Before the court is defendant's motion to exclude still photographers, TV cameras, and microphones from the courtroom. Defendant seeks an order categorically prohibiting any electronic media coverage during the pendency of this case. Because defendant has not shown that a categorical ban on electronic media coverage for all proceedings in this case is allowed by Utah law, defendant's motion is respectfully denied.
Just denied.
At defendant's request, the court held an evidentiary hearing where Dr. Brian Edelman, a trial consultant, and Dr. Christine Ruva, a cognitive psychologist, testified in support of defendant's motion. Dr. Edelman conducted a survey of 200 people in Utah County and prepared a report with his assessment of the local community's consumption of media coverage of this case. His base findings reveal that 99% of the community members recognize the case and that 64% believe defendant is guilty based off what they have heard, read, or seen in the media. He examined press coverage of the hearings that have taken place since defendant's initial appearance in court and discovered that only about 25% of the viewers watched the live stream of the court hearings. A majority of the remaining viewers consume media commentary of the live stream recordings over social media and local television news sources.
That's us.
According to his research, the commentary from established news media does not provide a neutral summary of court proceedings. Rather, headlines and talking heads typically focus on out-of-court statements made by attorneys and prominent members of the community and country. As a result, viewers are led to believe that the comments made out of court, such as the comments about unadmitted evidence, are made during a court hearing and part of the criminal case. According to Dr. Edelman, this commentary primarily supports the prosecution's narrative and is used as entertainment, sensationalism, and commercialization rather than to educate the public on what is occurring during the court proceedings. Dr. Edelman also expressed concerns that media coverage of the security measures used during the court proceedings, combined with cameras in the courtroom, will be added pressure on the potential jury pool and contribute to potential jurors' reluctance to serve on a future jury. During cross-examination, Dr. Edelman testified that viewers who watch the live stream, usually on social media and streaming sites, are inundated with commentary from other viewers spreading misinformation. Although the commentary is being made by the public, it is not generated by the live stream itself. In his view, the commentary would not exist without the live stream of court proceedings. Dr. Edelman's opinion is that continued media coverage, electronic media coverage of court proceedings will perpetuate prejudicial and misleading views of the defendant and the evidence and affect defendants' fair trial rights. Dr. Ruva testified that she specializes in the study of jury decision-making, specifically how pretrial publicity affects memory and the deliberative process. Among other concepts, her studies focus on source primacy of pretrial publicity, which indicates that if jurors are front-loaded with the extensive amount of negative pretrial publicity toward a defendant, it is difficult to overcome their initial biases, even if presented with positive publicity about the defendant or negative publicity about an alleged victim. Dr. Ruva examined the pretrial publicity reference in defendant's motion, which she summarized as provoking moral outrage and predominantly anti-defendant, full of dehumanizing language and accusations of guilt. Dr. Ruva explained that the jurors have a high amount of confidence that the information they use to reach a verdict is based on evidence that was presented at trial. However, research shows that jurors' memories cannot distinguish between what was heard at trial and what was heard from pretrial publicity. Jurors may even unconsciously distort evidence they hear during trial to align it with slanted information they heard pre-trial. Because video and audio sources of pretrial publicity result in more emotional responses, these sources are better remembered than other sources of information. Dr. Ruva's expert opinion is that live streaming of all proceedings can lead to deep-seated bias in juror deliberations. And while juror questionnaires can help eliminate jurors with the explicit biases, they are not effective at identifying implicit biases. Dr. Ruva concluded with her expert opinion that to a reasonable degree of psychological certainty, this case is situated within a highly prejudicial pretrial environment that presents a substantial risk to juror impartiality. Based upon this evidence and an evaluation of the factors listed in Rule 4-401.01 of the Utah Rules of Judicial Administration, defendant argues that exclusion of electronic media is necessary to ensure Mr. Robinson's right to due process, to a fair and impartial jury, to counsel, and to be free from unreasonable searches and seizures, and to be free from cruel and unusual punishment as required by the 4th, 6th, 8th, and 14th Amendments to the United States Constitution and Article 1, Sections 7, 9, 10, 12, and 14 of the Utah Constitution. Members of the media, like members of the public, have constitutional rights to access criminal proceedings. Again, the citations will be in the order that will be filed. I will not read them right now. However, like the public, the news media does not have a constitutional right to photograph or video record public hearings and trials. Once beyond the confines of the courthouse, a news gathering agency may publicize within wide limits what its representatives have heard and seen in the courtroom, but the line is drawn at the courthouse door. Although electronic media coverage is not protected by the Constitution, neither does the Constitution ban electronic media simply because there is a danger that, in some cases, prejudicial broadcast accounts of pretrial and trial events may impair the ability of jurors to decide the issue of guilt or innocence uninfluenced by extraneous matter. Electronic media coverage provides a means to facilitate the public's right of access to court proceedings for those who cannot physically occupy the limited space available in a courtroom. Live streaming in particular allows as many people as are interested to observe the justice system at work and hold our branches of government accountable to the guarantees of due process. Defendant argues that the decision whether to allow electronic media coverage is governed by Shepard v. Maxwell, which held that there is a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial. That the court must take remedial measures to abate any threat to the fairness of the proceedings. Defendant argues that because video recording and streaming of court proceedings creates a reasonable likelihood of prejudicing defendant's right to a fair and impartial jury, this court should ban courtrooms for the remainder of the case.
Ban cameras in the courtroom.
This court should ban media in the courtrooms for the remainder of the case. Consistent with Shepard, the court has taken remedial measures to abate threats to the fairness of these proceedings. For example, the court has positioned the video camera to the back of the courtroom, which has minimized, if not entirely mitigated, the potential for media to capture conversations at counsel's tables and documents on counsel's computer screens. The court has issued a robust decorum order to manage the proceedings and a pretrial publicity order to prevent statements from attorneys involved in the case from potentially prejudicing the jury pool. Rule 4-401.01 of the Utah Rules of Judicial Administration governs the court's determination of whether to grant or restrict electronic media coverage. The rule allows a news reporter to file a written request for permission to photograph or video record public proceedings. The rule creates a presumption that the permission will be granted as long as the predominant purpose of the electronic media coverage request is journalism or dissemination of news to the public. Defendant argues there is no presumption of electronic media coverage because the predominant purpose of dissemination of the court hearings in this case is not for journalism or the dissemination of news. Rather, it is for entertainment, sensationalism, and the promotion of commercial products. Defendant provided many examples of media outlets using footage of courtroom proceedings as background or as a springboard to discuss out-of-court commentary by public figures, opine on the relevance or existence of evidence that has not been admitted or presented in court, and generally vilify the defendant. The state referenced social media posts that have used media coverage of the case to promote conspiracy theories and to denigrate Charlie Kirk and his family. No evidence was presented by either party showing a media outlet using live media coverage to educate the public about the progress of the legal proceedings or the justice system as a whole. This court is not so cynical as to conclude that just because the parties did not present evidence of responsible journalism, none exists. Defendant did not interrogate the use of the live stream of prior court proceedings by the news reporters who filed the electronic media coverage requests under Rule 4-401.01. Applying the plain language of the rule, it is the motives of these specific news reporters, the requesting reporters, that the court must question, not the entire universe of media outlets and social media sites that have published information or misinformation about this case. Because under Rule 4-401.01 sub 2A, the court must examine the motivations of specific news reporter who request to photograph or record the proceedings. Defendant's request for a blanket finding by this court that there is no presumption of electronic media coverage is respectfully denied. The court must determine whether the presumption applies on a request-by-request basis, depending on the predominant purpose of the requesting news reporter. Determining whether there is a presumption of media coverage is not the end of the analysis. The judge may prohibit or restrict electronic media coverage in those cases only if the judge finds that the reasons for doing so are sufficiently compelling to outweigh the presumption. The rule then lists 9 factors, some or all of which the court must consider to determine whether to limit electronic media coverage of court proceedings. Defendant argues that because the rules uses the phrase "in those cases," the court has authority to weigh the listed factors and find the presumption of electronic media coverage has been overcome for the pendency of a case, regardless of the type of the proceeding held. Reading the rule as a whole, the court disagrees with the defendant's interpretation. The court interprets the phrase "in those cases" to mean the same thing as "in those situations," where there is a presumption of electronic media coverage. The court's interpretation is consistent with subsections 2C and 2D of the rule. Subsection 2C requires the court to make particularized findings, denying or granting a particular request. And subsection 2D requires that those particularized findings to relate to the specific circumstances of the proceeding rather than reflect generalized views or preferences. Court proceedings vary in character and substance, ranging from scheduling conferences to oral arguments to evidentiary hearings and to the trial itself. The dangers of prejudice and the newsworthiness of the proceeding may vary considerably depending on its nature. Therefore, because the court must make a particularized finding about specific court proceedings that are the subject of a news reporter request, defendant's request for a categorical finding that the presumption of electronic media coverage has been overcome is respectfully denied.
Every time he says
the court must make the appropriate findings on a request by request basis. Unless otherwise ordered by the court, Rule 4-401.013A requires news reporters to file an electronic media request at least 1 business day before the court proceeding. 1 business day is insufficient time for the parties to object to electronic media coverage or for the court to weigh the appropriate factors and issue a decision. Therefore, the court enters the following. This is the standing order on electronic media coverage. News reporters are required to file requests for electronic media coverage of court proceedings at least 14 days before the scheduled proceeding. The request must be consistent with all other provisions of Rule 4-401.01. Any request that is filed later than 14 days before the proceeding may be summarily denied. All requests will be filed in the docket. If a party seeks to suspend or restrict electronic media coverage of a court proceeding, the party must file a motion under Rule 4-401.01 no later than 10 days before the proceeding. The motion must address the particular circumstances of the proceeding and be no more than 4 pages in length. The opposing party may respond to the motion no later than 5 days before the proceeding. The response is limited to no more than 4 pages in length. Any reply must be filed no later than 3 days before the hearing. The reply is limited to 3 pages in length. No oral argument on the motion will be held. The court will issue an order before the proceeding, and if the request is denied, issue particularized findings denying the request. The evidence presented at the April 17, 2026 hearing and all arguments already in the record are preserved. This is the order of the court. This concludes the reading of the second ruling of this court.
That's a mess.
All right, counsel.
That's a mess.
What I want to turn to next is addressing the outstanding motions. As we are vacating the preliminary hearing, which is set for, I believe it's May 18th, the week of May 18th, that frees up time to address outstanding motions. And the court wishes to make best use of the time as you were previously scheduled to be there. So I'll turn to the parties to hear from you in determining if the parties will be prepared to address the motions that are outstanding. Turning to a defense.
The judge just stuck himself between every
Your
single
Honor,
media
I believe,
outlet.
are you talking about the ones that have been fully briefed at this point?
Individually.
That's correct, or anticipated to be fully briefed before that week begins.
Yes, Your Honor, we can be prepared to do that.
All right, and to be clear, do you want to put on the record the motions that you wish to address at that hearing, just so all parties are on notice and we know how we're proceeding?
Give me just a minute, Your Honor, and I'll pull them up. I know one of them is the motion for the order to show cause and compel discovery. I know that one is pending right now. Just 1 minute, let me pull them up.
Kathy, while you're doing that, Your Honor, I show 3 outstanding motions. The one is the motion for an order to show cause and contempt. That is fully briefed. I believe that's ready to be argued. Actually, I think that's a notice to submit without argument is how it's been submitted. The second is motion to close the preliminary hearing and seal exhibits. That was filed May 1st. We intend to use the full 2 weeks to respond. If the defense intends to reply, the reply will be, I believe, the 21st, which will be the day before the current preliminary hearing dates end. So I don't know if they intend to waive that reply time and argue it at that time or not. And then the final one is the recent motion the defense filed to find the use of hearsay at the preliminary hearing unconstitutional. We intend to use the full 2 weeks to respond to that. It also hasn't been served on the Attorney General's office, so that one will not be ready by the time of our preliminary hearing dates. We're going to have to find another date for that. We've also objected to the motion to close the prelim and seal exhibits because our objection is that it's not specific enough. We don't know which exhibits that is. So that issue needs to be resolved too before it can actually, from our view, be argued and decided upon.
All right, thank you, Mr. McBride. Turning to Ms. Nestor.
I do think we were waiting on their supplemental exhibit and witness list, which we have received. I don't know if they're still going to update it again, but that's one of the things we were waiting on before we identified which matters needed to be sealed in the preliminary hearing. So I know we could perhaps get together and talk with the prosecution about whether they anticipate adding any additional exhibits. And then we can probably specify which exhibits we think, but we had to leave it open because we didn't have their final exhibit list until within the last, I think, 2 days. We would be prepared to argue the motion to show cause and the motion to close the preliminary hearing. I do believe we either have, and I would defer to Ms. Visser, I believe we either have served the Attorney General or we are just about to serve the Attorney General, but I do anticipate that one might not be ready to argue by the week of the 18th. That one probably, I would agree, may need an extra date, but it would need to be heard prior to the preliminary hearing because it deals with whether some of the 1102s can be presented at the preliminary hearing.
All right. So my understanding is it sounds like the parties will be ready for defendant's motion in limine to close portions of the prelim. Is that correct?
Yes, Your Honor. And we will, we can supplement with specific exhibits now that we have their final exhibit list, I believe. I'll talk with the prosecution and our team, but I believe we can supplement that.
All right.
Chad Grunetter, I'll add on to that. If it is supplemented, Ms. Nestor, it would probably need to be done rather quickly as the preliminary hearing dates or the previous dates are a week from Monday. And we would like the time to brief that and be on appropriate notice. I would imagine the media would have similar concerns, but so Judge Graff, I'm not entirely sure if we'll be prepared to argue that motion on the dates that are open for Your Honor, but we can work towards that.
May I add, Your Honor, this is Jeff Gray.
Yes, Mr. Gray.
Notice to the Attorney General's office. They may choose or may not choose to respond. They're not required. They're required the particular notice, and we'll be talking with them. If they're satisfied with our response, they may choose to stay out of this at this point, but we still need to consult with them.
I also, Your Honor, just want to make clear, we don't necessarily, we serve the Attorney General out of an abundance of caution, but we do think since it involves a rule of procedure, it may not really be required to serve the Attorney General under the statute, but we did it just out of an abundance of caution. So I don't want to make it look like we're conceding that notice is required, although we are doing it.
I see. Certainly our position is that it is required.
All right. Well, I appreciate the parties sharing their views. Well, let's go ahead and tentatively address the motion to close the preliminary hearing, and we'll address that. How does May 19th at 10 a.m. look for the parties?
That's the first one we need to request for, May 19th. That doesn't.
Your Honor, the defense was planning on being available the whole week for the preliminary hearing, so I feel fairly confident that my team is going to be available on that day.
All right. To the state.
What was the date? May 19th. What time? It's not
All right,
14
we'll go
days
ahead and
away.
start at 9 a.m. on that day. And just to set the expectations, we'll plan on a 3-hour hearing. So from 9 to 12. And so I would ask that that you're fully prepared to go forward at 9 a.m. And to Ms. Nestor and your team, is it your request that Mr. Robinson be present physically in court?
Yes, Your Honor.
All right. All right.
Your Honor, this is Jeff Hunt. The media will want to be heard on that motion. I believe Mr. Judd is online, and he will be taking the lead on that. I'm not sure of his availability that day.
All right.
Be available.
Mr. Judd.
Hi, Your Honor. I am here. And yes, I'll make myself available that day.
Thank you.
I did, without taking any more of the court's time than is necessary, wanted to talk about one small detail. I appreciate the court's ruling saying that
we need 14
under
days.
the new order being entered today, a request to cover a hearing would need to be submitted 14 days in advance. That would only create problems, I think, with the one we're talking about today.
Right.
I wonder about a request to do that. If the media were to submit that as soon as they could get their ducks in a row collectively, would that be enough for the court in this case?
Yes, and I recognized when I was drafting the ruling that the one conflicting date would be this upcoming one. So I would request that the parties file, well, to be fair, until there's a request from the media to cover it, that wouldn't even come into play. Theoretically, if they choose not to file that becomes moot. And so for this hearing only, as soon as that's filed, please file anything that you wish to be considered as soon as possible to allow the other sides to reply. So please don't wait till the day before. If it's filed, I would say within 48 hours of the filing of media, the request for electronic media coverage, within 48 hours, parties who wish to file, please do so. Thank you, Mr. Judd. I appreciate you addressing that. And the court's obviously going to be flexible about that issue given the short turnaround.
Thank you, Your Honor.
Judge Michael Burt for Mr. Robinson. Could I raise one issue concerning the court's order on the procedure going forward? Is the court requiring that we be notified of the requests, or do we have to get that from the docket? Given the short amount of time that we'll have to respond, I'm wondering if the court would consider ordering, if it hasn't already done so, that we be provided notice of any requests when it's filed.
Well, wouldn't you be receiving, do you receive notice when the request is filed on the docket?
Only when it's issued by the court, Your Honor. We don't receive notice of the requests.
Oh, this is terrible.
I see. Well, let's see here.
This is so bad. I would have to
No,
serve
that's a good question.
every single
Mr.
lawyer.
Burt, I appreciate you asking that. Let me just take a look at what options we may have to address.
The judge has said he's going to personally decide
each
case with each media
on the
outlet.
onset. We have the deadline. I mean, we have given the deadline set by the court. There's a timeline in place, and so I would ask the parties to be cognizant and take a look at the docket on the date when that deadline is approaching. For now, please refer to the docket. If this becomes an issue, please let the court know. But I would ask the parties to be diligent as you have been in the past. And when you see that hit the docket, if you wish to file, you certainly can.
Thank you.
Yeah, this is Ms. Nestor. I do have one more clarification. So the motion of the order to show cause, can we not just argue that the same day that we argue just because of the travel and expense to the county? I'd like to try to do that at the same time. We did file a notice to submit, but we've not waived argument on that.
Let's see here. I wanted to pull up that motion briefly.
This is a pain.
There's a few things on the docket, so it takes just a little bit to get there.
No worries, Your Honor. I don't anticipate there would be any testimony at that. It would just be argument. So we shouldn't need too much more extra time.
All right, I see. One moment.
The judge just created so much work for himself and everybody else.
So what you're saying is you're not requesting an evidentiary hearing. You're simply requesting oral argument. Is that your understanding?
That's correct, Your Honor.
Well, I believe that the procedure is that if I rule on the motion and I grant it, we do need to take an evidentiary hearing because sanctions are being requested. And so I would want to follow the procedure so it would necessitate an evidentiary hearing, not just oral argument.
That would be my understanding. That would be later. So this is just a hearing to determine whether or not to set the evidentiary hearing is my understanding. So yeah, right. So that would be on a later date.
Okay. Well, we can address oral argument for that and then the court will make its ruling and take it from there. Obviously, I'm not weighing in either direction. I want to consider everything that's before me, but we'll set the oral argument as well on that same 19th date and address that issue as well.
Thank you, Your Honor.
Anything further from the parties?
I don't think so.
All right. Thank you to all parties for being here. This concludes today's hearing, and court is now in recess.
Okay, this is terrible. It was going really, really good until the very end. Let me tell you what just happened. The judge denied all defense requests to ban cameras in the courtroom. He said, no. But the court does have a responsibility to make sure that the use is appropriate. He put himself as the arbiter of that, And anyone who wants to cover any hearing in the future has to file with the court a request at least 14 days ahead of the hearing date so that all the other lawyers can review that request and file their own response, whether they're in favor of or against it, and the judge can make a ruling. I anticipate with this case that if everyone who wants to follow it, follows the request, that could be somewhere between 50 and 200 different requests. Just looking at other big cases and how many media outlets have been granted access when a pool media is really big like that. Okay, if everybody follows that, it would be so much easier to collectively just say there's been a request for media coverage, instead of trying to say, oh, I don't know, those talking heads are talking about out of court statements, and this guy, oh, well, he's sort of doing it so he can sell his own merchandise, and this guy's doing that, and we're going to take, just give us a pool feed and let them do what they want to do. Because A, they're going to do it anyway, because under First Amendment, I really doubt this court has authority to stop it once it's gone out, once this is released. And B, you've just dumped, he said, up to 4 pages, like a 4-page request per media outlet. So there's another 1,000 pages of stuff that all the attorneys have to look at, read, and respond to before every single hearing, because we're going to rinse, wash, and repeat and send it in again for the next one. This is probably one of the worst media configurations or decorum orders I've ever seen that still grants access. He's going to find out later today, as I'm reaching out to my PIO, the person who helps us, which is funny because the PIO is normally the person that handles this. Sometimes you have to file it with the court, and sometimes you have to file it with the PIO. Typically, I can do a lot of Utah courts just with the PIO. I reach out to Tanya, and I'm like, hey, this case coming up, this is who I am. Can we get coverage? Can we include in pool media? And she's like, yeah, here's it's easy. Sometimes I have to actually file with the court. I do have some files on different cases with the court, but the big players aren't nearly as affected as the rest of us. The big players have gotten together, right? We're talking the big networks, the big TV networks, Law and Crime, which owns Court TV, all the local news media. So you've got Channel 2, Channel 4, Channel 5, Channel 7, 11, and 13. I think those are all the Utah TV channels. The locals, they're all there. You probably have some Salt Lake Tribune, Deseret News, Davis County Clipper, if they still publish that. I don't think they do. A number of other papers around here, plus all of the you've got Fox and ABC and everything else. They're all on there. They've all got together in one big conglomeration. They've hired a couple lawyers to represent them. So they can collectively say, us, we. But it's a very inclusive circle, and it doesn't include anyone else who is also in the media. So we have to file separately. Typically what happens is they get access. There's a pool feed. They say, we don't have room for all of you. We're going to give you a link to a feed. It's going to come across the internet, and you'll have a live feed, and you can use that. You have to record it yourself, and you can run with it. I don't want the court flooded with paperwork to make this just a pain in the butt. But I don't know why the judge suddenly inserted himself in deciding what people do or what they say about what happens in court. Who cares if there's somebody in Florida who wants to show the case of Tyler Robinson's accused shooter and use it to sell tinfoil hats in the shape of an alien? Who cares? It's First Amendment. Let him do what he wants to do. Who cares if there's somebody who wants to argue this, that there's a big conspiracy theory in the cover-up? Who cares? Who cares if there's somebody who wants to translate this into Klingon live for their audience in other solar systems? Great, let them do it. Why the judge has to be like, I'm not sure. Klingon? I can see German, but Klingon's a bit of a stretch. Klingon TV. I speak Klingon. Yeah, a couple of you would tune right in. I know it. I would, just for the interestingness of it. It's going to happen anyway. That's number one. Because there is no way, there's zero way this court's going to be like, I'm going to look for every single person who carried this and commented on it and posted some social media on this or appeared in an interview talking about it to see if they had permission from the court to do it and if what they said was true. Excuse me? You don't have time. You don't have time to do that. You don't have money to do that. You don't have the resource to do that. And you don't have the right to do that. So before I talk myself into a hole that I can't dig myself out of, Klingon translator would be a great court. Hey, you heard it here first, guys. Maybe we'll have to hire somebody. Jade, welcome to the gallery. Thank you very much. May 19th, 9 a.m. I'm going to put my request in through my contact and see what she says. Nicole Rice just had another trial date set for another new case after her acquittal we covered. Cool. He's a new judge. He has no idea what he's done. He's relatively new. I mean, as judges go, you've got let's see. He's appointed in 2025. Before then, what did he do? He was a deputy attorney up north in Davis County, just north of Salt Lake. That's where I lived. He's done some SVU stuff for the Utah County. He's been a deputy district attorney, assistant attorney general, deputy district attorney in Nevada. He's been a special assistant to the United States attorney in Washington, D.C. So he's got legal experience. But when it comes to being the judge, I think this might be the first case that has anywhere near the type of interest that this one does for him. And he's going to learn really quick. Final Legion says, thank you for answering, Ari. I did not know the big players had grouped up for this. I presume there's no way to make one request cover every hearing with this ruling. No. Unfortunately, no. Here's how it works. When it goes to trial, the request to cover the trial is usually granted as a yes or no, and it covers the entire trial. Even if it's a 12-week trial, you'd have to put one request, not one for every day. But the hearings beforehand, you have to request each time. And sometimes there might be a hearing that's like, hey, we have this hearing to discuss whether or not we're going to cater. They don't do this, but I'm just trying to make it sort of silly. Whether we're going to cater lunch for the jury during deliberation. Okay, there are some issues pre-trial that are almost that boring. They're not that one, but they're almost that boring. And Law and Crime and KUTV2 and KSL is like, really? We're not going to send our guy all the way downtown to fight traffic and set up the equipment in the courthouse so we can find out if the jury gets to eat sandwiches or subs on their break. That's not worth it, and they might not cover it. And media might say, we don't want to be there for that one. But one guy might say, I do. I'm the sandwich guy. We all always cover news about sandwiches, and they might be the pool feed for that one. And then on another hearing, Law and Crime says, I'm in. We've got equipment. We've got people there. We want to cover the hearing that whether or not he's going to wear, civilian clothes at the hearings or whether he has to wear jail clothes. Let's do that. And so the pool camera changes sometimes. Sometimes it's been KUTV when I've gone to Corey Richards. Sometimes it was Law and Crime. Sometimes it was Court TV. That changes. And so for that reason, that makes sense to apply each time there's a hearing. For this July hearing, the preliminary, you're going to request for the preliminary hearing, and even though it goes July 6th, 7th, 8th, 9th, and 10th, if it lasts that long, it would just be one request for that. Anyway, great question, by the way. Did I answer it or not? So it's Freak Out Friday when we have no foliage. I could watch a food news channel. Yes. He's charged with capital. Yes, death penalty. It's a death penalty case. One of my brothers created a Klingon translation in notebook form, made him very popular with his friends in high school. He also made one for Vulcan. Yeah. No, I'd love to talk to anybody else who wants to cover this, just to see what they're doing, what we're doing on the outside. You know, like the fringe media, the new media, the social media. That's not the big television stations or the multi-million-dollar companies. Because I think, honestly, I think the way this is going to happen is once one media outlet comes in and gets approval, then there will be a blanket answer to everybody else as yes, go ahead. But making the judge have to answer every single one of those, this is a day's worth of paperwork for every hearing, and he needs to know that that's not the right way. So there's a better way. I'm not telling the judge he's doing his job wrong. I'm just saying there's a better way to do this, and the system already in place takes care of this. Plus, he doesn't have to worry about some of the things he's worried about. Yes, it was brought to his attention because the defense specifically, clipped Josh Ritter. And here's what Josh Ritter said about this, and he had a talking head said this, and here's what the news said about this, and great, that's wonderful. It's going to make picking a jury a little bit harder. Schedule an extra day, put out an extra 100 prospectus, surveys, grab a few more people down there. It sucks, but hey, when a murder is committed live on national TV, a few people are going to hear about it. And you just can expect that it's going to be a little harder to see the jury this time. You'll be able to find somebody who has no clue who Tyler Robinson is and probably who doesn't even know who Charlie Kirk is. Okay, it's going to be possible. You can do it. And it won't be an issue. But all right, this is my rant. I'm done with my rant. It's 6 o'clock. Where did time go? Holy smokes. The time is far spent. Is it going to be streaming? Yes. Yes, it's going to be streaming. There may be some hearings where the judge closes the hearing for various reasons. It's much more likely that happens before the jury is seated than after. So it is possible that we might even be fighting for access and information about what happens in this until the court opens. Once the jury is seated, the jury is not allowed to watch any media. So once they're seated, the judge instruction saying don't watch media should fix the problem about having the jury hear about something on the media they're not supposed to. So thank you all. Can't wait to tell you. I might post a picture of the car when it arrives. Show us the new car for members only. Ooh, that's interesting. We did not follow that one. You guys might have to jump over there. We're not following that one. Trial TV Live. Trial TV Live. If somebody could put a link up for Trial TV Live, that would be great. They are following that one. I think they have a live stream going. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe until we go live again on Monday morning. I think. No podcast tonight. Thomas is he's not able to get home in time. I apologize. We teased it a little bit. It's going to be a week off. It's terrible because I wanted to talk all about the hacking of the Canvas program and maybe some fast food issues that I've got to complain about. I'm sorry. How come I had the best biscuits you can ever get and the worst gravy you can ever get at the same restaurant? You guys, we'll talk about it another day. Have a great weekend. We'll see you. Bye-bye. Here's the link to Trial TV Live if you want to go watch the verdict. Thank you very much. Guys, see ya. See if I can link to him as well. I'll portal. Hang on, I'm not going yet. We're not done. Edit.
I don't like podiums, Your Honor.
We're going to portal to Trial TV Live. Just 1 second.
Remember in the beginning when we started 110 years ago?
All right. Portal incoming. See you guys later.